I will sub notice, Lord.
So appearing for the plaintiff. None appears on behalf of the defendant. Plaintiff has filed the present application, praying for amendment in the cost title as the name of the plaintiff company is changed. Counsel for the plaintiff submitted the application along with the documents have been served upon the advocate on record of the defendant on 26th of September 2024, but none appears on behalf of the defendants. Defendant or defendants?
Defendants.
Defendants. Full stop. For the interest of justice, the case is adjourned. The plaintiff is directed to inform the next date of hearing to the advocate on record of the defendants. Let the matter appear on 8th of August, November 2024.
Much obliged.
Under the same heading.
Defendant's application for
Yes.
extension of time to file written statement.
Hmm.
My lord, beyond 30 days, it's 24 days, my lord, on which the date is it has been.
Within 120th.
Within 120, my lord, it's 54 days. 54
Who is for the other side?
Good.
Served.
We have,
Copy served.
we have served.
Where is the affidavit of service?
I think the master summons, your lordship will.
No, there's no endorsement. Only sent. There is no track record.
Nee.
Okay, I am fixing on 8.
Well.
So the copy. So defendant number?
Defendant number, my lord, 1.
So appearing for the defendant number 1. None appears on behalf of the plaintiff and the other defendants. The defendant number 1 has filed the present application, praying for extension of time to file written statement. Full stop. It is found that the copy of the notice and the copy of the application is sent to the defendants, sent to the plaintiff, but no track report is filed. Accordingly, for the interest of justice, the case is sent down. Let the matter appear on 8th of November 2024 under the same heading. The plaintiff is directed to, and the defendant number 1 is directed to inform the next date of hearing to the learned advocate appearing for advocate on record of the plaintiff.
My lord, I am for the petitioner, my lord.
Yes.
My lord, in this matter, my lord, defendant has filed. My lord, one application GA4, my lord, is an application, my lord, for referring the dispute to arbitration. My lord, that in that application, my lord, your lordship was pleased to pass an order on 4th October 2024, directing the plaintiff to file its affidavit, my lord. GA5, my lord, is an application, my lord. My lord, I have requested, my lord, this is in connection to GA4. That day, this application was not appearing in the board.
Production
My
of
lord,
original agreement.
yes, production of, because my lord, I have sent them mail. Original is lying with them. I have a digital copy. I have annexed the digital copy with my GA4. There was a legal requirement, my lord. So, my lord, I requested them by an email, my lord. That is an integral part of GA5, my lord. But they have not, my lord. I have filed this application.
That email my learned friend is talking about has not been served on us. There is no annexure to the application which has been served on me.
Yeah.
But I have issued an email on 18th September asking them to serve me with the complete application with the annexure. But there is no response. But only the application has been filed without the annexure, has been served without the annexure.
My lord, I'm giving him my copy, my lord. My lord, I'm giving him my copy.
Then we shall come back on.
If you are having the original agreement,
But I'll have to take instruction on
Yes,
that. My instruction as of today is there is no agreement.
no agreement.
No, there is no agreement. There is no. So, my lord,
But I will satisfy your lordship.
Let them take instruction.
Let them say on affidavit that there is no agreement. My lord, that application, my lord, is appearing, my lord, on 29th November. My lord, GA4.
Yes, my lord,
GA4.
same day.
Let this appear together.
The plaintiff, since appearing for the defendant, the defendant has filed the present application being GA Com 5 of 2024.
क्या mistake है बोलो अभी.
Praying for a direction upon the plaintiff
अच्छा ठीक है.
to produce the original distributorship agreement executed between Print Group, Print and Supply Platform VB and S Supply Platform VB and SAS India containing the arbitration clause. Full stop. Counsel for the plaintiff submits that though the defendant has served the copy of the application, but the application does not contain the annexer. Full stop. Counsel for the plaintiff, counsel for the defendant has served a fresh copy of the application containing the annexes to the learned counsel for the plaintiff in open court. Counsel for the plaintiff prays for time for taking instruction. It is informed to this court that GA.com 4 of 2024, wherein the defendant has prayed for referring the matter to the arbitration will be listed on 29th of November 2024. In view of the above, let GA.com 5 of 2024 be listed on 29th of November 2024 along with GA.com 4 of 2024 in CS number 652 of 2020.
Lord, I have served him the
But,
copy.
yes, my lord, I've received. My lord, two things. My lord, only one. But my time to file affidavit in opposition to GA4 is expiring 2 weeks after the reopening. My lord, if your lordship kindly gives me time to file an affidavit to this, if there is an agreement, we shall disclose by way of the affidavit.
In the meantime, the plaintiff is at liberty to file the affidavit in opposition within 2 weeks.
2 weeks, my lord.
Within 2 weeks, a reply, if any, there to be filed within a week thereafter.
But
on 29th.
So one inconvenience on 29th of November, my learned friend is not
Okay,
there.
let's
Some
make
personal
affidavit complete.
Yes,
Very
yes,
With an affidavit.
Very
yes.
grateful.
Grateful.
I am appearing for the plaintiff petitioner, my lord.
Yes.
But I have served upon them, my lord. This is an injunction application, my lord. The lease granted to the defendant has been terminated on the ground of forfeiture. They have committed certain violations and breach of the covenants of the lease, and there was a clause that in the event of such breach, I will give them a chance to rectify the breach, and failing which I shall have a right to terminate. In terms of that, by a notice, I have terminated the lease, and I have filed a suit, my lord. This is the suit for recovery of possession. Now, my lord, in the meantime, I find that they are trying to make some construction in the property. My lord, I am only seeking the status quo as regards the nature and character of the property not to be changed by them. This is, my lord, the only limited injunction which I am seeking, my lord. Lordship will kindly see.
What is the lease agreement at this?
Yes,
Tenancy?
yes, it's a registered lease, my lord. Lordship will kindly see. It starts at page 28.
1982.
Yes, 1982.
Yes.
Then your lordship will kindly come to the clause at page 37. 36, the typed copy is at 37. In consider rent terms covenants, the lessors hereby demise unto the lessee all that piece parcel of land 2 kata 8 chataks 13 square feet with structure, outhouses, servants' quarters at portion of premises number 9C Lordchina Road, together with the right or use to the lessee and or its subtenant at the open space delineated on the plan. Kindly see towards the
On the map of plan and
middle of page 38 at the bottom. It is for a period of 99 years commencing from 1st of May 1982 with 2 options for renewal during the period hereby on monthly rent of 4250. Then your lordship will get this clause at page 42A. The lessee shall pay unto and to the lessors during the term of this demise the monthly rent at the rate and on the dates and in the manner herein before reserved, and in default of payment of such rent and on the day. My lord, page 40, Roman 2A.
Shall pay unto the lesser during the terms of demise month.
The monthly rent at the rate and on the dates and in the manner herein before reserved, and in default of payment of such rent and on the day and in the manner herein before reserved, the lessee shall pay interest thereon at the rate of 12% per annum from the due date until date of payment, and in case of consecutive default of payment of rent for a period of exceeding 6 months, the lessor shall be at liberty to take such proceedings, including proceedings for determination of the term hereby granted or for recovery of the rent. So, in terms of this default, I have issued a notice determining the lease.
Yes.
That notice is at page 256, which is at volume 2. That is 9th of August 2023.
Yes.
Initial part I have recited. Then your lordship will kindly come to page 257, last paragraph. There was a default from a long time. In a previous proceeding, they paid certain amounts to the joint receiver. After that appeal was also disposed of, thereafter they stopped paying altogether again. Kindly see, I have said here at 257 last paragraph. It was only after order dated 25th April 2021 passed in FA number such and such that you paid to the joint receiver the sum of rupees 14,53,500, that too in 2 equal installments on account of area defaulted rent for the period between December 92 till 2021 May. So 92 there was no payment. In terms of the said order, you thereafter paid occupational charges of 20,000 on and from June 21 to March 22. Even after disposal of the appeal, being FF 35, you have failed and are neglected to pay any rent whatsoever towards lease rent and interest thereof to my clients, and thus defaulted in payment of rent consecutively for period of more than 6 months from April 2022.
Yes.
So from April 22 is the starting point of their default, 6 months consecutive default, then I have terminated this. The area rent together with contractual interest as per the provision of lease deed amounts to and payable by you is 1 crore such and such. You by your conduct have acted contrary. My client, you have exceeded the right to make construction which is restricted to the demised portion. Here, my lord, though they have a right to make construction on the demised portion, they have made construction on the common areas also without any sanction. You have actually encroached upon the common area to be enjoyed as common passage by my client. Then my client has recently obtained information you have failed, neglected to obtain renewal of fire license and approvals in respect to the building constructed at the leased portion. Your occupation is inconsistent with lawful use and occupation amounts to nuisance. This is also a covenant of the lease. So, my lord, this is my notice of termination. Thereafter, they have issued a reply at page 266.
Yes.
My lord, whatever is, my lord, their case is in paragraph 8 of that reply. There is no breach. Now that will be an issue, my lord. They will file the written statement, and that is going to be now contested. Regarding the rent also, in paragraph 10 at page 268, they say that I have paid in excess. 10 and 11, your lordship will see at page 268. Yes.
determining the lease or eviction, the amount deposited in the order for towards the occupational charge are liable to be adjusted. What are the, where is the order of the appellate court?
Yes. Kindly come to page 221. যেখানে টাকাটা দিতে বললো না আগে এইটাই দেখি দিই Well, kindly come to page 221.
Yes.
But I'll tell you, Lordship, this was an earlier suit which my client had filed before the city civil court for eviction.
Hmm.
Now that suit was dismissed on a finding that I could not establish my title to the property. So, my lord, this was a regular first appeal by my client challenging that dismissal only on the limited aspect of the title. So in that or the appeal, my lord, the Honorable Division Bench, while admitting the appeal, passed this interim order. Lordship will see page 221, second part regarding can number 2.
Yes.
I am not placing, kindly see the page 222, third paragraph. We appreciate the submission of Mr. Bose that respondents cannot be allowed to enjoy occupation of subject premises without payment of any occupation charges. He is fair enough to say that his client is not claiming outstanding rent at this point of time, but the same may be deposited with the receiver. Considering the submission made, we appoint such and such as joint receiver. They shall open an account with State Bank of India. Account is to be operated jointly. From then, last paragraph, from December 92 till May 21, the respondent shall pay area rent at the rate of 4250 per month in favor of the first named joint receiver with check or pay order, which shall be deposited by the joint receiver in the said account immediately upon intimation to the parties. First, entire area is to be paid in 2 installments, such and such. So, my lord, there is an admission of default from 1992 December,
Correct.
which is being cleared only on the basis of liberty granted by this order.
Correct.
So the default does not evaporate.
Correct.
6 months default is there. And once there is a default, there is an obligation to pay interest as per this clause. So what?
No, so after the order,
Yes.
whether they have deposited the
Yes,
amount.
this amount they have
They
deposited.
have taken the plea in the reply because they have deposited in the court.
Yes, yes. I am not on that. I am saying that since there was a default, you had an obligation to pay interest in terms of the clauses of the lease deed at the rate of 12%. That you have not done. Secondly, I have said that you have deposited in terms of the order
Correct.
up to the date of the appeal.
Correct. That's why
Again,
after the appeal, after the disposal of the bill, what is the whether they are paying and
no,
whether they have
no, no, that
deposited.
is my case in the notice, my lord. I have said from April 2022. Again, there has been.
Because over 223, the current occupation charges is provisionally 20,000 per month.
Yes,
From June 2021,
yes,
payable by 7th of July 2021 for June and month by month of 7th of each month.
yes.
To be paid similar manner and deposited receiver in the said account. So
That
what-
they have paid. If your lordship comes back to my notice, I have stated that at 257. Last paragraph.
Yes. Yes.
Kindly see, it was only after the order dated 25th April passed in FA 35, you paid to the joint receiver an aggregate sum of 14,53,500.
So as per your case, that till March 2022, they have
They have
paid.
paid. They have,
Thereafter, they are not.
they have not paid. From
When the appeal was disposed of,
my lord, appeal was disposed of next
where is the disposal order?
13th, that is at page 225. At 227 it starts. 13th of April judgment was delivered, 2022. And they paid up to March. After disposal of the appeal, again stopped.
What the appeal held?
Appeal held, my lord, the title was decided in my favor. And therefore I got the liberty again to file the fresh suit. I'll show your lordship, my lord. Kindly come to 247, internal page 21. On the aforesaid basis,
Good.
it can safely be concluded by reason of vesting of the property in the company by operation of law, company has become the owner of the suit property and the landlord of the defendant. So this is my right which has been decided.
No, thereafter, in view of the fact that defendant one categorically stated that they are willing to pay the rent to the rightful owner, and
Eh.
as it appears that the municipal rates and the taxes payable by the defendant in respect of
We direct
Direct
defendant
defendant
to pay area rents till March 2022 if not paid by 30th April, and the municipal rates and tax in terms of the within 15th May. So they paid area rent till March 2022.
So as per your submission case, after this order, they have not paid.
Not paid. That is my case.
Yes.
So therefore, I have forfeited the lease on the basis of the aforesaid breach. And I have filed this instant suit.
Where is the construction? How you are
But
proving
I
the
have pleaded that if your lordship comes, my lord, to my petition, paragraph 23,
23, 20.
page 23 and 24, at page 16. Now, my lord, they had a right during the subsistence of the lease to induct subtenant. Now, upon termination, that right has to be suspended also.
Correct.
So now, my lord, I am also saying that in the meantime, they are also changing the hands in the property. So that also, my lord, I have stated, my lord, in paragraph 25. So, my lord, I am seeking, my lord, an injunction in terms of A and B, my lord, from changing the nature and raising any construction and changing the nature and character for. Special officer ki chahiye?
Have you served?
Yes. But I had also moved an application before your lordship, my lord, to leave to adduce certain additional document to show, my lord, the deeds which deeds there they appeared, my lord. Yes. They কবে হয়েছিল অর্ডারটা মনে আছে? Just before the vacation, that application was moved. They appeared. We served them the application.
Whether this application is served?
This is also served. This is the
Where is the affidavit?
affidavit of service, my lord.
Fourth October.
So at that time, we were trying to move, my lord, before the closure of the court. Main is defendant number 1. This is the partnership firm.
So and so appearing for the plaintiff. None appears on behalf of the defendants. Affidavit of service filed by the plaintiff be kept in the record. Plaintiff has filed the present application being GA-COM 3 of 2024, praying for interim order. On 17th June 1982, a lease agreement was entered between the parties with respect to the such property for a period of 99 years with 2 options for renewal of 99 years each, yielding and paying thereof, therefore, with 2 options for renewal of for 99 years, full stop, each, full stop. In counsel for the plaintiff submitted. 1. That the plaintiff has filed the present application being GA-COM 3 of 2024, praying for interim order. 2. That the plaintiff has filed the present application being GA-COM 3 of 2024, praying for interim order. 3. That the plaintiff has filed the present application being GA-COM 3 of 2024, praying for interim order. 4. That the plaintiff has filed the present application being GA-COM 3 of 2024, praying for interim order. 5. That the plaintiff has filed the present application being GA-COM 3 of 2024, praying for interim order. 6. That the plaintiff has filed the present application being GA-COM 3 of 2024, praying for interim order. 7. That the plaintiff has filed the present application being GA-COM 3 of 2024, praying for interim order. 8. That the plaintiff has filed the present application being GA-COM 3 of 2024, praying for interim order. 9. That the plaintiff has filed the present appli On earlier also, the defendant had violated the terms and conditions of the agreement, lease agreement, and accordingly the plaintiff had filed the suit for eviction, but the suit was dismissed by an order dated 5th of July 2019, entitled suit number 1076 of 1998 by the Learned Judge 5th Bench, City Civil Court, Calcutta. Full stop. Being agreed with the said order and said judgment and decree passed by the Learned City Civil Court, the plaintiff had preferred an appeal before this court, and at the time of hearing of the appeal, this court has appointed a receiver and directed the defendant to pay the arrears of rent at the rate of 4250 per month from the month of December 1992 till the month of May 2020. May 2020. December 1992 till the month of May 2020. Full stop. This court 1990, and subsequently this court has fixed the occupational charges of the said premises at rupees 20,000 per month from the month of June 2021, payable by 7th of July 2021 for the month of June 2021, and month by month by 7th of each month, to be paid in similar manner and deposited by the joint receivers in the said account. Full stop. Finally, the appeal was disposed of by an order dated 13th of April 2022, wherein the Honorable Division Bench of this court has held that the plaintiff company, by operation of law, has become the owner of the suit property and landlord of the defendant. The Honorable Division Bench has further held that the defendant number 1 was willing to pay the rent to the rightful owner, and as well as the municipal taxes with respect of the suit premises, and accordingly the Honorable Court had directed the defendant to pay the arrears rent till the month of March, till March 2022, if not paid by 30th April 2022, and the municipal rates and taxes in terms of the lease agreement within 15th of May 2020. Full stop. Counsel for the plaintiff submitted that the defendant has violated, has lastly paid the renter occupational charges. Paid the occupational charges,
Yes.
not the rent.
No,
Has paid the occupational charges till the month of March 2021, and thereafter he has neither paid
22.
March 2022, and thereafter he has neither paid the occupational charges nor has paid any taxes to the concerned authority. But
It should be rent because subject to correction because the
Has not
lease
been
was
rent.
again subsisting.
rent till the month of March 2022, and thereafter from the month of April 2022, he has neither paid the monthly rent nor paid the municipal taxes or other taxes which the defendant number 1 is liable to pay. Full stop. As the defendant number 1 has violated the terms and conditions of the agreement, accordingly, the plaintiff had issued a notice on 9th of August 2024,
2023.
2023, by determining the lease agreement and calling upon the defendant to vacate the premises and to hand over the premises within 15 days from the date of receipt of the notice. The notice was duly served upon the defendant, and on receipt of the notice, the defendant had sent a reply on 25th of August 2023, alleging that stating that he has not violated any terms and conditions of the lease agreement dated 17th of June 1982, and the rent deposited by the defendant is required to be adjusted, is liable to be adjusted with the monthly rent. Full stop. Consider the full stop. Counsel for the plaintiff submit that the defendant is neither paying the monthly rent or the required taxes. On the other hand, the defendant is trying to make construction in addition to the lease premises, as well as is also trying to create an subtenancy in the premises by letting out the premises to the third party. Counsel for the plaintiff prays for an interim order. At the learned counsel for the plaintiff peruse the materials on record. This court finds that in the appeal filed by the plaintiff, the Honorable Court has declared that the plaintiff is the landlord of the premises in question. It is also admitted that the order passed by the appellate court has not been challenged by the defendant and accepted that the plaintiff is the owner of the landlord of the premises in question. It is a specific case of the plaintiff that in terms of the order passed by the Honorable Division Bench in an appeal, the plaintiff has paid the amount, subsequently continued paid the monthly rent till the month of March 2022, but thereafter he failed to pay the monthly rent and also not paid the municipal taxes. It is a specific averment made in the print that the defendant is making construction over the suit premises over and above the premises and given on rent to the defendant, and the defendant is also trying to let out the premises to the third party by creating the sublease over the premises in question. Subtenancy. Consider the submission. Considering the above, this court finds that the plaintiff has made out a prima facie case and balance of convenience and inconvenience in favor of the plaintiff. This court also finds that if at this stage the defendant is not restrained from making any construction over the premises or over and above the premises, and for letting out the premises to any third party, the plaintiff will suffer irreparable loss and injury, and which will also create the multiplicity of the proceeding in future. Accordingly, the defendants, their men, agents, servants are restrained from raising any construction at the suit property or changing the nature and character of the suit property, and also restrain the defendants from creating any third party interest in the suit property till 29th of November 2020. The plaintiff is directed to serve the copy of the application, plaint and the document, and to file affidavit of service on the next 8 weeks.
Obligation.
How the commercial premises?
Yes, commercial matter. The suit is
Okay.
to be used for commercial purpose.
29 November.
Obligation.
Yes.
My application, my lord, an application for review. Your lordship was pleased to dismiss an application, my lord, for extension of time to file the written statement. From that order, my lord, the review petition has been filed.
Okay.
My lord, unless and
Certainly
until
he is not opposing.
Lord, unless and until your lordship is inclined to dismiss the application at the threshold, my lord, then otherwise, my lord, I'll have to file an affidavit, my lord. Because, my lord, this is
If you
nothing.
want to file affidavit, then
My lord,
the
then I
court-
have to, because, my lord, this is
the
nothing.
court cannot disclose the mind prior to that. If I will allow, the court will not.
Then, my lord, I have to
Once
file
the
an affidavit
application
because,
has come, it has to be decided its own merit.
then, my lord, then I have to file an affidavit, my lord. Because, my lord, though numbered and named as a review application, my lord, but this is an appeal in disguise, my lord.
No, not really.
My lord, that I shall demonstrate. I shall demonstrate.
Very
So and so appearing for the plaintiff, so and for all defendants.
Oh, no. 1 to 4.
Appearing for the defendant 1 to 4. Defendant number 1
Petitioners.
to 4 have filed the present application being GA Form 1 of
I was.
2024 in review number 41 of 2024. 2024. The counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks.
2 weeks, man.
Reply if any.
Hmm.
Reply
1 week.
1 week thereafter. List the matter on 29th November.
29th. Deeply obliged.
Lordship.
Great purpose.
My lord, item number 7, I'm appealing for the plaintiff, my lord.
Yes.
This is my suit for infringement of copyright of a song. My lord was pleased to pass an order of administrative injunction on 29th of July.
Yes.
That, my lord, has extended once and that is expiring tomorrow, my lord.
Mm.
That is my item number 7, GA1. And item number 8 is my application for amendment. I'm seeking a very formal amendment today, my lord. In the cause title, there was a mistake, my lord. If because of which the writ of summons cannot be
Who
issued.
is appearing for the defendant?
I'm appearing on behalf of the defendant number 1, my lord.
Hmm.
Now I'm yet to file my wakalatnama. My client is on his legs.
Hmm.
If my lord gives me an accommodation of 5 days, I'll come back ready with the matter. In the meantime, I'll file the wakalatnama also because we intend to file a written objection in this case.
What about the amendment?
Amendment we have not served,
have
my lord,
not
because
got any
today they
copy.
are first.
What amendment you have sought for?
Let them
My
serve.
lord, if my lord kindly takes,
Okay, let you serve the copy.
I will serve them, my lord.
And my lord allows us.
I'm appealing for the respondent number 3 matter. I'll file my wakalatnama.
File in the department. You are appearing for the 3. You are appearing for 1.
One.
What about the 2?
To file my objection.
What about the 2 and 4?
4 is the pro forma defendant, my lord.
What about the 2?
We have served them. I don't know, they are not.
Phonographic digital.
We have served them, my lord.
So and so appearing for the plaintiff. So and so appearing for the defendant number 1. Defendant number 1.
Defendant number 1, ma'am.
Defendant number 1 and so and so appearing for the defendant number 3. Police. Counsel for the defendant number 1 prays for leave to file wakalatnama within a week from date on behalf of the defendant number 1. Leave is granted. The defendant number 1 is directed to file wakalatnama in the department within a week from date. Full stop. The counsel for the defendant number 3 is directed to file wakalatnama in the department subject to scrutiny by the department. Full stop. Counsel for the plaintiff submitted the interim order passed by this court earlier is going to
Expire tomorrow.
And prayed for extension of interim order. Considering the submission made by the counsel for the parties, the interim order granted earlier is extended. Acha, just prayed for extension of it. Yes, you want to file wakala affidavit?
I'll file the affidavit.
How soon you will file? 4 weeks, 3 weeks?
4 weeks.
4 weeks. Counsel for the defendant number 2, 1 and 3 prays for extension, prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 4 weeks, reply if any there to be filed within 2 weeks
my lord.
thereafter. Full stop. List the matter. List the matter on 20th December 2024.
Very well.
The interim order granted earlier is extended till 20 December 2024 or until further order, whichever is earlier. Okay. Yeah. 8 May. The 7 May. 8. G8. Item number 8. Sensation suffering for the plaintiff, sensation suffering for the defendant number 1 and defendant number 3. The plaintiff has filed an application praying for amendment in the cost title.
Cost title, my lord, there's a small mistake that outside jurisdiction, that word was missing. And
Which
if my lord kindly takes.
address? Plaintiff's address.
No, my lord. Every, my lord, in cost title, in the plaintiff have defended, my lord, the amendment within the jurisdiction and outside jurisdiction, that is missing, my lord.
An application for amendment in the cost title of the plaintiff.
Yes, and that about in paragraph 81, my lord, that clause 12 leave, though in the prayer portion that prayer is there, that amendment was not there.
Which prayer? Which portion you
Uh,
want
paragraph 81.
as well as paragraph 81 of the plaintiff. Full stop. Counsel for the plaintiff submit that he has not served the copy of the said application to the defendant. The plaintiff is directed to serve the copy of the application to the defendant within a week from date. Full stop. Full stop. The defendants are at liberty to file affidavit in opposition within 3 weeks, reply if any there to be filed within a week thereafter. Please the matter on 20th December 2020.
Very well. My lord, since the defendant number 2 is not appearing, should I serve the application? I will serve, my lord. Grateful, lord.
Serve and file affidavit on that.
Very good.
Wait, please, Your Lordship.
Yes.
But in G3, my lord, the prayer is it's an innocuous prayer, my lord, because it's proceeding in a manner, my lord, the plaintiff where the defendant is not appearing. There's a direction from your lordship for substituted service. We have done that. That's in GA1, my lord. Today, before your lordship is listed, my lord, GA3, where, my lord, our prayer, because, my lord, the order of injunction was granted on 22nd. My lord, the first order was granted, my lord, on 10th of June, 2024. In the petition, your lordship will find this at page 10. In terms of order 39, my lord, rule 3A, my lord, the 24-hour service, my lord, this was delayed by 11 days. That is, my lord, the reason for this application. If your lordship kindly takes up, my lord, the prayers at page 8. May I start from there, my lord? The prayers at page 8. Delay of 11 days in complying with, my lord, order 39, rule 3B. Be condoned. So that's the prayer, my lord. Also, I should indicate on 22nd of July, there's a subsequent order by your lordship, where, my lord, the injunction was again reimposed. My lord, thereafter, within 24 hours, my lord, we have served. So, my lord, the service is there. So, effectively, my lord, this application becomes infructuous. So, it can be disposed of with such directions because, my lord,
Nobody's appearing.
nobody is appearing. In fact, my lord, we have made a substituted service pursuant to your lordship's order. And, my lord, we have the affidavit of service.
Of this notice.
My lord, that this is of substituted service in GA1, my lord. GA1. So, it's not there before your lordship today, but if your lordship permits, my lord, we can file it today.
When is the GA1 is fixed?
Just check. Kindly give me a moment. 22nd November.
Let it come on.
We can file on that day, lordship.
No, this also come on the 22nd November.
My lord, it can be disposed of then. Yes, my lord.
Because along with all
My
this,
lord.
if they will not appear, then the whole suit will be taken.
Lordship.
Sense appearing for the plaintiff. None appears on behalf of the defendant in spite of service of notice. Police counsel for the plaintiff submitted. The plaintiff has also filed an application being GA-COM 1 of 2024, which is fixed on
22nd November.
22nd November 2024. Let this application be listed on 22nd of November 2024 along with GA-1 of 2020.
Very deeply obliged.
But item number 10, my lord, is my application.
7 to 11.
Yes.
There are two applications, my lord. One order to 11 and my lord, my application under order 12, rule 6, my lord, where admission is there, my lord. In an affidavit, my lord, they made.
You are for the plaintiff.
For the plaintiff, my lord.
May I let's state the facts in nutshell, thereafter, my lord, I take your lordship through the papers. Lord, the plaintiff's case, my lord, is that the plaintiff had lent and advanced.
Your application is GA?
4, my lord.
Yeah. Yeah.
Plaintiff's case, my lord, is that the plaintiff had lent and advanced, my lord,
sum of money, 2.5 crore. And defendants, my lord, 1, 2, and 3. Basically, my lord, 1 and 3 is the guarantor, and 1 and 2 are the husband and wife. That's their relationship between the parties. The plaintiff had lent in advance that sum of money with the understanding that the money would be repaid within 2 years, and thereafter interest, and in between interest. But there was initial there was an agreement which was unregistered, then the supplementary agreement which was again unregistered, and thereafter a registered mortgage agreement, where various share documents and properties were mortgaged in respect of this financial accommodation. Their case is that the money was not returned, so they waited for a while, asked for money, they did not get the money, so they filed the suit. Now, my lord, interestingly, the suit, my lord, if your lordship kindly, I'll show you the plaint from the beginning, my lord. I am attacking this plaint on three grounds. First, my lord, is that there is no cause of action between this plaintiff, and the defendants. The second is that, my lord, the suit is expressly barred by limitation. And third point is that, my lord, it's the Commercial Court Act is not applicable, and even if it is applicable, plaintiff's pleadings but not say so. There are three grounds that I'm taking in the Order 711. Now, in order to establish my first ground, that is the ground of no cause of action, that I had first, my lord, show your lordship the cause title of the plaint. Kindly comes to, my lord, page 12. Page 12 is where the plaint
Page
starts.
12.
Page 12. Well, that's the cause title of the plaint, my lord.
Yes.
Lordship would see the name of the plaintiff, Madhva Real Pro Private Limited.
Yes.
And there are three defendants, Sushila Jain, Sunil Jain, and Comsor Data System Information Technology Private Limited.
Yes.
I'll straight away take your lordship to page 62, which is the only registered mortgage deed.
62.
That is the only document on the basis whereof the plaintiff is suing. Page 62. The registered deed of mortgage. The other agreements are unregistered. They are also not relying upon this. Now, this Sushila Jain name lordship would find in the mortgager, part 1, first page.
Susila Jain.
Next page, she kindly comes to page 63.
Yes.
Sunil Jain at the first line.
Yes.
Thereafter, my lord, 6 lines after that, the Comso Data System Information Private Limited lordship would find. The three defendants are there. Now, my lord, kindly comes to the 6th line from the bottom, my lord, of that very paragraph. After the what? Part 3.
Correct.
The name, kindly read the name, Lord. Madhva Real Estate Company Private Limited.
Madhua. Yes.
Madhva, so the agreement was between the defendants and one Madhva Real Estate Company Private Limited, and the suit has been filed by one Madhva Real Pro Private Limited. Now, my lord, it is the I'll also show the checks which, Lord, according to my learned friend, had been issued.
Yes.
Kindly comes, there are 2 volumes, kindly comes to second volume.
Yes.
But page 158.
158.
That's my letter.
It is your letter.
Yes, I am writing to Millard, the company with whom Millard.
Madhua Real Estate.
Yes, with whom I had entered into an agreement.
Yes.
I've given these checks in its favor. All these checks.
Yes.
These are all admitted positions, Millard. Now, Millard, what the plaintiff has done, the plaintiff has deposited these checks. The plaintiff. And the bank sends plaintiff a notice that name of the payee does not match with you. Naturally, it won't match because the checks were given in name of some other company, and another company is now encashing those checks. So it won't match. That is why the dishonour of checks. And the basis of those, Millard.
Where is the reason?
But this thing has been said in the plaint itself. I'll show you lordship the pleadings of the plaint.
They are not enclosed the
I do not have a copy.
written memo.
No. I could not find that. Maybe they. Yes, Lord. Kindly come to me, Lord. Page. Yes, Lord. I'll show you. Page, Lord.
Yes, 120.
120. All written memos are there and reasons given, Milord. Pay name differs. All checks. Pay name differs.
1192.
122, Milord. Sorry, 1192, Milord.
123.
131. 132, sorry. 132. Same reason, Milord.
Yes.
All these checks were Milord, issued in the name of this other company with whom the
Pay name
plaintiff.
differs.
Yes. So name differs, Milord. That's the only reason of default.
Yes.
Now, Milord, this is also their plaintiff's case. They have said that this is the reason why the checks were dishonored. Now, Milord, what they have, one more line that they have added in the plaint is that although the agreement was between these two entities, but it was all along understood by the parties that the plaintiff is the one who were to get the money. Now, Milord, there is no other contemporaneous document from which this pleading can be substantiated. It's only a oral statement written in the plaint. There is no proof on no assistance of any other documents where from Lordship can check the veracity of this document. So, Milord, my first issue is that, Milord, there is no contractual relationship between the plaintiff and the defendants. And in the absence of a contractual relationship, Milord, there cannot be any cause of action by whereof, Milord, the plaintiff could sue the defendant. That's my first point.
Yes.
In fact, Milord, to make my case better, Milord, I would also, Milord, show your Lordship the other two agreements which my learned friend had annexed in the plaint. First one is at, Milord, page 39. So there cannot be any confusion regarding the name because all agreements were with the same between the same parties. It's not that mistakenly some other name came into this one registered document. Page 39 is the first deed of mortgage which was unregistered. The same name, Sushila Jain. Next page, Sunil Jain. And Milord, thereafter, page number 41, ComSource data system. These three defendants are there. And on that very paragraph, towards Milord, 8 lines after the
Madhva Real Estate.
yes. Thereafter, Milord, the supplementary agreement was executed, page 58, between the same parties. So it cannot be a case of a confusion or a mistake in one document. Repeatedly, the same parties are entering into agreements with the understanding that the defendant would pay back to the plaintiff, and defendant had given those checks.
Is there any pleading that the name is changed?
No, their case is that it is not a case that that company does not exist anymore. It is not a case that the name has changed into this company. The case is the one case. I'll show you, Lordship, the pleading of the plaintiff in that respect. The case in the plaintiff is that the plaintiff and the defendants were aware that although the agreement in the name of some other company, but the plaintiff is to get money. That was the understanding, unknown understanding, unwritten understanding between the parties.
So whether the loan was given by the plaintiff?
No.
Where is the transaction detail?
Details is the annexed in the that is recorded in the deed itself, mortgage deed. The money came.
Mortgage deed.
Yes,
Thereafter, any confirmation, account
The
confirmation?
deed records the schedule. Schedule says yes, that company.
Yes.
Money 2.4. I show you the schedule.
How the money was paid?
That was also paid by check.
In whose name?
In the name of yes, page 80. Received from within mentioned mortgagee by the mortgager rupees 250 towards loan subject to repayment thereof, financial charges, interest, done such, and these checks are there. So, Milord, the mortgagee is giving these checks to the mortgagor, that company, Real Pro,
Yes.
real estate, and this is how, Milord, the transaction was between the parties.
Yes. Then?
So, Milord, yes, that's Milord there. I'm not showing Lordship, the second agreement is at page 58. Lordship will also find the same names between the parties. Now, my lord, one more document I'll show, that is, my lord, at page, my lord, 114. 114, my lord. So, my lord, this is a letter given to us, where, my lord, they say that money was payable and demanded this recovery of the sum of money. But there, my lord, they have not said about this unwritten understanding of between the parties of a different company getting back the money.
Have you given the reply to this 114?
But no, I have not given it.
Huh?
I have not given a reply.
You not given any reply.
Now that one more thing, that at page 77, the Lordship would find an arbitration clause between the parties. That's the part of the registered mortgage deed. Now, my lord, in the their case in the plaint is that because the issue in the plaint touches the question of mortgage, that is why arbitration cannot be held between the parties, because my lord, arbitration proceedings are cannot cover, my lord, mortgage issues.
Yes.
Yes, my lord. And one paragraph of the plaint, paragraph
So
7,
you are relying upon 16 arbitration clause.
16, the clause is there. I'm not relying upon this because, my lord, the reason is that the plaint's prayer is recovery of money, my lord, and also some rights regarding the properties which were mortgaged. Also, it's in addition to that. So, my lord, it's not a sole question of mortgage, but at this state, I have not filed any application under section 5 and 8 of the arbitration, so I can't rely upon this. I'm just indicating a lordship that there exists an arbitration clause. One paragraph of the plaint I'll show, page 22, paragraph 17. This is the plaint. This is their explanation regarding this. Page 22, paragraph 17 of the plaint. Page 22.
Yes.
May I read, my lord? Although the plaintiff completely relied upon the defendant number 1 in blind faith in accepting such checks mentioned in Annexure F, the said checks appeared to have been made out in the name of Madhwa Real Pro Private Limited in place and stead of the plaintiff, being the signatory of the agreement, including registered deed dated 17 March 2016. Although in the initial schedule of the said agreement, including the said registered document, the name of the fourth party by mistake has been mentioned as Madhwa Real Estate Company Limited, the PAN number and all other details, including signatory details on behalf of the fourth part, is the plaintiff. This fact was always known and admitted by all concerned. As such, all those checks, as mentioned in Annexure F, hereto, when presented, were dishonored with the endorsement of the name, payee name, deferred. So, my lord, this is their explanation regarding this this change of name. And paragraph 18, when the checks were first time dishonored, at paragraph 18, fresh checks were issued in the name of the same company with whom the agreement was entered, and knowingly they accepted those checks. So that even after 3 years, they accepted the checks in the name of another person, another entity, and deposited them, and those were also dishonored, for the same reason. Paragraph 18. So, this cannot be a mistake. This has been, I do not know the reason why this entity, the entity with whom the plaintiff had entered in this Madhwa Real Estate Company Limited had not come before your lordship by filing up. I do not know. But if I have an agreement with that company, then I am only bound to serve the contractual obligations as against that company and not against the plaintiff who is suing. That is my first point. The other 2 points. One is the next point is the point of limitation. That the lordship would find the date of the agreement, the registered one I am relying upon, 17th March 2016.
So this is a cause of action.
Yes, this is the ground of this. I am saying there is no cause of action between the plaintiff and the defendant. So I am not bound to repay any money to him, to the plaintiff, and he cannot sue me. He has no cause of action against the defendant, the plaintiff, the present plaintiff. Now, the second point is the question of limitation. The registered mortgage deed is of March 2016. Now that the clause says within 2 years you have to repay. So that's the maximum. I'm taking it to 15. Now that they are suing in 2022. The letter they write in 2018,
When the check was issued,
right at the time. I have read paragraph 16, 17, I've read.
hmm, 2016,
Yes. So 22 suit is filed. Now, that for redemption of mortgage or for recovery of money, that money becomes due and payable when within 3 years. I will lay upon Article 19 of the Limitation Act. It specifically bar it says
what is the date of the dishonor of the check?
Millard checks lordship would find 2017 check at page 119. 2 checks of that page 118. I have given the particulars of the check, Millard, 2017, 18, 17, 18, all dates there.
21.
That these 21 checks are subsequent after the expiry. 16 agreement 3 years, 19. So cause of action has already expired, and thereafter if I give him checks, that does not extend the period of limitation. The limitation has already expired, and thereafter there is a gap of 3 years, and then they again come to me and say please pay, and then I give him checks in the name of the correct party. They deposit it.
Correct.
So that the cause of action has to be continuous. That there is no pleading regarding that. There is a break in the chain. This is a continuous cause of action. If 16.
No, see, one agreement entered between the parties.
Yes.
That was for 2 years.
Yes.
Correct. 2 years expired. You not paid the amount.
Yes.
They not filed the suit.
Yes.
Within 2 years, we did not file the suit. Subsequently, you have issued the check.
After the expiry of the period.
After the expiry of the
Yes.
period, you have issued the check.
Yes.
And the check was dishonored. So it
Yes.
is not a fresh cause of action.
But so far as the lordship is probably indicating section 14, if that has to happen, that has to happen within the tenure of the first limitation period.
So why you issued the check?
That I issued a check in, if I'm wrong, another entity who is to get money.
That is, see, with
So
regard
so I did not issue any check in favor of the
to this
plaintiff.
plaintiff.
Yes, I do not have any agreement with it.
So that
So in any event, that is what point is there. So far as the second round of checks giving.
So the second check
Yes.
which you have given, that is also not the plaintiff.
Not the plaintiff.
No,
So regarding that, so that is why.
Before the court.
Yes, that entity has never come to court as on this date. So that's second point. And the third point, the barred by limitation point I am taking, because 3 years and then there is a gap, so it cannot be continuous. And then there was fresh checks, so they could sue, but they did not sue on the basis of those checks. They are suing on the basis of the registered mortgage deed. Lordship has seen the plaint. And the third point is that
No,
the
registered mortgage deed, but
Yes.
where is the cause of action they have pleaded?
Yes, kindly, I'll show you Lordship that. Kindly come to page 20.
Page
28 of this.
28.
Yes, there is no particular paragraph regarding the in that manner, but page 28, paragraph 36 is where the paragraph 34 is where they talk about the commercial courts. There is no separate paragraph where they had said that this is my cause of action and that date it appeared. So there is only one line, paragraph 37 of the plaint, which says the plaintiff says no part of cause of action is barred by limitation.
Yes.
But on which date the limitation arose? The cause of action arose, and how it arose. So those pleadings are not there. Lordship knows CPC as well as the original side rules both mandate those pleadings, but those are not there. Does not exist in this plaint.
Yes. Next.
And the other is that the last point that I want to indicate is that the issue of commercial court. The Lordship kindly from paragraph 27 till paragraph these paragraphs. There is not even one line regarding how the suit is a commercial suit. There is no pleading at all. 7 except paragraph 34 where they talked about the urgency. Why the mediation, they can't go to mediation and they have to come to court. Paragraph 34. Apart from that, there is no pleading regarding Commercial Courts Act. And now that is also now Lordship knows that is also barred. They have to say that This is how it is a commercial suit. Under this provision we are coming, and this is 2022 suit, not a 2016, 17, 18, not those. These are at least in 2022. These laws were very clear. Now, my lord, in support of my argument, that I will cite, my lord, two judgments on the point, my lord, of the cause of action point. My lord, Delhi वाला. Pro. Delhi. The 2012 SEC online Delhi 5325. That I am relying upon, my lord, paragraph 125. My lord. 125. 125.
Yes.
The subject of this suit was, my lord, a sum of money. This suit was filed for recovery on the ground that the plaintiff was promised by the defendant number 2 to supply of wheat by the defendant number 1 to the plaintiff. However, the defendant number 1 supplied the wheat to the plaintiff at a higher rate in violation of the associateship agreement entered into between the plaintiff and the defendant number 2. So defendant number 1 is suing the plaintiff on the basis of agreement between defendant number 2 and the plaintiff. The further case set up in the plaint is that since the plaintiff had to supply wheat to government trading corporation, and therefore since it could not afford to commit the breach with the said GTC Iran, plaintiff was forced to purchase wheat from the defendant number 1 at an even higher rate. It is this difference of the rate, that the difference higher than that which is claimed through the subject suit. Paragraph 2. Though the defendant number 1 filed a written statement, thereafter it did not appear and was proceeded ex parte. However, as per the case as set up by the defendant number 1 in the written statement, it was pleaded that it had no privity of contract with the plaintiff for any supply of wheat, much less at a particular rate as claimed by the plaintiff. That is also my case. There is no privity of contract between plaintiff and the defendants. Now, I will kindly come to paragraph 5. I'll also show that the issues which are framed, paragraph 4, whether there is no privity of contract between the plaintiff and the defendant number 1. That is the first question. That was the first question, and thereafter we'll have subsequent issues. So, issues number 1, paragraph 5 decides issue number 1. Issue number 1, 2, and 7 are as to whether there is any liability of the defendant number 1. Since admittedly the plaintiff never had any contract with the defendant number 1, whereby the defendant number 1 had to supply any wheat to the plaintiff, much less at the price of such and such, there cannot be fastened any liability upon the defendant number 1. In my opinion, once the plaintiff has no privity of contract with the defendant number 1 and the only contract of the plaintiff is with the defendant number 2, it is not understood how the defendant number 1 can at all be liable, because once there is no contract, then there is no breach of any promise or contract committed by the defendant number 1 qua the plaintiff, and which thus can be sought to be enforced in the present suit. These issues are therefore decided against the plaintiff and in favor of the defendant number 1. So that's the first judgment that I wanted to lay. Now the next one is that 57, 56 first. But AI 1950, AI 1957, Punjab Haryana 169. The 169. I am relying upon Millard, paragraph 2 and 18. Paragraph 2 is for the factual aspect. Millard. In this case, the fact was that one Jumma and others mortgaged 67 bighas of agricultural land for rupees 3,500 with the plaintiffs. Some time later, partition of the land took place. One of the land falling to his share, Jumma mortgage with possession of 25 bighas of land with defendants Kaka Singh and Dhanna Singh. Out of the mortgage money, rupees 875 were left out with the defendants' second mortgages for payment to the plaintiff. Defendants did not pay the money to the plaintiffs. The latter therefore initiated the present suit for the recovery of the money left by the mortgagor with the second mortgages. This suit was registered by the defendants on the ground that there was no privity of contract between them and the plaintiffs, and the latter therefore were not competent to sue. Because the agreement was between the other mortgage agreement had other parties. Now on the paragraph 18. From the perusal of the, I'm not repeating the authorities which were, those are lordship would find those in the report itself. From the perusal of these authorities, it is obvious that there is abundant authority in favor of the view that a stranger to a contract cannot sue to enforce it unless the case falls within one of the exceptions mentioned in the earlier part of the judgment. The cases laid upon the learned counsel for the appellants are distinguishable, and in most of those cases, Privy Council authority was not cited. Even in those authorities, general principle is accepted that a party who is not privy to a contract is not entitled to sue. It therefore appears to be well settled that in case a trust is created, the beneficiary is entitled to enforce it. Keeping this principle in view and following the authorities of the Privy Council and Madras Full Bench, I am of the view that the present case does not fall in any of those exceptions. The money is merely left with the mortgagee to pay off the mortgage debt of the first mortgage. This by itself does not create any trust in favor of the plaintiffs. Thus, they, by being strangers to the contract, were not competent to sue. The suit was therefore rightly dismissed by the lower appellate court. In the result, the appeal is dismissed with cost and the judgment and decree. The appeal was also dismissed.
Yes.
So this was the second lot on the question of privity of contract and that entitlement of sue, entitlement to sue. The last one on this point is that the 2002 PLW. 2002 no?
Yes. Next.
But the 2000 but these are two judgments I'm relying upon on this point. And one on the limitation. I'm not citing any judgment because this is beyond 3 years. That's my case. It's expressly barred by limitation. I wanted to cite a judgment on the point that if it is expressly barred, then lordship can dismiss, even if limitation is a misquotation of law and fact, but expressly barred, in case of expressly barred, lordship can dismiss at the interim stage. And also the question of commercial suits. I just want to indicate that the Commercial Courts Act provisions that form lordship has, that now it's mandatory. Someone has to plead. And even when the suit was filed in 2022, those pleadings are completely absent in the plaint, the commercial suit. These are my page. This is the one judgment I want to cite. I'm not carrying copy. I'll give the copy here, that I have the copy in my. It's 2002, 2000.
The last issue has not been pleaded, my lord.
Which one?
It's got to the commercial courts not been pleaded, my lord.
It's a question of form. Why do I need to
plead
plead
that
No,
first
no,
application?
The question of form, writing up.
Okay.
Why do I have to plead something which is evident from the plaint?
What can take so?
2002, volume 3, Law Weekly 572.
2002.
Yes, 2002, volume 3, Law Weekly 522. Paragraph 259 to 12.
Page number?
Page number 522. Paragraph number 225 and then 9 to 12. I'll give the copy of the judgment to your court, my lord officers, my lord. It's on the same principle that unless there is a privity of contract between the parties, because this is a division bench judgment.
Privity of contract.
On
Not
that.
the commercial.
No. Commercial, I don't want to cite in judgment on that. I'll give the copy.
Yes. That's all.
That's all.
Yes.
Lord, the first issue raised, my lord, there is no cause of action, my lord. Kindly, my lord, takes the plaint once, my lord. Just only.
You give me what's the name of your company, plaintiff?
My lord, it's a plaintiff name. Plaintiff
And
name.
what about the
My lord, it is there in the deed itself. But all the pages are not shown. Now, where there has been a unilateral mistake, only that page has been shown. But where, well, how the money has come in, the company who has paid the money, who have signed the deed, that has not been shown to my lord. And my lord, this has been recorded in my lord's order also. Not only my lord, Lord humble, my lord, kindly my lord takes the order first of my lord's, my lord. What did they go? My lord, no, first order. My lord, kindly my lord takes up September 29th, 2022 order, my lord. That is the first ad interim order. Just passed, my lord. But this issue is considered by my lord. Thereafter, the order was passed, my lord.
29
And this is
September.
my lord, this issue they have also raised in their injunction application, my lord, in the opposition injunction application. That issue was decided. The injunction application was allowed. This point, my lord, has been dismissed, my lord. No appeal was preferred thereafter. Still, my lord, I'll just address the issue once. My lord, kindly, my lord, takes the order of 29 September 2022.
You are having the copy? You are
My
not.
lord, the first order which was order copy.
29 September.
It's the first order it was passed, my lord. The first order. The second order. Second order. Case number 182 তে প্রচুর পুরনো সিএস এই নতুন পুরনো সিএস 182 29 সেপ্টেম্বর 2022 আচ্ছা কপি আছে can you take my application number that's annexed there GA3 one is annexed one
তো দিলে তো annex করিস তো।
আমি কেন annex করিস annex করিস তো
আগে তো annex করিস তো।
But my application, I mean, my application Article Rule 6 one is there.
Year
But,
3 page number.
But kindly my lord takes my lord আমাদের application order GA3 well it's there my lord take my lord the plaintiff has filed a suit for decree of such and such perpetual injunction interest. Well, this is a suit for redemption of a mortgage deed, my lord. In the month of January, the defendant has approached the plaintiff for financial assistance. Secured. The defendant has agreed the defendant shall provide security by mortgaging their assets and properties on finalization of the terms and conditions. Plaintiff defendant has entered into agreement. Subsequently, the plaintiff has entered into a supplemental agreement in such and such. As per the agreement from such and such, the plaintiff has paid a sum of rupees to the defendant by transferring the said amount in the account of defendant. My lord. And the is recording the amount being transferred. As per the secure defendant also deposited checks.
What has happened? It's still pending, not disposed of.
Disposed of, my lord. I'm just showing my lord's order, then I'm going to come to the final order, my lord. Now, my lord, it has, well, kindly, my lord, takes page 3. The recording is there, my lord, that the name was deferred. The name, the reasons payee name deferred, my lord. The checks, my lord, the same has been dishonored with the reasons. So, my lord, it has been shown and also to explain that there has been a unilateral mistake on the part of the parties with regard to writing the name only in the deed. And these checks were handed over by the defendants 1 and 2 to the plaintiff, my lord.
Yes. Then
Now, my lord, in this application, my lord, the defendant number 1 and 2 and 3 had filed an affidavit, my lord. My lord, this affidavit will be found in my GA number 3, my lord. If it's there, GA number 3.
yes, it is there.
GA number 3, my lord, kindly, my lord, takes page 247. Well, this issue, my lord, has already been, my lord, dealt with, explained, and now, my lord, they cannot take the issue at all, my lord.
Yes,
Now, my lord, kindly, my lord, takes page 250, 51, my lord, paragraph 5. May I read, my lord? I shall now proceed to categorically state the actual facts and circumstances of the event that occurred. A, the answering respondent has filed a vacating application and such. The answering respondent, for the purpose of availing a loan loan of rupees 2 crores 50 lakhs, execute a deed of mortgage dated 17 February 2016. The first deed of is getting accepted. Thereafter, my lord, and it's always a plaintiff, my lord. The kindly my lord sees the name is entered into with the plaintiff. The kindly my lord takes the C. Thereafter, 252, the supplementary agreement, my lord, being accepted. Now, my lord, he goes to the relevant clause of the supplementary agreements, which he has entered into with the plaintiff. Vacating application तो है, vacating application same issue raise किया था ना vacating application में, कोई vacating application है देखो ना. E, my lord, subsequently, as per legal advice, parties collated all the terms and conditions in the deed of mortgage 17 February and supplementary deed and executed a deed of a registered deed of mortgage dated March 17, 2016. Well, again, admission, my lord, that the plaintiff and the defendants have executed or entered into this deed.
Yes.
Now, the answering respondents handed over the checks. It is the defendant dated such and such by the covering letter. It is their letter they have handed over, my lord. We have taken it in good faith. That is our case in the plaint. We have taken it in good faith and we have seen these are the difficulties. They said that furnish it. We have furnished it. It came about the addressee name wrong, my lord. The bank name wrong. Now, my lord, they had also taken out a vacating application, my lord. They had taken a vacating application on the same line, my lord. My lord, now, my lord, the vacating application as well as, my lord, the injunction application, both, my lord. No, the vacating application got dismissed. I mean, injunction got allowed. My lord, kindly, my lord, takes the order dated March 4, 2024. No, sorry, my lord. No. My lord, date of March, my lord, it is February 19, 2024.
February
Yes, my lord.
2024.
2024, my lord. Well, small order, may I read out? This is a vacating application filed by the defendant. Inter seeking discharge of the order dated September 29, 2022.
GA number?
Plus GA number 2. One was my injunction application, 2 is a vacating application, 3 is my order 12 rule 6 application.
No, it is not here.
Achhe,
You're writing the copy?
But in this application, the order, their application under vacating got dismissed. The issue which was raised, kindly takes it from me, the issue which was raised is similar to that of order to 11, my lord. That name is the name of the plaintiff.
Where is the application?
My lord,
you have annexed, not.
No, not disposed of, not annexed. That's the
GA3 का नहीं है. हाँ, where is it? ये तो
GA
order है.
GA2. I ordered.
No, this order. He's not referring this order. This order is here already. He's referring some other order.
GA2 of 2022. 19th February. No,
That is GA3.
Well, there are two orders, 19 February 2024. There are two orders, my lord. My lord, OCD 7, my lord, and OCD 8. OCD 7 kindly takes one, the GA1, that's an injunction application order. My lord, the defendant, so respondent remains unrepresented even a third call. The matter therefore is taken up for the absence of the defendant respondent. In this application, my injunction application is set out, my lord. And thereafter, my lord, the matter was again adjourned. The matter was thereafter appeared on several occasions and adjourned. In the aforesaid facts, in absence of any contrary version being available from the side of the defendant, which is also not apparent from the affidavit used, the order is confirmed, my lord. The GA1 gets disposed of. Now, my lord, GA2.
GA1 is with regard to the interim order.
Interim order, my lord.
That was
Injunction
confirmed.
application was not allowed, my lord. Now, GA2 is another 19th February 2024 application. That is OCD 8, my lord. Any my lord takes left hand inside corner, OCD 8. OCD 8. OCD 7 আছে OCD 8 direct.
আলাদা জিতে হয়েছে
হ্যাঁ
আলাদা
আলাদা জি আলাদা জি হবে না
OCD 8 and the separate orders are there. Yes. Now that is 7.
कॉपी रखिएगा ना तुम तो कुछ नहीं करते कौन हो गया Any squishing in it?
ওটা শুনবেন বাড়ি করে
None of them is annex followed. On purpose.
This is a vacating application.
By the
None
defendant.
appears on behalf of the application, even a third person. So that is not decided on merit.
It's not decided or is dismissed, my lord.
Yes. Next.
Now, my lord, thereafter, my lord, I'll show another order of March 4, 2024.
Yes, 4th March. Order to Rule 6.
Yes, well, this is an application on for judgment of an arbitration.
I find there's an admission as to the receipt of the loan amount. The mortgage did not represent agreement evidence. It did not represent due to change of sorry,
अरे judgments will कहाँ गया
So case adjourned.
Yes, John, my lord, recording, my lord, the admissions they had made. So, my lord, the statement that, my lord, the plaintiff and the person signing the agreement are different, my lord, that goes away. In any ways, I'll show the deed once, page 47 of the page 47, kindly, my lord, not 43. Sorry, my lord, I'm sorry, my lord, I'm just referring to. And here, my lord, kindly, my lord, takes deed page what we have to. Deed page 62. Page 62, my lord.
Page 62.
Yes, my lord.
Of GA4 or GA3?
My lord, GA4, my lord, GA3 also, my lord. If my lord is on GA3, my lord, that is on page, my lord, 47.
GA4, page number?
Lord, 62, my lord. Kindly, my lord, takes the signatories, my lord, at page 79.
79. Sunil Jain.
Lord, the 79 lab, my lord, on the below, my lord, last. Mahadeva Real Pro Private Limited, that's a plaintiff company, my lord. GA4, my lord, page 79. And my lord, page 80, my lord, is my lord, page 79. My lord. Page 80 is the sum received by the defendant numbers 1 and 2, my lord, from the plaintiff company. There has been a unilateral mistake on the part of the parties, my lord, in recording the name in the deed. But, my lord, the money and the deed has been signed by the plaintiff, my lord.
79, seal. See the seal, Sushil Kumar Agrawal.
Stamp used. There's a stamp was used.
এই দেখো
That is, they are pleading in the plaint itself. They
Correct.
use the stamp but signed by the same, directors are same.
the PAN number my lord,
That is why.
PAN number কত PAN card ওদের দেখো Lord,
हम लोग कहाँ पे लेके आए थे?
Lord, we had also annexed the PAN card, my lord. PAN card of the defendant to the plaintiff to show that the in the deed, my lord,
That
the
is
PAN
correct.
card
The
stated.
Now the only question is that as per your deed, the Madhav Real Estate Company Private Limited is the party concerned. Correct. He is the party concerned who has received the amount. And the signature which you are relying upon, page 79.
My lord, page 81 is the my lord, kindly my lord takes my lord the I'll show my lord the plaint. Kindly my lord takes the PAN card number, my lord.
No, see, PAN card of the company or PAN card of the
Company. একই তো আরে ভিতর প্রিন্টে কত আরে না মর্গেজ দেখছি ক্যালেন্ডার ওয়ান পার্ট মানে এই পেজ 81 দেখো নাম্বারটা বল kindly takes page 41 the PAN card number and the PAN card at page 81 of the plaint. The plaint page 81, which is also there, my lord. আচ্ছা দিয়েছে দেয়নি as usual.
Page 81
of the plaint, my lord, which is my lord not here, but kindly my lord the plaint page 81 of the plaint, my lord.
So in this
Lord, Lord A Lord is my lord double A GC M9123R.
Madhava Real Estate Company Private Limited. Madhava Real Estate.
No, that's the same company, my lord.
Double A GCM 9123R.
Yes, my lord. Page 81 of the plaint.
How it can be?
Yes.
See, page, kindly come to your plaint page 32. Or mortgage or the GFO.
Page 32.
Page 41. Page 41. Come to the page 41 of your GFO.
Yes, my lord.
Correct.
Yes, my lord.
Madhava Real Estate Company Private Limited.
Yes, my lord.
PAN number AAGCM 9123R.
Yes, my lord.
Correct. But now we come to the 81.
Yes, my lord.
Then it is the Madhava Real Pro Private Limited.
Yes, my lord. Can you stick the PAN number? But that is what we are
Correct.
saying. There has been a unilateral mistake in writing the name. It's a typographical error, my lord.
Of
my lord, on the part, my lord, on the deed, my lord, with regard to the name of Mahadeva Real Estate, my lord. That is what the typographical error is, my lord. Because at all material point of time, it was a real pro who had given the money.
So after the
because the real pro has signed it.
When the check was dishonored.
Yes, my lord.
When the check was dishonored, have you taken this plea? Have you taken this plea when the check was dishonored on the ground that the name does not match, name differ? Have you taken the plea before the defendant? See, you give the check in the name of the real estate, not to the pro.
My lord, that is what the pleading is, my lord. When Kani takes the pleading, my lord. And my lord, kindly my lord takes my lord,
How
the, my lord, now my lord,
how the PAN card number
Lord,
will be different. PAN card number is in the
PAN card number my lord, cannot be differed, my lord.
Cannot
PAN
be
card
differed,
number has
that's
to be
why.
same. So my lord, when entering into the agreement, my lord, the PAN card of Real Pro is there. Only one of the name, my lord, by typographical error has been changed. Only the place, my lord. But that is what is being utilized by the defendants right now. Page 140. And my lord, now my lord, when we have issued the notice at page 133, my lord, for redemption of the mortgage, my lord.
Hmm.
And after the check, my lord, dishonored, my lord, page 133, at page 140, my lord, we had made such statements, my lord. This, my lord, if kindly my lord sees,
Page
133 at page 140. Although, my lord, page 133 is letter of, my lord, redemption of mortgage of May 23, 2022. GA4 only, my lord. Although my clients, my lord, at page 140, my lord, may read out. Although my clients completely relied upon the defend number 1, it is in blind faith and in accepting such checks, the said checks appears to have been made out in the name of Mother Real.
where from you are reading?
Instead of, my lord, page 140, my lord. GA4, my lord.
Yes, although my client completely relied upon sociology.
In the name of Mother Real Pro, in place and instead of my client, and have been the signatory of the agreement, including the registry of such and such, although the initial schedule of the agreement, including the said registered document in the name of the party, by mistake has been mentioned as Mahadeva Real Estate Company, the PAN number and all other details, including the signatory details on behalf of the fourth part, that is of my client. This fact was always known and admitted by all concerned. As such, all those checks were presented, were dishonored with the endorsement of the name, payee name, deferred.
Yes.
But the defendant has received money from the Real Pro, that is the plaintiff. They have signed the deed knowing, my lord, on purpose, seeing that there has been a typographical error, my lord.
So whether the amount which you have paid,
Yes, my
which he has paid, in whose name?
His name. I have paid to his name, my lord.
Whose name?
Defendant number 1 and 2's name, my lord.
That is the
My lord, payment details isn't there, my lord, at page, my lord.
by way of check or by way of RTGS?
RTGS, sir, no? RTGS, my lord.
RTGS, I mean the bank account in whose name the bank account?
Lord, kindly, my lord, takes page 80 is there. This is not denied. This amount, page 80, my lord, of GA4, my lord. This amount, my lord, they are not denying.
No, amount they are not denying.
RTGS, name of the bank must given, my lord.
They are taking the plea with regard to the name of the
My lord, the account number, the check number is all there, my lord.
page 80.
Page 80.
In whose name?
The account details is there.
Account detail is
Well,
there.
it is their account details, my lord. They have to, my lord. It's there, my lord. They have to say, my lord.
Transferred, the account detail you could.
My lord, I can bring in an affidavit saying that, my lord, whose details.
To bring that.
Well, I'll give that on
Whether it is a real estate or real pro.
I'll bring that. No, Real Pro has given.
That's why whether
I'll show that, my
account,
lord. I'll show that.
in whose account?
In, my lord, defend number 1's account, but, my lord, I'll take instructions with regard to same, my lord. I will, my lord. Now, my lord, with regard to, my lord, the 2016, the payment was made.
given this 2 crore 50 lakhs,
Yes.
from which give Madhava Real Pro or Madhava Real Estate?
My lord, real estate, sorry, Real Pro, my lord. Real Pro account. From the Real Pro account, it has gone to the defendant number 1. There is no denial of that. Even in the affidavit, my lord, they say that. My lord, the affidavit which I relied upon, my lord,
They are relied upon.
which they specifically said that they have received the money. They have entered into an agreement with the plaintiff. They cannot deny those parts. All of a sudden now, my lord, during litigation time, my lord, they come up and say that no, this is not real. I don't know who is Real Pro is. I only know real estate.
So let the party go for the trial. It is a trial matter. Why
My
order
lord.
7 rule 11 or why the 12 rule 6?
My lord, because in the order 12 rule 6, my lord,
No, it can't be. Because
Lord.
now you are telling that it is not a real pro, it is a real estate. You are telling that this is a matter of
my lord,
trial, sir.
my lord, my bank account will show, my lord, who has received it. My lord,
So that is a matter of trial. Now in the order
Lord,
12 rule
this
6
issue-
cannot go into that.
judgment that they wait. My lord, this issue, my lord, greatest of respect, my lord, this issue, my lord, they cannot raise it. This is a completely fraudulent issue, my lord, and on which they cannot take good of a mistake, my lord. My lord, I'll be relying upon, my lord. I just have one copy, my lord. That is the only. And my lord, only one thing, my lord, kindly, my lord, takes prior to that. My lord, kindly, my lord, takes the order of this honorable court, March 4, 2024. Page 2, my lord.
Yes.
On perusal of the agreement.
Yes, I got it.
My lord, there is
Last
already an
paragraph.
admission. My lord, already an admission has been made.
But here there is that plea was not there.
My lord, this point of time was there.
Where? Can you show in this order?
My lord, this
court has
order is of
decided-
March 4, 2024.
Correct.
Their application, which they had taken out of vacating up to, is much prior to that.
Maybe, but that is
2022.
not on merit. That is not on merit.
They had given an affidavit, my lord.
Maybe.
They did not press their affidavit
Maybe.
or my lord, the application.
Maybe. If it is not decided on merit, can this court say no, that has been taken
My
care
lord,
of?
in the injunction application, their affidavit was there. It was decided, my lord. This honorable court was pleased to take notice of their affidavit, the contents of the affidavit. Thereafter, in the contents of the affidavit, even the statements which they had made were with regard to the change of name or the name not there was not considered or, my lord, not given importance to by this honorable court, my lord. My lord, should the order of this court while deciding the injunction application. Again, now they are trying to come up with the same application.
Okay. Next.
They have already taken the plea once, my lord. Not only, my lord. My lord, only, my lord, kindly, my lord. This is Indian law reporters, my lord. My lord, I just have one copy, my lord. My lord, देखा कल देख सकता है नहीं मैं और भी 4 तो judgment था my lord, I've got other judgments even, my lord, on this issue, my lord, that, my lord, in a contract, my lord, if there's a mistake in recording, my lord, and, my lord, the defendant cannot utilize that mistake, and that would tantamount to fraud, my lord. They cannot utilize the mistake.
That is on order 12 rule 6.
My lord, that is what the plea, what they have taken, my lord.
Correct. That's not telling, but they have taken the plea.
Yes, my lord.
That plea is to be decided on trial. That's
That
why
plea
this court-
cannot even, they
that's
cannot
why
even
this
take
court-
that plea.
That's why this court is asking with regard to what the payment you have made to the defendant
may I-
as
may-
per
may
page
I-
80.
My lord, may I come back tomorrow itself with, my lord, an affidavit stating that how the payment has been made. Only that fact, my lord.
Correct.
I'll
That's why.
take that, my lord.
That's why. See, it may be may be a wrong name, or maybe you are using that company name, whatever it may be. PAN card is there, but the transaction which page 80, ever 7 or 8 transaction which you are telling, whether that transaction has been gone from the pro or for the real estate.
My lord, I'll come back with an affidavit stating the same.
That is the real.
Only that is, my lord, kindly, my lord, gives me leave to on that count itself, my lord, that specific leave, my lord, that I'm going to, that, my lord, these transactions, my lord, have been brought by Real Pro, my lord, only into that leave extent. I'll bring in the documents, my lord.
But bringing the document, can this court under order 12 rules can decide that is this is stage now.
Not order 12 rule 6, my lord, but kindly, my lord, takes the orders to rule 11 once, my lord. they are taking a plea, my lord, with regard to different names. Which, my lord, I am saying that you cannot take even that plea. That is completely a fraud. You cannot do it. You cannot take such plea at all. I'll bring judgments for that. There's one judgment, there are others even, my lord. That is one aspect. Then, my lord, the money they have already accepted. So now they cannot come up and say, my lord, there is only one place a wrong name is there. All other places, my lord, the actual name, the real name comes into picture, my lord.
Okay.
Well, I'll
Yes.
come back tomorrow, my lord.
So far as the legal question, legal question that my friend is going to argue, if he argues that point, then I'll give answer to that. And Milord, so far as the permission to file a supplementary an affidavit explaining the details, Milord, that in
I have
one-
not yet used an opposition, my lord.
Only this court is directing to give the details with regard to the payment made to you,
Yes.
from which account it was.
subject to subject to correction, Milord, that thing is not there in the plain.
Because you are admitted in your affidavit.
That is what I wanted to show. Because by that admission, Lordship is my friend is showing from an order of court.
Not
No,
all.
no, no,
the
your
court, in
affidavit.
affidavit.
Yes, the affidavit.
In affidavit.
I understand. I will, Lord, that affidavit I have retracted.
No. They have filed
that
it,
is the-
page 247.
Milord, that is what I wanted to cite, Milord. अरे আমি জানি ওটা তুমি কি লেখা
কি এটা?
Kindly give me that page 24th April 2023 order, court's order. That the question of retraction of that affidavit is recorded in the order of court. I have the same day when this affidavit was served upon them, on that very day at 4:30, the early advocates were there. Though, at
It
that
was
point of time.
filed.
At that
That
very
is the
day,
statement made by them. It's filed.
I'm relying on an order
Please
of court.
find enclosed here with the copy of the affidavit in
I did
opposition
not take it off
filed.
my right hand when he was submitting.
On
May
behalf
I,
of our
Milord, may I
client.
make my submission, Milord? 24th April order, 2023 order records there is an utter confusion in this matter.
24th April.
24th April 2023. Justice Mukherjee was taking interlocutory court at that point of time. There is an utter Lordship has the order that order clarifies this issue, this affidavit.
Signed affidavit served and there's a
Yes, that I know. I have taken care of this.
you have not
Order is
taken
not
care of it.
here.
The order 20, I can hand over the order, Milord. I am carrying a copy. Over the order. This one page, Lordship will understand what happened. I don't have to say anything more than this. This is 1 year before, 1.5 years back. I was not even briefed in that matter, in this matter at that point of time.
That's the reason I'm saying, man.
We are taking advantage of that.
So what has happened to the J1? J1
No,
Not allowed.
So, Milord, J1, Lordship had seen the order. On the same day when the vacating was filed, on that very day, the court records that there was no one appeared for the defendant. So on this day, we are allowing J1. Because we are allowing J1, the application becomes infructuous. And it was the vacating was rejected accordingly. Defendant was not absent on that day. And Milord, the other order that was shown,
No, that has reached
court
final.
marked order.
There is no appeal preferred. There is no recalling preferred. Nothing is there.
Why this habit of interruption?
No. I'm
I
sorry,
did
man.
not interrupt at all when he is
When
submitting.
you are saying something, you have
So,
to do
Milord,
that.
4th
na.
March order, Lordship would find that in that very file, the 4th March order is also there. On that very day, although the defendant was present, the defendant did not have wakalatnama. So no submission was made at all. And the court records
This
you
plea
can't
cannot be taken, my lord, now, my lord.
order
Then
records
how
show.
can you file it then?
Well, order records show. I
How
am
can
not
they
making
file
it
it?
up. 4th March
But
order
kindly, my lord,
records.
calls, my lord. This is, my lord, the completely, my
Lord,
lord, dishonor of
March.
the court, my lord.
Either my handprint will, when he was submitting, I did
no,
not
no, what are
interrupt
you
for what?
submitting?
I do not know
Give-
why this
submitting,
habit
this
of
is not
interruption. Milord.
Once an admission made, they
So,
want to
Milord,
retract the admission. This
order
way. You cannot do it.
get the chance. You will get the chance to reply.
So, Milord, yes, that is there. I'll when the affidavit comes, Milord, I'll deal with. Kindly give me opportunity to deal with that affidavit.
So appearing for the plaintiff. So appearing for the defendant. Plaintiff has filed an application being GA3 of 2023. Praying for judgment upon admission.
Judgment
Defendant has filed an application. Defendant number 1.
Yes. No, I'm for yes,
All.
one.
You want.
Number 1 has filed an application being GA4 of 2024. Praying for rejection of plaint. Full stop. Counsel for the defendant has argued the matter in connection with GA4 of 2024. Full stop. Counsel, while giving reply by the learned counsel for the plaintiff in connection with GA4 of 2024, This could find that the plaintiff has relied upon the transaction made between the plaintiff and the defendant, which is appearing at page 80 of GA4. But from the said memo of receipt, it is not clear from which bank account, the bank account from which the amount was transferred in the name of the defendant is recorded.
My lord, only one thing, my lord. I'm sorry, my lord, in GA2 at the state bank statement is there already.
J2.
GA2, my
What is
lord,
the
may I
GA2?
just, for
is
my
the
lords, my lord, just showing it, my lord, in GA2, my lord, they had taken the plea and this is the affidavit which we had filed. And it is from Mahadeva Real Pro. Kindly, my lord, consider this affidavit once, that paragraph 8 and page 11. my lord.
Details.
Details, okay.
What is the GA2?
Well, GA2 is a vacating application which they had filed stating the same, raising the same issue that the names are different.
So the GA2 is disposed of?
Yes, my lord. But kindly calls for the records, my lord. Then, my lord.
ये बोल रहा is recorded in the name of Madhav, in the name of the plaintiff, or in the name of Madhav, MADHVA, Madhava, Real, Real, ESTAT, State Company, Private Limited, having PAN number AAGC M 9123 R, capital. Counsel for the plaintiff submit that the details of the bank account has already disclosed by the plaintiff in an application being GA2
Yes, ma'am. 2, my
of
lord.
2020.
No, 2022, my lord.
2022.
My lord. It's an affidavit dated 10th February 2023.
It's not a part of the paint. I'll take a chance to revert.
Yes. Full
You
stop.
have already.
2022. Full stop. Considering the submission made by the full stop. It is also submitted that the said GA2 of 2022 is already disposed of by this court.
Yes, my lord.
Disposed. In view of the above, in view of the above, the office is directed to place the record of GA2 of 2022
My lord, one also, my lord, may I, my lord,
filed in CS number 182 of 2022 before this court on the next date fixed.
not even one can be brought on record, my lord. 1 and 2 both.
What
my
is
lord.
the one?
My lord, of the pleadings of which they have made, my lord.
Full stop. The counsel for the plaintiff further submitted. It is also necessary to see. It is also necessary to dispose of the said and the present applications, the GA1 of 2022 and only call for GA2, na? GA1 of 2022 is also required to be gone into. Accordingly, the department gone into. Accordingly, the department is directed to place the record of GA1 of 2022 as well as GA2 of 2022 before this court on the next date fix. Full stop. If the record is placed, the defendant is at liberty to inspect the record and he intends to file any reply to the said. No,
They have already filed in
to
GA2, my lord.
inspect the record.
Grateful, my lord.
Let the matter appear
Okay.
before this court and let the matter appear on 18th of November
18th.
as parted.
Grateful. The failure in the top, my lord.
Parted.
Part on the top. Grateful, my lord.
Under the same heading, huh?
Appear for the state respondents.
Yes.
My lord, in this matter,
Hmm.
affidavit in opposition has been preferred by the state.
Hmm.
My lord, this is an application for appointment of receiver.
Hmm.
My lords. My lords, my learned friend has filed affidavit in opposition on 3rd September 2024, and I have preferred my reply thereafter. And my lord, with a advance copy to my learned friend.
Hmm.
My lord, may I take your lordship to page number 61 of my reply?
May I file my affidavit?
GA1.
GA1, my lords.
Have you served the copy?
Yes, yes, absolutely.
I have received mine.
Yes. Page number
Page number 61,
of GA1
GA1 of my reply, my lords.
of your reply. It starts from reply.
My lord, in the short, my lord, it can be resolved. My lord,
Okay, okay. 61.
my lords.
Yes.
My lord, the main contention is that there was an earlier order of injunction against the state defendants
Hmm.
by this honorable court as well as Learned Alipur court.
Hmm.
And both the courts has directed that my patent should not be infringed.
Hmm.
My lord, thereafter, many manufacturers have preferred a writ petitions.
The IP matter.
My lords,
Intellectual property matter.
my lords, 12A has been complied with.
No, 12 is a commercial, but it is intellectual property.
My lord, but interlocutory, IP matter, my lords.
IP matter. What is a prayer?
My lord,
What
my
is the
prayer
suit
is,
for?
my lord, patent infringement, my lord.
Patent infringement.
My lords.
So the suit has not been. The suit is to be. Number is to be corrected.
My lord, it has been renumbered. CS Commercial 548.
Now again it is. If it is a commercial, now it has
It has to be again renumbered.
IP division.
IP
Then it is
division
to be
number.
given as a IP number, not commercial.
My lord.
Yes, IP number, my lord.
So let the record be corrected first.
My lord, there one date may be given at a fixed time, my lord, so that it can be
Which
taken
year
up
suit?
because I am
Year suit.
in the GA, my lord.
Which year suit?
My lord, the suit is 24. 23. Original suit is 23, renumbered on 24.
So they are this court is not having jurisdiction. If it is commercial IP, then this court is not having jurisdiction.
And go to court number 10, I believe, my lord, should be.
Yes, my lords. Whatever is the determination, it will go.
So and so.
I'm led by Mr. Anirban.
No, so and so appearing in person as plaintiff, and the plaintiff is appearing in person. Full stop. So and so appearing for the defendants. Full stop. After going to the what is the suit number?
My lord, suit original number is CS 199
Then
of 2023, renumbered as CS Commercial 548.
But what is the prayer?
My lords.
Appointment of receiver. In the suit, appointment of receiver.
My lord,
So much.
my lord, prayer is at page number 30.
42.
30.
Yes, I am having the CS.
My lord, page number 30 is the prayer.
No, page 42 of the of your plaint.
My lords.
Correct. Appointment of receiver, interim attachment, order in terms of ABC.
My lords.
So,
my lord,
how it has been commercial?
My lord, if this court is having the determination, my lord.
No. What is the appointment
because
of receiver in the main suit?
My lords.
I'm not making any
My
submission.
lord, yeah, we
lord,
yes, my
may
lord,
I take
we are waiting for this, my lord.
My lord, may I take your lordship to paragraph 2 of my plaint?
Sir,
my lord,
you satisfied this court only for appointment of receiver.
Only for appointment.
Can a suit be filed?
My lord, under order 40, my lord, it can be filed because main suit is pending, and in the
Main
under,
suit is pending.
my lord, main
For Ali.
under order 2, rule 2, my lord, under order rule 2, I have taken the leave because I have not prayed this in the main suit. That's why, my lord, by leave under order 2, rule 2, I have filed this suit, my lords.
I have to go to the college and read again. I have to study.
My lord, there is a provision under order 2, rule 2, that if any
That's
prayer,
correct.
if
But
any,
that's correct. Order to rule 2, the court grant leave.
my lords,
But for filing of the suit for appointment of receiver,
my lord, because this prayer has not been made in the earlier suit, my lord. That's why, my lord,
in
this
the it is necessary in the suit the receiver prayer is required for appointment of receiver.
my lord, because my main
If
prayer,
your suit is pending, why you not file an application before the same court by filing an application, miscellaneous application, whatever it may be.
my lord, that remedy is available, but under order 2, rule 2, I have taken the leave because there is a provision, my lord.
That cannot be.
If I can relinquish.
Order 2, rule 2, you can go for anywhere and file a suit for any prayer.
No, my lord, I am
And
filing.
he's not asking for
My
any
lord,
final
with regard to
adjudication,
the,
so
my lord,
there is no
may I
suit.
see your lord?
What the adjudication you want in the suit?
My lord, may
What
kindly
decree
see,
will be passed in the suit?
my lord, may kindly seize paragraph 2, my lord. Of
Why I will go to the paragraph 2? I will go to the your prayer.
my lords,
Go sit, go sit. Kindly come to the prayer.
my lords,
When it was admitted.
my lord, it was admitted on
What decree the court can pass in
my
this
lords,
matter?
my lords. I am satisfying your lordship on this point. First, my lord, it was admitted on my lord, it was admitted on 21st September 2023. My lord, earlier I have filed the suit with the urgency prayer for leave under order 12 of 12A of the Commercial Court Act. The Honorable Court is of the view that you have to comply with 12A. So I went before the mediation center and 12A has been complied with. A detailed order has been passed by the erstwhile court, my lord, with regards to this prayer. My lord, the earlier order was annexed.
What?
My lord,
How many suit you have filed?
my lord,
Only one suit.
only one suit has been pending before this court, and in that suit, my lord, this is a
190.
connected suit.
This. Acha, GA1. GA. You are ready with the suit. What is the suit? What is the prayer in the suit?
My lord, the prayer in the suit, my lords, for appointment of receiver, my lord. Only appointment of receiver under order 2, rule 2, my lords. By the leave of under order rule 2. Because, my lord, that prayer has not been made in that suit.
You made this court full. You are having the plaint.
My lords.
Kindly come to the page 31.
My lords.
What is the prayer?
My lords. Decree for 1,000 crores, my lord. This is the main prayer. And my lord, thereafter, injunction and receiver.
I think that the receiver.
My lord, I am sorry, my lord. I apologize. I have not read, my lord. My lord, there is a main prayer of decree, my lord.
Correct. That's why I'm asking you.
I'm sorry. I apologize.
And where is the cause of action?
My.
Why this compensation you ask for? This amount you ask for?
My lords. My lord, after the order of injunction has been passed, my lord, the registrations to the electric vehicle has been granted by the state of West Bengal without complying with the order of injunction passed by this honorable court, which caused the royalty losses to me, my lord, to the extent of 1,000 crore. My lord, I have annexed the evidence.
Why you are telling that the patent infringement of patent?
My lord, because the main injunction has been granted on my patent, my lord. for infringement. And my lord, the main cause of action, bunch of fact arouse out from there, my lords, only. Because from there only genesis of the fact arouse.
So how the infringement case has been made out?
My lords,
Where is the pleading?
my lords. My lord, may I take your lordship to paragraph 27?
I am there only.
My lords. In view of the facts pleaded in the foregoing paragraph, plaintiff is entitled to claim defendant sum of rupees 1,000 crore for registering electric vehicles. 48,076 number of eco-friendly battery-operated electric vehicle as per report published in the Press Information Bureau.
Correct.
As per report filed on dated 11/7/2019 in review petition number such and such, defendant have registered 19,830 eco-friendly battery-operated e-rickshaws till 11/7/2019. The plaintiff accordingly calling for the exact number of registration from Vahan e-module based on the said report grant the said. This is the matter of trial.
No. So you are having the only license holder of the EV?
My lords, I am the only inventor of electric vehicles. The Mahindra Kinetic already has lost writ petitions with me, and there after those writ petitions were filed, my lords, the royalty has been paid to me by the Mahindra, by Kinetic, and all the dealers. And now, and that NOCs were accepted by the state of West Bengal. They have granted registration on the basis of my patent license. And now they are not following that. They are whimsically proceeding to grant the registration, which is causing royalty losses to me, my lord. That's why this suit. My lord, they are not follow. Their order is there. Their subsisting order is there.
So and so appearing for the plaintiff, so and so appearing for the defendants. After going to the record of the suit, we're going to the record. This court find that the plaintiff has claimed his right, claimed the patent right of electrical vehicle.
For the technology applied for eco-friendly vehicles.
For the technology applied for eco-friendly vehicle. This court find that this court is not having the jurisdiction. Full stop. This court also find that the suit is filed in the year 2023, and as such, this court is not having the jurisdiction to hear the suit as the matter is related to intellectual property right. Full stop. This court also find that initially the suit was registered as non-commercial matter. Subsequently, the commercial number has been assigned. Now the IP division has been created, and this case is related to intellectual property right. Thus, the department is directed to assign a new IP, a new number in connection with the IP suits, and to place before the appropriate court having determination.
My lord, registry may be directed to list the matter before the appropriate bench within a week, my lord, because
that I cannot. You mentioned the matter.
My lord, grateful, my lord.
Grateful.
Grateful, Lord.
My lord, this is my application for judgment upon admission.
Yes.
Lordship, I'm for opposite party, my lord. I'm praying for not today, my lord.
My lord, I'm opposing, my lord. They also prayed for an adjournment
Just
on
for
the
1 day
last
accommodation, my lord, because of some person difficulty, my senior has not come to court today, my lord. Just for 1 day accommodation. He will come tomorrow, my lord. Kindly keep it tomorrow.
Pleadings completed?
Yes, your lordship. The pleadings are complete.
Who is your senior?
Ms. Joshi Shah.
My lord, on 3rd September, my lord, they also prayed for an accommodation. The matter is being taken up today, my lord, thereafter.
Judgment upon admission, reply kept in the record.
My lord, acknowledgements galore, my lord. Dishonored checks, and my lord, further acknowledgement in the, my lord, opposition, my lord. I shall show.
How the commercial?
My lord, goods, my lord, services rendered, my lord. Services rendered.
Asking time, what can be done? Not today?
Not today, my lord.
Grateful, my lord.
As per the prayer made by the counsel for the defendant, The case adjourned. Let the matter appear tomorrow. Yes.
In respect of a contract for supply to Steel Authority by Titagarh, 148 wagons. There was a contract. The contract was entered into and work order was issued in 2020. It was to be supplied by 2021. Now they did not supply anything. It was extended from time to time till 2024. Now, my lord, they have not supplied one wagon even. My lord, it is about 43 crores of rupees. Now, there is a provision for arbitration, but they have filed a suit. The suit, my lord, covers all disputes, and the arbitration clause, the arbitration clause, my lord, is very extensive. It covers everything. Well, therefore, my lord, in the first instance, we filed an application under Section 8. And that application, my lord, I beg to place before
That's the
you.
GA2.
GA2, yes.
Yes, you argued the matter on the last.
Yes, I argued the matter, my lord. I just take 5 minutes to remind your lordship, my lord, what I had submitted on the last occasion. My lord, as I said, my lord, 141 wagons were to be supplied. A letter of acceptance in 17th of October 2020. Purchase order on 23rd October 2020. Performance was to be completed by 16th of September 2021. Not one wagon was supplied. Various fees were taken. The shortage of raw material, the increase in price. Then they also said that the government of India had issued instructions regarding the quantum of the GST. That stands reduced, but in the contract it was highest in the highest side. The government of India issued further direction regarding what should be the amount of performance bank guarantee, percentage of performance bank guarantee, that the government of India reduced. Steel Authority has not done so. These are the various allegations. The suit has been filed. The principal players, that is all regarding the
contract,
regarding the bank guarantee. Regarding the bank guarantee, invocation of bank guarantee by Steel Authority. And that's the initial prayers. But subsequently, the prayer also includes all the disputes. If your lordship kindly takes the plaint, or I shall take first your lordship to the arbitration clause in our Section 8 application, page 64.
Yes, I have taken note of it.
Yes, your lordship has taken note of that. Yes.
Clause 22 and 23.
Yes. Then, Lord, if your lordship takes, my lord, the plaint, page 188 of the plaint, the prayers, my lord, at page 21. I first take your lordship to that. In the plaint, the prayer is at page 21. The prayer starts from page 19 of the plaint. My lord, your lord, if your lord sees first of, my lord, they ask for decree for damages, etc. Then kindly come to CI. This is regarding the bank guarantee. Then II, everything. The perpetual injunction in D, prayer D, is also in regard to bank guarantee. Declaration that bank guarantee, that is E. But kindly come to prayer G. Declaration that the notice dated 9th May 24 being annexed K, and notice dated 6th June 2024 being annexed L, any other similar notice, illegal. Then this annexes K and L, they cover, my lord, the entire other factors, not only bank guarantee. You will kindly come to page 188 for a moment.
188.
188 of the plaint.
Yes.
My lord, 180, the letter starts. Then page 189. This is, my lord, the letter coming from Steel Authority. Kindly come to 189 middle. I mean the third paragraph in this letter. Even after that, in spite of repeated follow-ups and visits by DSP, no serious efforts could be noticed from your end for the delivery. DSP has already extended the delivery period several times till date, but no effect. This purchase tendering action was also taken once against you in March 23, but based on your request only for process was kept on hold. Next paragraph. Even after the amendment, in spite of repeated reminders from DSP.
Where from you are reading, sir?
We are page 189. The letter at page 189 of the plaint. What page 189?
Plaint is not there. Plaint is
Section 8, page 205.
Page 205 of the section 8 application, if you not.
GA2.
205.
205. The same letter.
Of GA2.
GA2 at page 205. First back. Page 205 of the section 8 application.
Yes.
Section 8 application is GA2. Page 205. Milord, first paragraph, purchase order for supplies of such and such, etc. Scheduled. Then second paragraph, commercial notice was issued to you on this regard earlier on 25th of February 23, and subsequently risk purchase notice was also served. Even after that, in spite of repeated follow-ups and visits by DSP, no serious effort could be noticed from your end for the delivery. DSP has already extended the delivery period several times till date. Risk purchase tendering action was also taken once again against you in March 23, but based on your request only, the process was kept on hold. The next paragraph, even after the amendment, in spite of repeated reminders from DSPN, no firm action or any suitable response was noticed from your end regarding supply. Refixing delivery period for all three recs has also been exhausted. In this line, another commercial notice was served. In response, your letter number such and such was received, which appeared to be a clear attempt on your part to completely disown your commitments regarding contract execution, and also appeared as an exercise in repudiating all the sincere efforts put by sale of DSP for the required procurement, including suspension of risk purchase action against yourself. This covers the entire dispute. And their prayer in the plaint, Lord, is with regard to this also.
Yes.
Now, Millard, apart from the fact that bifurcation of an agreement for the purpose of adjudication, Millard, is not permissible. But here, Millard, really, they are not trying to bifurcate. They amalgamated the entire thing in the plaint, and the entire thing is covered by the arbitration clause.
Correct.
Therefore, Millard, my section 8 application.
Okay.
Now, Millard, this is the only point I am making. Now, Millard, may I refer to a few judgments on this? Millard, I had cited on the last occasion, 2024.
Dhanuka.
Yes. Today's Dhanuka, 2024 SCC. Have your lordship?
Yes, yes.
Required paragraphs also, lordship. Then, Millard, the Utkarsh tubes, 2014.
Yes.
Then 2010, the IR 2010, that is Magma.
That is not.
Then 2010 is not there. 2010 now.
Magma.
Magma. 488. The IR 2010 Supreme Court 488.
Yes, you referred that on that day you are not having the copy.
Oh, I see.
So
Then
I have taken note of it.
Lordship.
If you are having the
19 to
copy,
24.
page 19 and 19 to
19
20.
to 24. Paragraphs 19 to 20.
24. Yes.
Down. 2000, 2010. এখন আজকেও এক সেকেন্ড নো কি নাম ব্রাঞ্চ ম্যানেজার ম্যাগমা লিজিং may I read and hand it over to you? paragraph 19 I am reading. In the instant case, clause 22 of the hire purchase agreement that provides for arbitration has been couched in widest possible terms, as can be well imagined. It embraces all disputes, differences, claims, and questions between the parties arising out of the said agreement or in any way relating thereto. The hire purchase agreement having been admittedly entered into between the parties and the disputes and differences have since arisen between them, we hold, as it must be, that the arbitration clause 22 survives for the purpose of their resolution, although the contract has come to an end on account of its termination. The next question, an incidental one, that arises for consideration is whether the trial court must refer the parties to arbitration under Section 8 of the 1996 Act. Then Section 8 is quoted. Then paragraph 22. An analysis of Section 8 would show that for its applicability, the following conditions must be satisfied. A, that there exists an arbitration agreement. B, that action has been brought to the court by one party to the arbitration agreement against the other. C, that the subject matter of the suit is same as the subject matter of the arbitration agreement. D, that the other party, before he submits his first statement of the substance of the dispute, moves the court for referring the parties to arbitration. And E, that along with the application, the other party tenders the original arbitration agreement or duly certified copy thereof. Then paragraph 23. Section 8 is in the form of legislative command to the court. And once the prerequisite conditions as aforesaid are satisfied, the court must refer the parties to arbitration. As a matter of fact, on fulfillment of conditions of Section 8, no option is left to the court and the court has to refer the parties to arbitration. Then 24. There is nothing on record that the prerequisite conditions of Section 8 are not fully satisfied in the present case. The trial court in the circumstances ought to have referred the parties to arbitration as per arbitration clause 22. This is not magma leasing.
This has been referred in the Vidya Dronya.
Yes, yes. Now, there is one other aspect, that is and there exists an exception where a fraud exists, where a fraud is committed. Now, fraud has been pleaded in their plaint. In their plaint, they have pleaded fraud in paragraph 26 or 27. I just point. In paragraph 26, they have pleaded fraud in the plaint. The defendant number 2 had page 14 of the plaint, paragraph 26. It has several subparagraphs. The defendant number 2 is in the process of procuring breach of the defendant number 1's legal as well as other obligations in respect of the said bank guarantee. The defendants are thus perpetrating fraud of an egregious nature, vitiating the underlying contract between the plaintiff and the defendant number 2, some particulars whereof are given. A, the defendant number 2 had never intended to discharge its legal obligations, including the obligations arising out of the force majeure situation as per the terms of the contract. The defendant number 2 had always intended to unjustly enrich itself by not acting in terms of the contract. The defendant number 2 has fraudulently and dishonestly misled the plaintiff into believing that it would comply with its obligations under the said memorandum such and such, as would be evident from the defendant number 2 emails. Then defendant number 2 had never intended to honor its contractual obligation to reimburse pay the full GST amount at the applicable rate. The defendant number 2, in collusion with the defendant number 1, has fraudulently retained the said 2 bank guarantees, both dated such and such, in spite of the fact that they are entitled to performance bank guarantee worth rupees the lower amount. The defendant number 1 has acted as per fraudulent dictates of the defendant number 2 by not fulfilling its obligations owed to the plaintiff in terms of the bank guarantee, both dated such and such, as well as all other law applicable. The defendant number 2 has all along fraudulently and dishonestly misled the plaintiff into believing that it would act in terms of its obligations to reduce the amount of PVG and pay full GST amount, and on that basis allowed the plaintiff to proceed with the contract. In this regard, reference may be made to such and such. The defendants in collusion and conspiracy with each other are fraudulently trying to have the said 2 bank guarantees encashed. The defendant number 2 suggested to the plaintiff the fact that it would consider and act on the plaintiff's request for reduction of the PVG value and make payment of the increased GST rate. However, the defendant number 2 had acknowledged that such facts were that
Not
such
true.
facts were. That's exactly.
Were not true.
Yes. Now, if your lordship looks to this various allegations, there is no iota of any allegation
Particular.
that it involves any public domain. It's all between the parties. And the Supreme Court has specifically held that the question of fraud, only if it affects the public, then only by suit, etc. Otherwise not. Miller, I refer in this connection to 2019, 2019, volume 8 Supreme Court cases, page 710. Now, Miller, kindly come to paragraph 3. Paragraph 3 on
Ayasami case.
yes. Ayasami case, then paragraph is quoted in I'm reading paragraph 25 of Ayasami.
Yes.
In view of our aforesaid discussions, we are of the opinion that mere allegation of fraud simpliciter may not be a ground to nullify the effect of arbitration agreement between the parties. It is only in those cases where the court, while dealing with section 8 of the Act, finds that there are very serious allegations of fraud which make a virtual case of criminal offence, or where allegations of fraud are so complicated that it becomes absolutely essential that such complex issues can be decided only by the civil court on the appreciation of the voluminous evidence that needs to be produced. The court can sidetrack the agreement by dismissing the application under section 8 and proceed with the suit on merits. It can be so done also in those cases where there are serious allegations of forgery, fabrication of documents in support of the plea of fraud, or where fraud is alleged against the arbitration provision itself, or is of such a nature that permeates the entire contract, including the agreement to arbitrate, meaning thereby in those cases where fraud goes to the validity of the contract itself, of the entire contract which retains the arbitration clause, or the validity of the arbitration clause itself. Reverse position thereof would be that where there are simple allegations of fraud touching upon the internal affairs of the party, inter se, and it has no implication in the public domain, the arbitration clause need not be avoided and the parties can be relegated to arbitration. While dealing with such an issue in an application under section 8 of the Act, the focus of the court has to be on the question as to whether jurisdiction of the court has been ousted, instead of focusing on the issue as to whether court has jurisdiction or not. It has to be kept in mind that insofar as the statutory scheme of the Act is concerned, it does not specifically exclude any category of cases as non-arbitrable. Such categories of non-arbitrable subjects are carved out by the courts, keeping in mind the principle of common law that certain disputes which are of public nature, etc., are not capable of adjudication and settlement by arbitration, and for resolution of such disputes, courts that is public fora are better suited than a private forum of arbitration. Therefore, the inquiry of the court while dealing with an application under section 8 of the Act should be on the aforesaid aspect, namely whether the nature of the dispute is such that it cannot be referred to arbitration even if there is an arbitration agreement between the parties. When the case of fraud is set up by one of the parties, and on that basis that party wants to wriggle out of the arbitration agreement, a strict and meticulous inquiry into the allegations of fraud is needed. And only when the court is satisfied that the allegations are of serious and complicated nature, that it will be more appropriate for the court to deal with the subject matter rather than relegating the parties to arbitration, then alone such an application should be rejected. The principle of law laid down in this appeal make a distinction between such serious forgery or fabrication in support of the plea of fraud as opposed to simple allegations. Two working tests laid down in paragraph 25 are: does this plea permeate the entire contract and above all the agreement of arbitration and rendering it void, or whether the allegations of fraud touch upon the internal affairs of the parties inter se, having no implication in the public domain. Judged by these two tests, it is clear that this is a case which falls on the side of simple allegation, as there is no allegation of fraud which would vitiate the partnership deed as a whole, or in particular the arbitration clause concerned in the said deed. Secondly, all the allegations made which have been relied upon by the learned counsel appearing on the behalf of the respondent pertain to the affairs of the partnership and siphoning of funds therefrom, and not to any matter in public domain.
Yes.
That being the case, we are of the view that the disputes raised between the parties are arbitrable, and hence Section 11 application under the Arbitration Act would be maintainable, etc. Now, there is one aspect, there is jurisdiction point. The
Forum selection.
Durgapur. Forum selection. That is, in any event, it could not be filed in. That is page 60. Page 60 of section 8. Page 60 of section 8 application act. With the clause 11. Jurisdiction of courts. The courts are the place of ownership of REX by the respective sale plant only shall have exclusive jurisdiction. Now, we are pausing here for a moment. This was initiated, this process of tender was initiated in respect by the steel authority in respect of all its steel plants, Bhilai, Durgapur, and in the south. And therefore, it says that the courts are the place of ownership of REX by the respective steel plant.
Correct.
Only shall have exclusive jurisdiction, because here before your lordship, we are all concerned with Durgapur steel plant. Over any dispute arising out in respect of this contract, that is supply of bogie open type, wagon type, such and such for BSP at Durgapur, Chhattisgarh, supply of this, we are concerned with Durgapur. Therefore, Durgapur court will have jurisdiction. Supply of bogie open wagon such and such at Bokaro, Jharkhand, and supply of bogie open wagon such as Western for DSP or Durgapur, West Bengal. Therefore, this is wherever the rakes are to be supplied.
Yes.
That particular plant which is owning these rakes, that will determine the place of jurisdiction.
So as per your case, this court is not having it. It is Durgapur. Durgapur
Section
is
11 anyway could not be filed. The suit could not have been filed here.
টাইটেলে যে অ্যাড্রেসটা আছে ওই অ্যাড্রেসে কোনোদিনও কোনো এই কন্ট্রাক্ট রিলেটেড কোনো কমিউনিকেশন কোনোদিনই হয় তো আমরা লিখেছি পেজ 3 প্যারা 9
One minor aspect though, if your lordship takes the cause title
of the plaint,
cause title of the plain petition, but same cause title.
Yes.
Steel Authority of number 2, the Steel Authority of India Limited, a government company within the meaning of Companies Act 2013, Eastern Regional Office at Ispat Bhavan, Jawaharlal Nehru Road, Kolkata. This is how, my lord, we have been described here. But, my lord, this Kolkata office of the Durgapur Steel Plant had nothing to do with this contract. It was everything done in Durgapur.
কোনো কমিউনিকেশন
There is no communication also from this office. All communications are from Durgapur. Nothing to do with the Calcutta office. Type was out. 2015.
Yes.
My lord, the bifurcation aspect possibly I did not stress upon, because in the prayer of the plaint, it is not only the bank guarantee aspect, but even then, my lord, if they say regarding the bank guarantee, that is the main, they have highlighted on that. Then, my lord, I say that bifurcation is not permissible under the scheme of this act. Now, on that, my lord, I just refer to one judgment, 2015, 14 STC, 444, paragraphs 8 to 10 and 13. Sundaram Finance.
Yes.
Paragraph 8 at 447. Once there is an agreement between the parties to refer the disputes or differences arising out of the agreement to arbitration, and in case either party, ignoring the terms of the agreement, approaches the civil court, and the other party in terms of Section 8 of the Arbitration Act moves the court for referring the parties to arbitration before the first statement on the substance of the dispute is filed, in view of the peremptory language of Section 8 of the Arbitration Act, it is obligatory for the court to refer the parties to arbitration in terms of the agreement as held by this court in P. Anand Gajapati. Then paragraph 9. The position was further explained in Hindustan Petroleum Corporation. Paragraph 14. I read out not the paragraph 14. This court in P. Anand Gajapati Raju has held that the language of Section 8 is peremptory in nature. Therefore, in cases where there is an arbitration clause in the agreement, it is obligatory for the court to refer the parties to arbitration in terms of the arbitration agreement, and nothing remains to be decided in the original action after such an application is made, except to refer the dispute to an arbitrator. Therefore, it is clear that if, as contended by a party in an agreement between the parties before the civil court, there is a clause for arbitration, it is mandatory for the civil court to refer the dispute to an arbitrator. In the instant case, the existence of an arbitral clause in the agreement is accepted by both the parties, as also at the court below, but the applicability thereof is disputed by the respondent, and the said dispute is accepted by the court. But that it as it may, be that as it may, at the cost of repetition, we may again state that the existence of the arbitration clause is admitted. If that be so, in view of the mandatory language of Section 8 of the Act, the courts below ought to have referred the dispute to arbitration. In Magma Leasing, the position has been restated. Then paragraph 11. The attempt of the trial court and the approach made by the High Court is in bifurcating the cause of action is fallacious. It would only lead to delaying and complicating the process. The said issue is also no more res integra. In Sukarna Holdings, at paragraph 16 and 17, it was held as follows. Then paragraph 16. The next question which requires consideration is, even if there is no provision for partly referring the dispute to arbitration, whether such a course is possible under Section 8 of the Act. In our view, it would be difficult to give an interpretation to Section 8 under which bifurcation of the cause of action, that is to say, the subject matter of the suit, or in some cases bifurcation of the suit between parties who are parties to the arbitration agreement and others, is possible. And this would be laying down a totally new procedure not contemplated under the Act. If bifurcation of the subject matter of a suit is was contemplated, the legislature would have used appropriate language to permit such a course. Since there is no such indication in the language, it follows that bifurcation of the subject matter of an action brought before a judicial authority is not allowed. Secondly, such bifurcation of suit is in two parts. One to be decided by the arbitral tribunal and the other to be decided by the civil court would inevitably delay the proceedings. The whole purpose of speedy disposal of dispute and decreasing the cost of litigation would be frustrated by such procedure. It would also increase the cost of litigation and harassment to the parties, and on occasions there is possibility of conflicting judgments and orders by two different forums. Then 13. Once an application in due compliance with Section 8 of the Arbitration Act is filed, the approach of the civil court should be not to see whether the court has jurisdiction. It should be to see whether its jurisdiction has been ousted. There is a lot of difference between the two approaches. Once it is brought to the notice of the court that its jurisdiction has been taken away in terms of the procedure prescribed under a special statute, the civil court should first see whether there is ouster of jurisdiction in terms or compliance with the procedure under the special statute. The general law should yield to the special law, generally was, specially was, non-derogatory. In such a situation, the approach shall not be to see whether there is still jurisdiction in the civil court under the general. Such approaches would only delay the resolution of disputes and complicate the redressal of grievances, and of course, unnecessarily increase the pendency in the court.
Yes.
Therefore, in my humble submission, the suit should not be allowed to be proceeded. The parties will be referred to arbitration for the entire dispute.
Yes. Any further?
No more.
That's all. Yes, Mr. Mitra.
It's almost 1:15, May I start? No point in starting just now.
Next. So appearing for the plaintiff, so appearing for the
সোমবার আমি নেই সোমবার ছাড়া সোম শুক্র ছাড়া
defendant number 2
সোম
has
আর শুক্র
filed the
ছাড়া
present application
সোমবার চরণ আমি একসঙ্গে মাদ্রাসে থাকবো
form 2 of 2024 praying for referring the matter to the
বাইরে
arbitration
থাকবো না তা আগে
in
করতে হবে, পরে
terms of clause available here. Counsel for the defendant has concluded his argument. Due to paucity of time, counsel for the plaintiff could not argue the matter. This is the matter.
এই উইকে করবে না
ফ্রাইডে ছাড়া যে কোনো দিন। সোম মঙ্গল আর ফ্রাইডে
therefore it will be taken up tomorrow.
Yes, tomorrow.
Whichever day lordship says.
Let the matter appear tomorrow as parted under the same heading.
টাইম ফিক্স করা হলো টাইম ফিক্স করেন যাচ্ছে
অনেক সময় পোস্ট থাকতে হবে।
Milord, is it possible to fix any particular time for
Only appearing before this.
Yes, I feel so, my lord. But the GA lordship will have the determination.
This is not the IP, this is not IP.
This, my lord, it's the number is, my lord, in the cause list. It's incorrectly appearing as IP com. It's not an IP. It's a, my lord, suit for damages.
It's not an IP.
So why IP has come?
No, I don't know, my lord. Some typographical error. Because last order I have, my lord, this is the last. The last order, my lord, incorrectly it went down as IP com. If this is corrected, I think, my lord, the cause title will also be, my lord, naturally, my lord, correct.
This is the suit.
This is the last order, my lord. Kindly sees, my lord, the, my lord, cause title there. It's IP com recorded there. It's a suit for damages.
That
my
can
lord.
be corrected. That can be corrected.
So why IP com has come?
भूल करे हुए बोले
क्यों आया? नहीं ऑर्डर में क्यों आया? सूट में तो नहीं है.
Malad, may I say this kindly, my lord, corrects this order, my lord, the order of 20th August and keeps it, my lord, any day next week except, my lord, 13th. Mr. Sinha possibly has some difficulty on 13th.
What is the prayer?
My lord, summary judgment. It
No, the suit for
my lord, damages arising out of a works contract. I have an uphill task, but I'll limit my prayer. I'll limit my prayer to, my lord, only a portion of that claim. Only a portion of that claim.
I cannot calculate the.
That is why I don't want your lordship to go through the papers today. I know my limitations, my lord, with this application. I will only restrict my prayer to a limited portion of that claim, my lord. Kindly keeps it, my lord, any day next week or, my lord, 18th, which is Monday week.
So appearing for the plaintiff, appearing for the defendant. Full stop. The plaintiff has filed the suit praying for a decree. A sum of rupees and they can लिख लेना. Again the defendant. Full stop. Though the matter is related to the commercial division, but it is not the intellectual property matter. But inadvertently, the department has assigned the intellectual property number as IP COM 5 of 2024. IP -COM 5 of 2024.
Original number CS COM.
In view of the above, the department is directed to correct the how it can to
CS COM
to reassign the number as commercial suit number instead of IP COM number.
Yes.
IP COM. List the matter.
My lord, by consent, my lord, 18th, my lord, which is Monday week.
Let the matter appear on 18th November 2024.
Grateful, my lord.
Very grateful.
Great.
It is not the suit, na?
No.
No, it's the application.
Under the heading adjourn motion. Grateful, my lord.
Item number 16, your lordship.
Yes.
Kindly. Item number 16, your lordship.
Adim.
Yes, your lordship. Your lordship has directed for a report, your lordship. Your lordship, we are yet to receive a report from the department. Kindly, I am
What
praying
report?
a report
The order,
seeking.
what order was passed?
Yes.
You want extension?
Your lordship.
So appearing for the plaintiff. By an order dated 20th August 2024, this court by an order dated 20th August 2024, this court has adjourned the matter with the liberty to the counsel for the plaintiff to obtain report from the department to ascertain whether the writ of summons was served upon the defendant or whether the defendant have filed written statement or not. Counsel for the plaintiff raised for extension of time to obtain reports from the department. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on how soon? 22nd?
Your lordship.
Appear on 22nd of November.
My lord,
Let
item
me know.
number 17, my lord.
Yes.
My lord, on the last occasion, my lord, the commissioner had filed a report, my lord, special referee had filed a report assessing the mean profit. My lord, I am appearing for the defendant and I intend to challenge it. My lord, I'm in the process of filing an application. So I would humbly submit that my lord will kindly adjourn it for 3 weeks.
Who is for the other side?
My lord, the other side is here. And my lord, just one minor connection in the order of last 20th August. My lord, the parties' names and the advocate's name, only first page, my lord. Party's name and the advocate's name has been interchanged, my lord. I am appearing for the defendant, my lord. And the other side is appearing for the plaintiff. That be corrected, my lord.
So item number 17.
17, my lord.
So what you want now?
But I'm seeking an adjournment for 3 months, 3 weeks, my lord. Kindly also record that if my lord may record that I am intent to challenge, my lord.
Census suffering for the plaintiff, census suffering for the defendant.
Kindly make it 2 weeks.
Census suffering for the defendant. Full.
Only
For
one.
the defendant submit that he is agreed with the report submitted by the special referee and prays for time for filing objection to the report submitted by the special referee. In view of the submission made by the counsel for the defendant, the case adjourned. Let the matter appear on 22nd November 2024. Full.
I'm grateful to
Counsel
my
for
lord.
the parties brought to the notice of this court that by an order dated 20th August 2024, the name of the parties appearing and name of the advocates appearing for the parties have been interchanged. And as such, in the order dated 20 August 2024, 2024, the name of the advocate may be corrected as follows. Mr. Devnath Misra with Mr. P.K. Singh appearing for the plaintiff and Mr. Devdutt Mukherjee, advocate, as well as Mr. G.K. Das appearing for the defendant.
I'm extremely grateful to my lord.
This pertains to the estate of Priyambadevi Birla. There was an, your lordship has a very big smile at the beginning of the year. Not good sign. So we start the post puja session with Birla man. Lord, he's fighting from the first day of Diwali.
I'll only
friendly opposition.
I'll only correct Mr. Mitro. His submission was not correct. This relating to Priyambadevi Builders.
That was your council submission there. You go to testamentary with Mr. Thakkar submitted, go to testamentary court. You know,
We will see that. But Mr. Mitra has now started trying to champion the other side's cause always. Let him make his case.
Always for the underdog, no, Mr. Mitra. Yes, yes. That's how it should be. Yes. Now, Malad, what has? Can you give me 1 minute?
বলবো না এটা কোনটি এরিয়া না আমি কি একবার বিনাশী পেরিওয়ালা আছে
What happened here, Lordship may recall, this pertains to the issue of a taking of an office pertaining to the estate of the Birla in the camp of the defendants. Now, what happened, Lordship, very briefly, Lordship may recall, there are 5 tier 1 companies where Mrs. Birla's estate directly and indirectly through cross-holding has majority shares, which has been described, which has been valued by them at 2,000 crores, and we have valued at whatever, at the par value. So this is the core of the estate where through which dividends on these shares are the substantial part of the assets. Now, Malad, there is the division bench judgment restricted the powers of the APLs to the shares held by the estate of Mrs. Birla. And on that basis, the division bench had further held that so far as the tier 1 companies are concerned, the APLs should act in the interest of the estate. Now, these tier 1 companies at all material times had their office on the 4th floor of Birla building at Arun Mukherjee Road, which is owned by Birla Corporation Limited, which according to my other side is also a part of the estate, but they were contending all throughout. The 2 APLs, Justice Shah and Mr. Chakraborty have been also contending that till such time as our division bench held, no, it's only strength of the shares. You have only 14% shares at by your cross-holding, so that's not part. So Birla Corporation owns that property on the 4th floor. And these 5 companies have their registered office there at a very nominal rent. Yes, 69,300 rupees per annum rent, and they also enjoy some infrastructure there. These companies have no business because they are the ones holding shares. That's all. So no running business, no industry, no trading, no running business. Now, but this was the position all throughout during Mrs. Birla's lifetime. After that, R.S. Lodha, then when the APL, Mrs. Thakkar was the third member, Ravindran, AP Shah, it was always like this. Now, what happened was in 2024, 2023 December was the division bench judgment, which undid the 2 APLs and the defendants' contention that they control Birla Corporation and everything. Then came Justice Shampa Sarkar's order, which negative all the APL's decisions regarding societies, trusts, and managed societies and trusts, and the control over things where the estate don't have legal rights. Unlike these 5 companies where the majority shares are with the estate. So, Malad, that the division bench is pending. There's no appeal from Justice Sarkar's order. No, there's an appeal pending. There's no stay of the Justice Sarkar's. Sorry, I'm only appearing in the appeal. Now, Malad, what happened here is that 25th of October 2024, the Mr. M.K. Sharma, respondent number 7, who was the 3rd APL, who was our nominee. Our nominee was Mr. M.K. Sharma. Mr. A.C. Chakraborty was the nominee of the Birlas, and the third APL is Justice Shah. So he sends a mail from which it transpired that on 23rd November, there was 23rd October, 25th of October, we get the mail. 23rd October, there was a board meeting of all the 5 APLs at 24 hours notice. Not a board meeting of APLs, a board meeting of the 5 companies at 24 hours notice. And a resolution was passed that that a lease will be taken of the 7th floor of an area of 1800 square feet on the 7th floor of Birla Buildings, which is owned by Birla Buildings Limited, a company belonging to the defendants group in the suit, testamentary suit, who are the Birlas, at a rent of something 70 lakhs per annum. And we also got we asked for a copy of the proposed lease agreement, where from it appears there is a lock-in period clause of 3 years, which makes all these investment companies liable for at least 3 years rent. They can't leave before that. So it involves a stake of 2 crores approximately, little more than 2 crores. So this is how it is in the interest of the estate. That's the question. Well, what we are opposing is that the APLs cannot or ought not to exercise their powers in such a manner as would deplete the estate of its money. 2 crores of money should not be spent, number 1. Number 2, the APLs, who are officers of the court, and the core estate, there's nothing to be secretive about. So their objection that they will take it out of Birla Corporation's portion and put it into the defendant's 7th floor is against the interest of the estate, and they cannot be secretive. Just because the division bench, they were unsuccessful thereafter continuously before every court. Now, that is why we immediately went to the vacation bench, because if they signed the lease deed, the estate would be saddled with a 2 crore liability. After all, estate is in medio, as has been held, and which is under the court's protection through the APLs. I have a right as the universal legatee enshrined under the Succession Act. Now, my lord, this is the factual background in which in a plain petition. There was an interim order was passed. Saying that that signing of the lease deed is stayed. They had taken they had appeared, even though there was no caveat, and taken the point of you should go to testamentary court. Why have you come to the suit court? Also taken the point that this relates to the company's internal affairs. So you should go to the NCLT under section 241. My immediate response there was the division. This is a decision of the board of directors of the 5 companies. The division bench has categorically held that there cannot be any order against third-party entities. So the testamentary court I cannot go to in order to ventilate and ask for orders against third-party entities. I also responded, Companies Act I can't go to because I'm not a shareholder. The shares are held by the APLs. I'm not a shareholder. I have an interest by virtue of Succession Act from the date of demise, but the legal right is still with the APLs. Now, this is the factual position, Lordship. I will the learned single judge felt that yes. One more point. The division bench judgment also provides that any major decision, according to the 3rd APL, should be testamentary court. The 3rd APL we have not been has been supporting the Birla's nominee so far. So according to us, this was also major decisions pertaining to the estate, and the 3rd APL and when Mr. Sharma referred this to by letter, wrote to the 3rd APL and all the others that this shouldn't have happened. He should have referred it to the court, testamentary court, taken the testamentary court's views before plunging ahead with the decision. So that was my other point. Now, but the court granted this interim order and directed that the matter should be should appear, and they should get a chance to make their proper.
What is your suit for?
The suit is for the suit is challenging the decision. Lordship sees the plaintiff press. The plaintiff is also there. Challenge the page 25 that the decision of the 5 companies boards to shift the office is bad. Not shift the office to take the new office is bad. On 7th floor is bad. Number 1. Number 2, injunction and no lease should be executed. Basically challenging the board of directors, 5 companies' decision to take the new office. So we have made the directors of all the 5 companies parties. We have made the APLs parties, the 5 companies parties, and also Birla Corporation Limited, in whose premises the present office is there, and Birla Birla Buildings Limited, with whom they propose. So that everybody is on record, whoever wants to say anything. So this is the position, the interim order is till today. Now that's why I had mentioned in the morning, and Lordship was kind enough to list it.
So all defendants are appearing.
We have served. Have we served all the
defendants? You are appearing for
10.
7.
8 and 10.
I'm appearing
8 and 10.
11 and 12.
I'm for 14. 14.
We served on all manner.
But I am the landlord.
Huh? Build a building.
Build the buildings.
No, Birla Corporation.
Landlord. Landlord.
Landlord.
Yes.
Oh, landlord.
So, Lordship, I'm seeking as an extension of interim order and the matter being heard by your.
How soon you file affidavit?
We'll file our affidavit, but I just want to show, can you look at the order, which was passed
Correct.
at my learned friend's instance.
It has not gone into anything.
Yes, it is not an order, under order 39.
Correct.
Maybe 151, maybe, but I don't think that order can survive. My learned friend will really have to argue his case to get an order. I have 3 submissions to make. At the first stage, will kindly say who's filed this suit. Are they related to the companies? According to them,
actual person is 3.
No, all the 3 are heirs of Mr. R.S. Lodha.
Yes, but he must have a cause of action so far as these companies are concerned. A company has taken a decision, or a set of companies have taken a decision that they want additional space. For that, they want to rent a portion of a building. With the greatest of respect, can a universal legatee, that's what he says in paragraph 35, come and say, no, I'm going to prevent the company from taking such a decision. That's exactly what they're asking for. Where's the cause of action which they have? Kindly look at their petition. Plaintiff also same thing has been said.
But anyway, then if they want to file the affidavit immediately.
No, otherwise, I'm saying today the order
then
is,
I shall have to argue fully.
Yes, because the order was only on the question that we are not going into merits. Do not execute the lease. My humble submission is this is not an order under order 39. He has to show what prima facie case he has, how the balance of convenience will be against him, and all those factors he has shown before he can obtain an interim order from my lord. Because interim order, the order, that's why in the morning I had made that submission and I did not kindly see for page 4 of the.
Yes. For the ends of justice.
No, before that, page 4 at the top, without assailing the oral submission, learned advocates representing both the parties and considering the documents in proper perspective, would not be prudent on the part of this court to form an opinion at this stage. Whether the execution lease by the respondent companies to detriment lawful petitioners fell within the ambit of major decision acted upon seeking appropriate orders from the testament cannot be decided at this stage without hearing both the parties being legally present. Learned advocates stop. For end of justice,
and to avoid further complications without considering the merits of the case. My lord, I'm sorry, my lord, but that, my lord, is, my lord, exactly, my lord, what, my lord, the law says you can't do. You'll have to consider what is the merits of the case before, my lord, an order is passed. So this order, my lord, with the greatest respect to the, my lord, to the learned judge, my lord, this order has ended. Today, my lord, we are on a fresh slate where, my lord, my learned friend has come upon notice to me to ask for an ad interim order. Because this order, my lord, cannot be of any assistance for him to come and say, please extend this order. Because it's not under Order 39, Rule 1 and 2. My lord, this is purely, my lord, if at all, under 151. And says, my lord, without consideration merits of the execution lease agreement, additional space is stayed till 4th November. No, no, why should, my lord, with the greatest of respect?
Well, but then if they're not willing to file affidavit, that
No, not willing. It's a question of, my lord, he has to, my lord, first, my lord, satisfy the court that he has made out a cause for obtaining an ad interim order.
No, Mr. Banerjee is objecting that this order cannot be.
Very well,
extended.
then I can make my submission.
He has to make a submission.
Lordship, yes.
Well,
very well.
We can file an affidavit, but, my lord, I'm opposing, my lord, any ad interim order because, my lord, I think, my lord, it is really cutting into, my lord, the question of management of, my lord, company.
Cannot be any urgency in executing the lease and saddling the estate with 2 crores liability. And also taking away records. Very well, Lordship, may then? Lordship may start with the division bench judgment to show. Kindly come to page in volume 2, page 162 is the division bench judgment. It starts at page 162. Paragraph 2 and 3 কোন page আছে? Yes. 162 is the division bench judgment. Now, Lordship, kindly come to paragraph 213 of this judgment, for which Lordship has to go to volume 4. Volume 4, page 458. It's really a 2-volume judgment, my lord. 458.
Yes.
Paragraph 213. The steps taken by the APL in registering its nominees as members of the companies where the deceased testatrix held shares in consonance with and in the ratio of the shareholding rights of PDB in each of such companies perfectly justified in law. The APL through its nominees may very well decide which way the votes of the testatrix's shares should go and how they would exercise their voting rights and election of directors. May I pause here for a moment? I've given here the earlier entire board was replaced by the new board nominated by 2 of the 3 APLs. Next sentence. The nominees as such shareholder, that is representing the estate, may participate in the shareholders meeting and decision making process of the tier 1 companies and thus mold the course of action and business decisions of such companies. Since the said tier 1 companies are also shareholders of other companies in the secondary and tertiary tiers, the APL through its nominees may also decide how to go about asserting the interests of the estate of PDB in the secondary and tertiary companies through the tier 1 company. So the tier 1 companies being under the direct control of the estate and APLs having fully replaced the board, it is the obligation of APLs to ensure that that these companies' decisions are in the interest of the estate of PDB. So let's leave in asserting the interests of the estate of PDB. With this being the position, and also by law is recognized that majority shareholder has control over the company, over its management fully. That's Vodafone and several judgments. So the court has recognized that, and so the decision, so these 5 companies not having independent business should be managed by the APLs through the APLs nominees in the interest of the estate. Now, my lord, I have come here as the universal legatee. Lordship may recall, this will has been placed again and again. by the will, the entire estate was vested in Mr. R.S. Lodha. Now, that R.S. Lodha died in the year 2008. Now, so comes into operation Section 104 of the Succession Act. Section. We also have an extra copy. Section 104.
Yes.
If a legacy is given in general terms without specifying the time when it is to be paid, this is like here, not deferred. The legatee has a vested interest in it.
Section
104. 104. Time of vesting legacy in general terms.
Yes.
If a legacy is given in general terms, like here, not deferred, without specifying the time when it is to be paid, the legatee has a vested interest in it from the day of the death of the testator. And if he dies without having received it, it shall pass to his representatives. So that interest has passed on to the 3 children of Mr. R.S. Lodha, who died intestate. Meenakshi Periwal, the daughter, Aditya Lodha, and Harshvardhan Lodha.
Yes.
Harshvardhan Lodha has been mainly conducting the litigation, but on all the proceedings, it is the 3 of them who are representing the estate. In fact, in the probate proceeding also, so all 3 have been substituted upon theirs.
So the will is in question before the
The will is under question.
So why the separate suit?
Separate suit, Lordship. Lordship kindly suit. Now this is the decision of the 5 companies at a board meeting held on 23rd of December to take on lease. So I need an order against these 5 companies. No, not to take on lease. These companies being an extension of the estate by virtue of the majority shareholding.
But you are relying on the will.
Lordship kindly comes to page 394 of this same judgment. This came up in issue. What is the scope of the testamentary proceeding?
Page
394, volume 3. 394, paragraph 108. What is the testamentary court's powers? Paragraph 108.
Correct.
The learned senior advocate appearing for the respondents had relied upon several decisions of the Honorable Supreme Court as well as other high courts to support their contention that the injunction can be granted by the probate court. On going through the facts of each of these cases, we find that in all those cases, the orders of injunction were granted pending appointment of appeal, which was in the light of the judgment of the division bench of this court in Otulawala. Thus, having taken note of the above legal position, the next issue should be considered under this head is whether the probate court can pass orders against the third party. We need not labor much on this issue, as the learned single judge has rightly noted the proposition of law in this issue and held that the companies not being parties, they are not amenable to the jurisdiction of the probate court. While considering whether companies can be joined as party defendants, the court held that the noticee companies can neither be joined as a party defendant, nor can any order of restraint be passed against such companies who are not a party to the proceeding. Further, the court held that it cannot extend its jurisdiction to a person who is not a party to the present proceeding.
Yes.
Further, held that noticee companies are not parties, no order can be passed against it. Now, this was upheld by division bench. So, here, my lord, since the decision legally, I mean, in the eye of on the records is taken by the board of directors, as I will show just now. We had no option but to file. Otherwise, why should we unnecessarily file a second suit, making fire? But then here we need orders against the 5 companies. And by abundant caution, we have also implemented their directors, who are presently the nominees, because they should also be. So that's why I have come to court. Now, this is in this factual background, we have come to court asking for orders which are in the interest of the estate. Now, Lordship kindly sees in the Rent kota bola ache, rent koto hoche na?
No, if the companies are taking the premises on lease or rent, whatever it is, how you will be prejudiced?
Two reasons, Lordship. Two reasons, my lord. These companies, as I said, is an extension of the estate. Now I will show from the APS minutes also, decisions also, and as I showed from paragraph 213, everything regarding these companies, all decisions should be in the interest of the estate. Now, Lordship, these companies,
Page 6, para 6.
now in this, Lordship, kindly comes to page 7 of the petition. কোথায় বলা আছে নতুন ভাড়াটা কত? Lordship, kindly come to page 6, paragraph 6. The said companies, page 6, paragraph 6.
Yes.
The said companies, that is those 5 tier 1 level companies, the said companies at all material times have occupied a portion of the east block of the 4th floor of Birla building, which as stated earlier is owned by Birla Corporation Limited. On record, the tenants are the respondent numbers 8, 9, and 11, but the offices of the other 2 companies, that is respondent numbers 10 and 12, and in fact, all their registered offices are also situated in the same portion of the Birla building. This is the position since prior to the demise of Premvara Birla, which would also be corroborated by the returns and records filed by the said company with the registrar of company. The total rent that is paid for the offices on the 4th floor of this 189 is 69,300 per annum till March 2024. In fact, it's been paid up to March 25 also, as per particulars given here and below. So indirectly, the estate's expenditure is 69,000 per annum on these 3 properties, just to have basically the company registered office on the 4th floor. Now, Lordship kindly comes to paragraph to page 20, paragraph 24. The respondent number 7, by email dated 25th October 24, copy whereof is annexed here and so, had informed the petitioners and the other parties to the testamentary suit of a decision taken by the board of directors of the said companies to enter into a lease agreement with Birla Buildings, in terms whereof the said companies are to acquire leasehold rights with respect to space and measuring 1852 square feet, situated at the eastern block of the 7th floor in Birla Building at an exorbitant rent of rupees 4,93,000 per month, with increase of lease rent at a rate of 15% per annum after expiry of 3 years. There is also a proposal to be subject deposit of rupees 11 lakhs. Apart therefrom, the expenses for interior work, furnishing, etc. of the entire area is expected to cost in the range of 75 lakhs, to be shared by the 3 companies. So that's why I've said it's well low. So 2.5, with the 3 years lock-in period, there has to be initial outlay of 2.5 crores. Is it in the interest of the estate? Now, going back to page, I'm just reading out that one line from the judgment of the division bench regarding the business of these companies. Since the tier 1 companies also shareholders of other companies in the second and tertiary tiers, the APL through its nominees, that is page 459, the division bench judgment, volume 4, page 459. Yeah. Second line from top. Since the tier 1 companies are also shareholders of other companies, secondary and tertiary tiers, APL through its nominees, that is the directors, may also decide how to go about asserting the interests of the estate of PDB in the second and tertiary. So the interest, and even otherwise, Lordship, whatever these companies' dividends are coming, the entire share, I mean, since the majority shares are with the estate, the income of this company will be inuring to the benefit of the estate, because it will be coming to shareholders ultimately. So these companies' decisions should be guided by the interest of the estate, because these companies, if they're showing to deplete the money, they earn to 10 crores of dividend every year. if they spend for 5 crores on donation, and I come and object, they can't come and say, who are you to object? I don't know, these are the company's income which is being being donated or used for some function, some celebration. So when the date when the probate is granted and my legal
What is the purpose for taking out the premises on lease?
that's the whole issue. That is the whole issue. Whether now this is what is required. After all, this is these companies. Lordship kindly sees the company's accounts. The companies have no business, but for earning dividends and interest, they have no running business. They have a meager staff for the secretarial practices. Now, Lordship kindly comes to the decision or to the communication of one of the appeals, that is page 961, last volume. This is what has given me the cause of action. Page 961. Page, yes. Last volume. Volume 7. This is APL's letter to one APL and to the other APLs. 961. 25th October 2024. MK Sharma, who's respondent number 7. Subject objection. May I read out? This is addressed to the third APL. Mrs. Shah.
Yes.
I refer to the board meetings of Gwalior, Webbing and East India held on 23rd October, where your good self and Mr. A.C. Chakraborty were also present as directors. An agenda note was circulated approximately 24 hours ahead of the meeting about a significant proposal to lease additional space of 1852 square feet situated at the East Figure 7th floor in Birla building. An exorbitant rent of is 4,93,000 plus. Next paragraph. To my specific query, whether the companies will vacate the premises made available by Birla Corporation, it was clarified by A.C. Chakraborty that it is intended to retain the space of Birla Corporation and the new lease will be over and above the space currently available. There has not been any material change in the size and scale of operations or number of staff members which may warrant leasing additional space. It appears to me to be a clever attempt on the part of the majority of the board members, including 2 of the 3 APLs, who are aligned to Birla's, the opposite parties, to put them with funds for ulterior motives to enable them to pursue diverse litigation. I also stated at the board meeting that there were no competitive codes or benchmark used to determine the fairness of rent and revisions, even if there was justification for it. I have therefore, for a aforesaid reason, dissented from the proposed resolution. In my respectful submission, shifting of office, registered office of the company to the place belonging to the rival Birla Group is a clear attempt to hijack the investment companies and take the said companies out of the fold of MP Birla Group. There is no cogent reason given by the board, notably the 2 joint APLs, for shifting the registered office of the investment companies which have been operating from the 4th floor of the building of the Birla building for the last several decades, spanning the lifetime of MP Birla and Mrs. Birla at a very nominal rent, permissive usage basis. This also goes against the customary norms of functioning and operation of the said investment companies and are per se despotic and unwarranted. The only reason for the purported relocation of the registered office has been that our employees are feeling threatened, which is ex facie false, concocted and misleading. There has been no complaint of any threat of any kind in the past, which has ever come or been brought to the notice of the joint APLs. Even the office of the joint APLs is functioning from the 4th floor of the Birla buildings. Mr. P.S. Nair, the manager to Birla, secretary to the committee to the joint APL, is also an employee on the payroll of one of the investment companies, has been attending his duties and sitting in the same floor. Have never complained of any kind of threat or pressure created on him from any quarter. Taking on rent the office space at an exorbitant rate and spending of ₹70 lakhs plus for renovation of the space at the cost of the investment company is a wasteful expenditure and will definitely amount to depletion and dissipation of the estate of the assets of Birla. Considering the fact that the 2 joint APLs are claiming at the investment companies to be part of the estate, The two joint APLs have already squandered several crores in contesting litigation from the funds of some of the investment companies to support the cause of defendants in the testamentary suit. The two joint APLs are also treating Birla Corporation Limited to be part of the estate of Priyamba Devi Birla, which is incorrect. Then why the two joint APLs are shifting the office of the investment companies from the space belonging to Birla Corporation to the space belonging to the rival Birla Group? The impugned decision of the investment companies of relocation of the registered office at the behest of two joint APLs and board members aligned with them is completely illogical, irrational, and capricious, and has no basis. Obviously, such decision attempted to be effected to enable Shil Kumar Daga and Mr. Krishna Damani to carry out their illegal activity. They are both subject matter of investigation in the South Point case, who have been accused of siphoning funds belonging to not-for-profit society. This is a concerted attempt to disintegrate the MP Birla Group, which is neither in interest of the investment companies nor the estate of Priyamba Devi Birla. Before exercising the rights as directors of the investment companies, which the two joint APs are claiming to be part of the estate, the shifting of the registered office of the investment company should have been discussed and deliberated in the meeting of the joint APLs. Surprisingly, without prior discussion and or intimation in the meeting of the joint APLs, the decision has been taken at the behest of the other two APLs clandestinely, though the two APLs are claiming the investment companies to be part of the estate of Priyamba Devi Birla. Before concluding, may I submit that we may have fuller discussion and debate on the basic issues raised by me, and in the meanwhile, we put the proposal on hold, since the lease, if signed, has 3-year lock-in and would entail huge cash outflow. So this was the objection raised by an officer of the court, who is as much an officer as the respondent numbers 5 and 6, who are the two other officers. And why? During the vacation in tearing hurry. During the vacation, so that you could not come to court easily. In fact, taking leave was an arduous task in the morning to convince the learned judge to take up the matter. Okay, give me 1 second. This office space, which the company has always, which the companies have always had, the lease rent is paid up to 2025. And at least on record, at least to my knowledge, Birla Corporation can say whether they have received any complaint regarding the employees being threatened. And the APL estates office is also on the 4th floor, where the 3 APL's secretary, Mr. Nair, sits there.
Yes.
So what is the tearing hurry to shift this office? And especially, yes, Lordship, if it is the APL's decision and one of the APLs bring it to the notice of the 3rd APL saying that he is dissenting, and this I will show from the affidavit of assets, this is the prime asset of the estate. I will show the Birla's probate petition, which has also been filed regarding to an earlier will which has not seen the light of the day. They have valued the estate stake.
Page 65.
Lordship, kindly may I just show page 65. Lordship, kindly sees page 65. This is the affidavit of assets, page 65, volume 1.
Yes.
Lordship kindly sees the page 65, it starts. This is the affidavit of Ganga Prasad Birla's Kashina Tapadia so and so in their probate proceeding. The total assets are valued at rupees 2,404 crores, page 70. Typed page 70. 2,400 crores. Out of which, Lordship kindly sees these 5 companies' valuation, Lordship kindly comes to page 68. কোন পাঁচটা?
উপরে পাঁচটা ইস্ট
তা
ইন্ডিয়া
তারপরে এগুলো নয়। But she kindly sees the 5 investment companies. A, East India Investment, 33,000 shares, 1,656 crores. Gwalior Webbing, 743 crores. Then
পাঞ্জাব প্রডিউস এম
কোথায়?
এম পাঞ্জাব
M, Punjab Produce, 2 crore. Lordship. So 2 of the companies where the estate directly holds majority shares, and through this A and B, East India and Gwalior, the other 3 companies are held, are valued at over 2.3 crores. 1,600 plus 743, 2.4. Almost the entire value of the estate is the estate stake in these two companies through which the other 3 companies are held. That is 2,400 crores is value of these 2, and the balance is 4 crores only. Balance estate is 4 crores. 2,400 crores they have attributed as the value of the estate is in these 2 companies through which the other 3 are held. So this is the core estate, and what is the estate stake? That is 30. That is the shareholding majority share. And today they stand up and say these are separate companies.
Where is the email?
The email 961. They are separate company. They have nothing to do with the estate.
No, 961 is your objection.
No, this is the MK Sharma's.
My email. Email. But what you have received? How you got the information?
This is from the email at page 961, which is given by Mr. Abdul Mojumdar's client to the other 2 APLs and to all the companies and the 2 sides advocates, Mr. Devanjan Mandal, then Krishna Damani and everybody. Also Harsh Lodha. Even Khaitan and company also.
Yes.
So this is the 2,400 out of 2,404 crores estate is the stake in these companies. So if these companies are depleted, then now Lordship, apart from the division bench judgment, which casts an obligation on the APL and its nominees to manage these companies in the interest of the estate, the APLs themselves, in several decisions, have treated these 5 companies as part of the estate. And the APL's nominees who are on the board of these companies are now standing up and saying, because they are represented by the board of directors, that they have got nothing to do with the estate. Now she kindly comes to page 511. 15th June, page 511 first. The APL's nominees are saying that we have got nothing to do with the estate. We are an independent organization. 511. Lordship, this is the decision starts 15, 16 June. Kindly come to 531, paragraph 38. 531, paragraph 38.
Yes.
Paragraph 38. Having considered all the relevant facts and circumstances, and having considered that the major part of the estate of late P.D. Birla consists of direct and indirect shareholding through chain and cross-chain holdings in various companies, controlling interest in MP Birla Group companies, particularly with the companies with the percentage of shareholding set out in the chart annexed to this decision. APL committees of the considered view that during the pendency of the probate proceeding before the Calcutta High Court in respect to the estate of late P.D. Birla, it is necessary to protect for the protection and preservation of the estate of P.D. Birla to see that A, all 3 members of APL committee are nominated as directors on board of these 5 companies. There can be no dispute that the estate of late P.D. Birla is directly or indirectly majority shareholding on all the 5 companies, and APL committee will get weightage on the board. This will also ensure that in case, say, Mohit Shah is unable to attend, APL committee does not get does not go unrepresented. Lordship, may for a moment's aside, kindly come to page 512 here. For a moment's aside, page 512, paragraph 3. Mr. So-and-so senior advocate. So the famous man is sitting next to me. So that was his stand, which was accepted by the APL, and this was the decision. Kindly move on to the next decision, page 536. At 573, the APLs have treated these companies, their affairs as part of the estate.
573.
536, it starts at 573. Or 572 at the bottom. Last 3 lines of 572. This is regarding the significant beneficial interest.
Yes.
Last 3, late Mrs. P.D. Birla would thus be qualified for making a declaration in terms of 91 qua the 3 companies mentioned above, in which she held 10% or more shareholding, directly or indirectly, together with direct holding in terms of Rule 21H. Details of share, Lordship will see how the APL treat East India Investment. APL is treating 99.97% as held by the estate. Of course, to that extent, only 72% has been is legally, and 8.97 through Gwalior, and so basically 99. Then Gwalior may be 100%. Third company, Baroda Agents, para 43, 100%. Punjab Produce, page 574, 100%. And Punjab Produce Trading, the Punjab Produce Holding, 100% according to these APLs. And now their nominees stand up and say, we are independent, separate. Lordship kindly comes to next is 23rd October 2020, page 621. This is extract from the 23rd October 2020 minutes.
Yes.
This is extract from the minutes of the meeting of the APL committee held on in August. Item 6B, the committee discussed at length whether permanent chairman should be appointed for 5 investment companies. Since Mohit Shah expressed the view that he has no academic or practical experience to finance accounts, investments, and that having regard to the fact that the 5 investment companies are in tiers 1 and 2, over which they will have undoubted control over the majority shareholding in 5 companies, there should be a chairman for all the 5 investment companies having the necessary experience. APL is deciding. Kindly turn the page to the next minutes of the internal meeting of the APL committee held on 23rd October 2020. 1. At the last meeting of the APL committee held on 8th October 2020, it was decided to hold the next meeting of 23rd October. In the meantime, pursuant to the request of all 3 members of APL committee, who are also directors on the board of investment companies in the MP Birla Group, board meetings of 5 investment companies held on 8th October. Mohit Shah attended the board meeting of all the 5 investment companies, and Mr. A.C. Chakraborty and Mr. M.K. Sharma attended the board meetings of East India and Gwalior. Both the companies in which estate directly hold majority shares, these 2 companies directly holding majority shares in Baroda Estates, which in turn, along with PDB Estate, which in turn, along with PDB and Gwalior, hold majority shares in the 5 companies. Then Lordship kindly comes to 623. Next page. This is a letter written on 23rd December 21 by the 5 companies. Lordship sees the email of 23rd December 21 by Chaudhary Law Office. By Chaudhary Law Office representing our clients East India, Gwalior, Baroda. And see first paragraph. As you are aware, since the lifetime of late Mr. MP Birla, the founder of and promoter of the MP Birla Group, the in-house direct tax department of the MP Birla Group dealing with and handling direct tax matters of all entities within the MP Birla Group, including our clients, has been operating from the headquarters of the MP Birla Group located at Birla Building 9/1, Mukherjee, 3rd and 4th floor. So this is personnel working in the said department and handling affairs in the said department have been on the payrolls of different entities, including some of our clients, and most of them have always been on the payroll of Birla Corporation, Mr. Bachawa's client, being the flagship company of the MP Birla Group. Now, Lord, you kindly sees the 5th paragraph. This department has been responsible and handling all matters pertaining to direct tax laws such as advance tax, filing of income tax returns, assessment by the assessing officers, filing of appeals before CIT, and all other incidental matters of all the investment companies, including our clients, trusts and societies and above, that of Birla Corporation Limited under other manufacturing. Now, why do they want to separate from this? After all, they are representing the estate, the 3 APLs and their nominee directors. Why do they want to take it out of this fold? In 2021, December also, they have asserted this stand. Is it because the division bench has gone against their stand? Is it because Sarkar has gone against them? I am asking myself this question. Why suddenly this sudden fear that they feel threatened? They've never felt threatened. There's a single complaint from any employee that I'm being threatened by somebody.
Yes.
And saddling the estate with 2 crores a year, I mean, with 69 lakhs plus the renovation costs, 2 crores. And saying I'm an independent company, my internal affairs. Now, Lordship, kindly, and they are not, and there's so much of a hurry, and without filing an affidavit and explaining why they want to shift the companies, why they want to have this new office taken on the 7th floor. They don't want such a hurry that the office, it has to be signed immediately. They can't wait for affidavits. Now, Lordship, kindly see the accounts. Though it's on record that they're little business, kindly come to page 650. 650. Huh? Yes, Lordship, my junior rightly points out, Lordship, kindly sees page 628. Absolutely right. I should have pointed this out, 628. Before the 2 of the APLs had gone to the NCLT unsuccessfully. They've lost all the way, trying to stop some appointment of directors. Kindly see how they filed the petition. 628. The committee of the first petitioner is the Committee of Administrative Penalty of Priyambade Birla through Justice Shah and Mr. A.C. Chakrabarti, majority members, jointly with Punjab Produce, one of the 5 companies, jointly with Punjab Produce. So now Lordship sees the accounts of these companies. Page 649 is the East India's. Kindly come to 650. What is the company's income is in thousands? What 11 something 582.51. Out of this, revenue from operations is scheduled is note number 12, and other income is 13. Kindly turns the page to 652. What is the income? Note 12, note 13. Dividend income. Page 652. This is the schedule where note 12 and note 3 are given.
Yes.
On non-current investment, dividend income, gain on sale of investments, current So 11,000 crores plus and note 13 is the other income is income on income tax refund. This is the only income is dividend and next company lordship page 653 Gwalior Webbing.
My employee nahi, salaries and wages.
Yes, lordship, my junior rightly points out. President, yes.
1,000. Yes, salaries and wages.
Lordship, salaries and wages. 3,43,000 is the total salaries and wages. Note number 14, employees expenditure. The total whole year's in salary expenditure 3.43 lakh. Company has no business. Lordship sees the one more. I will not show more than that. 653 is Gwalior Webbing. At 654 is the income given in the profit and loss account. Income is note 16 and note 17, 142 something. What is note 16, note 17? Lordship kindly comes to page 656. What is the revenue from operations? Note 16. Dividend income. 66. From tax-free bond.
Page
656, note 16.
Yes.
That is the income. Note 16 is the dividend. Note 16, revenue from operations is dividend income and interest income. This is the companies do not suddenly, after so many years, all of a sudden need additional space for which they have to incur the estate's money, I'm saying, because it's the estate's income. Now, Lordship kindly sees they had relied upon when at the opening submission that the APLs are not to interfere, not to interfere in the company's affairs. Going back to page 4, volume 4, page 458. Or page 457. This is the core of the judgment, 211 to 213. The core of the division bearing judgment.
Yes.
Kindly sees page 211. We are required to distinguish here between the rights directly flowing from and incidental to such ownership of shares and those which are remotely derivative from such ownership and not proximate. The former are subject matters of the estate and the APL can exercise those, but the latter, remotely derivative rights, cannot be thrust by the testamentary court or the APL on the respective companies, which are independent juristic entities. We are not deciding any legality or irregularity of the said company's affairs. Thus, the concept of lifting the corporate will doesn't apply. The rights of the testatrix over the companies of the different tiers were coextensive with the rights as the owner of the shares of the tier 1 companies. Tier 1 companies are a different category, and the incidentality with the rights of those companies as shareholders. The APL thus cannot interfere with the internal affairs of the companies of all the tiers with the blessings of the testamentary court. There cannot be any universal or dynamic injunction or direction affecting the future course of action of the companies from the testamentary court, simply because the testatrix could not have herself had taken any such action in law. 213, the steps taken by the APL in registering its nominees, which I had placed earlier, of the companies which perfectly justified, and they should the fourth line of paragraph 213, the APL through its nominees may very well decide which way the votes of the district should go and how they would exercise their voting rights in election of directors. And the nominees as such shareholders may participate in shareholders meeting and decision-making process of the tier 1 company, decision-making process of the tier 1 companies, and thus mold the course of action and business of such companies.
Yes.
That is why, my submission is, and incidentally, I must also show that কোথায় majority
ওই যে কোর্টে যেতে হবে তো
yes
3 জায়গায় আছে
217
তার আগে
217 issue 3II Thus, the very composition of the APL brews conflict of interest since two of the members represent the two warring factions and have left no stone unturned.
217 para 5.
Well, no, sorry, I'm missing, but page 460, para 217, page 460. দেবার তো সব ভুলে দেওয়া Paragraph 217.
Yes.
Issue 3II, the very composition of the APL brews conflict of interest since two of the members represent the two warring factions and have left no stone unturned to show their true colors in that regard. Thus, in view of the discussion above, the only way in which the APL can function effectively is for the third member, who is necessarily retired nominated judge, to act as arbiter in case of conflict of decision between the two members of the APL. In case there is no resolution, third member shall exercise veto power. In case of major decision, which the decisions are major for this purpose, shall be decided by the third member. The APL may seek appropriate orders from the testamentary court. According to one of my submissions, is that this is a decision because this relates to the core asset of the estate, where the records will be kept, where the office will be, and how the money will be spent. Is one of the major decisions, and the third member, upon receiving the letter of Mr. M.K. Sharma, mail, should have taken leave of the testamentary court, or the decision of the third member not to come to court for the appropriate orders from testamentary court is. And Lordship, the next line, the APL must also keep in mind that it is not an adjudicating authority, but merely representative of the estate of the deceased entity. So they should have acted in the interest of the estate and not gone ahead with this. Now, Lordship, no order against third parties I had shown. Anything else? Yes, Lordship, the board was changed completely. That I will show that the full chart is given. The board that was there before that has been replaced by the nominees of the, because the two APLs to page 15. Paragraph 17 of the petition, page 15.
Yes.
This is, we have given a chart showing each company wise what was the composition before the illegal reconstitution by the two APLs according to us.
Yes.
Justice Shah, East India Investment, Justice Shah, Mr. Sharma, Mr. A.C. Chakravarti was there earlier, and there was Harsh Lodha, Pracheta Majumdar, Krishnan Damani. Krishnan Damani is the one who has turned rogue, who was behind bars for 3 months. Now, the present board, Harsh Lodha is removed, Pracheta Majumdar is removed. Nominees appointed. Same with Gwalior Webbing.
When it was appointed?
This was all happened when the appeal was pending, 2020 sometime. The division bench judgment is
December 2023.
Yes.
14th December.
That is 23.
Yes. So this happened during the pendency of the appeal. Lordship, each company, Lordship, will find the board has been, wherever Harsh Lodha was the director, he has been removed, and other old directors like Shardul Singh Jain, Ravindra Pratap Singh, and new. So the entire board is now the nominees of the majority of the APS because they have the majority powers. So this is the position, Lordship. So in my humble submission, anything else?
shareholder now only 244 waiver.
Yes, well,
This point-
in case they argue that I have to go under 430, then I shall respond. It is too early that being a non-member, I can't go and take 244 leave and go to NCLT. So NCLT is ruled out because an argument was made at on the first day that section 430 excludes the civil court jurisdiction because I can go under 241. 241 for operation mismanagement, how the company. 241 can be filed by only 10% or less, but not a non-member. Say if these three persons had one share also, they could have asked for leave.
Let us see whether they are
Let us
taking that.
So,
clearly.
this is my submission. They should explain on affidavit why these companies need to spend so much of the money, since they are now represented by the directors nominated by the APL.
Yeah.
Look, the gist of my learned friend's submission, my lord, would be. If
You are for the defend number?
Sorry, my lord, I'm for defend numbers 8 and 10. Two of the companies, my lord, out of this, my lord, groups.
Yes.
So, my lord, the gist of my learned friend's submission, my lord, legally would be that, my lord, he is asking, he is, my lord, maybe a shareholder of these companies, not a shareholder, maybe shareholders of the companies who comes to a civil court and says that please overturn the decision of the board of directors of, my lord, all these 5 incorporate companies. Because, my lord, as we know, my lord, a company, my lord, is managed by its board of directors. Here, my lord, we are not on the APL issue. I'll come address that, my lord, very shortly. So, my lord, he is saying, I may be a possible shareholder if I win the case of the will. And if I win, then I'll be shareholder. Now, I'm not a shareholder, but I want the civil court. My lord, it's not a question of, my lord, one decision. It may be tomorrow anything. Question is, my lord, whether the civil court will permit a challenge like this to be entertained at all. I'm on the question of, my lord, the threshold entry of this kind of, my lord, a plaintiff. So this is, my lord, the legal principle which really, my lord, the civil court, my lord, today has to address. So we'll have to, my lord, leave aside, my lord, the provisions of the Companies Act which says no, board of directors are supreme. They will really manage the company. They will take decisions. We will have to leave aside, my lord, section 430. We will have to leave aside everything and say no, because you say that you claim that you might be a shareholder under a will, the court has to entertain. Now, my lord, I am a little confused, my lord, with my learned friend's suit and, my lord, his arguments. At one breath, he, my lord, shows a complaint made by a third APL member. And repeatedly went on saying, I'm trying to protect the interest of the estate. Now, my lord, as far as I understand, protection of the interest of the estate has to be before the probate court. No civil suit will lie to come and say that either I'm espousing the cause of one of the APL members or I'm asking for protection of the estate of the deceased, because we are on general principles. Let's not, my lord, have in this Billah, Lodha, my lord, we'll be getting into, my lord, a question, my lord, which is really, my lord, a lot of litigation has come. So if his complaint is I want to protect the estate, then, my lord, he has to go to, my lord, the probate court. If he says he is carrying out the complaint which has been made by one of the APL members, then also the probate court.
How? As per the order of the division bench?
Well, what he cannot do directly, he also cannot do indirectly. The division bench has not said that because I'm saying in the probate court, I cannot look after I cannot interfere with third-party interest companies, means the APL and the universal legatee will have a right then to come and say that, no, I want to challenge all the decisions of the board. Because in Mulad will find in the division bench order, Mulad, we are also agreed by the division bench order. But his contention, his Mulad, when I say his Mulad, all the 3 of them Mulad were parties, their contention was that no, you cannot interfere with the affairs of companies. And that is what, if Mulad comes back to Mulad, the division bench order, just to show Mulad where we stand, because Mulad, these are all kindly Mulad come to page Mulad
Not from 450.
457.
457. Yes, absolutely. Absolutely, Malad. 210 paragraph 2. I'm sure Malad has considered this judgment, Malad, in other matters also. That's what I'm told, Malad. The answer to this issue lies embedded in the previous issues. We cannot but be a bit conservative here. APL steps into the shoes of the deceased testatrix, nothing more, nothing less. So APL steps into the shoes.
Correct.
Thus, it cannot exercise powers which the testatrix herself did not have during her lifetime. PDB was the owner of certain specific shares in some of the companies. Such capacity of shareholders shared all incidental rights, voting rights, decision-making powers, ownership of shares, rights directly incidental thereto, and heritable rights which devolve upon her estate on a demise. But her personal charisma, authority, and influence asserted over shareholders' management, if not heritable and not property, cannot be the subject matter of estate and consequently under the adjoining authority of testamentary court. In fact, Malad, we had argued, Malad, to the contrary. We're saying, yes, not the personal charisma, but Malad, the estate was larger. That's Malad, what our argument was. We are required to distinguish here between the rights directly flowing from an incidental to such ownership of shares, those which are remotely derivative from such ownership and not proximate. Former are subject matter, the former are subject matters of the estate and the APL can exercise those, but the latter remotely derivative cannot be thrust by the testamentary court or the APL on the respective companies, which are independent juristic entities. We are not deciding any legality or irregularity of such companies' affairs. Thus, the concept of lifting the corporate wealth does not apply. The rights of the testatrix over the companies of the different tiers were coextensive with the rights as owners of the shares of the tier 1 companies and incidentally with the rights of those companies as shareholders of the other companies. So they are successful in preventing the expansion of the estate by saying that these are restricted to the shares. That doesn't mean that they will have as universal legatees or as one of the APL members to come and say, I can file a civil suit. Correct. Because you must have a right to try and say that. Then 212. The APL thus cannot interfere with all the internal affairs of the companies of all the tiers with the blessings of the testamentary court. There cannot be a universal or dynamic injunction or direction affecting the future course of action of the companies from the testamentary court simply because the testatrix could not herself have taken any such action law. Steps taken by the APL in regard to its nominees as members of the companies where the deceased testatrix held shares in consonant with and in the ratio of the shareholding rights of PDB in each of such companies is perfectly justified in law. APL, through its nominees, may very well decide which way the votes of the testatrix share should go and how they would exercise their voting rights and election of directors. The nominees as such shareholders may participate in shareholder meetings and decision-making process of the tier 1 companies and thus mold the course of action and business decision of such companies. Since the said tier 1 companies are also shareholder of other companies, secondary and tertiary tiers, APL through its nominee may also decide how to go about asserting the interest of the estate of the PDB in the secondary and tertiary tier companies through the tier 1 companies' actions as shareholders of the latter companies. Yes. Then, however, such process can only be done in the above board and legal manner and due process of law. APL, for example, cannot jump steps to directly take or preempt business decisions in respect of the tertiary tier companies without going through the process of first taking decision in the first tier companies and getting its decision approved through the representation of the first tier companies shareholders in the lower tier companies. So as and when any immediate decision is required to be taken regarding transaction transfer shares themselves, the APL mandatorily has to approach the testamentary court for necessary orders. Then, what is major is also left, to the third, member. Also, the APL itself being the repository of interest of the estate of the representative testamentary court shall have to take appropriate directions, orders, testamentary court prior to initiating or contesting litigation. However, day-to-day decisions, every stage of such litigation need not be sought from the court, which would be unnecessary burden on the court and would put an unwarranted spanner in the wheels of the APL. Yeah. Then 3I is very important because it talks about, kindly see this is also very important. Functions. Very composition of the APL brews conflict of interest since two of the members represent the two warring factions and have left no stone unturned to show their true colors in that regard. Thus, in view of the discussion above, the only way in which the APL can function effectively is for the third member, who is necessarily a retired nominated judge, to act as arbiter in case of conflict of decision between the other two members of the APL. In case there is no resolution, third member shall exercise veto power. In case of major decision, which decision the major for this purpose shall be decided by the third member. The APL may seek appropriate orders from the testamentary court. APL must also keep in mind that it is not an adjudicatory, but merely representative of the estate of the deceased testatrix. Now, my lord, therefore, my lord, let us understand, my lord, what this cause of action is. My lord, first of all, my lord, the universal legatee here, that's what he claims himself to be. Paragraph 35 of the petition I'll show. Cannot have, my lord, any right in respect of the estate now because it is being protected by the APL.
Yes.
If he has to make a complaint, he has to really go to the testamentary court. Because he will not have an independent right to file a civil suit to come and agitate this issue.
Yes.
Till, my lord, this order stands. And that was their stand. Then come also, my lord, please come back, my lord, again to my lord, paragraph 213. The steps taken by the APL in registering its nominees as members of the companies where the deceased testatrix held shares in consonant with and in ratio of the shareholding of between each other is perfectly justified in law.
Yes.
So the board is there. So far as tier 1 company is concerned, my lord, I found my learned friend making arguments. Oh, now they are saying independent. Well, where's the question of independence? The issue is not here.
Correct.
Issue is, my lord, there is a board. And he says illegally constituted board. I have not understood that also. Issue is, my lord, there's a board of directors of the company who have decided in their commercial wisdom that they have one floor office, and which my learned friend has also not pointed out because, my lord, there's a larger, my lord, conflict and, my lord, interest in this because, my lord, the Birla Corporation Limited, my lord, lease has actually expired on 31st March 2024. And very well, my lord, it has been camouflaged, my lord, in this petition itself. So these companies wanted renewal. The formal no agreement has been entered into. They have obviously, my lord, which, my lord, any tenant will do, gone and deposited the rent. Now, leave that aside. Today, my lord, the board's decision is we want additional space for our working.
Yes.
It is as regular a decision like that.
Yes.
The APL members are, my lord, part of the board. Now, if one APL member has a grievance, then, my lord, the division bench order says, I'm sorry, your grievance will have to be subjected to majority decision.
Correct.
Quite naturally, my lord, the majority is not supporting, majority has not said anything. Now, if again there was a grievance by the APL member, he would have to go, my lord, to the testamentary court.
That decision has not been challenged by any of the board of directors.
Correct. My lord, which decision, my lord? The
board decision which
yes, because in this suit, correct. Absolutely.
Because as per the letter issued by the R7, the plaintiff has taken the suit.
Yes.
Taken out the suit.
Yes.
But the decision taken by the board members are intact.
That's the challenge here.
They have challenged.
Yes, they have challenged.
That is intact.
Correct.
Board of directors who have participated in
Yes,
the meeting,
yes.
they have not
No.
challenged.
No. Absolutely. And, my lord, also kindly see, my lord, as we know corporate law, my lord, can, my lord, an individual director come and challenge a board decision? And where is the illegality? They will, I understand, my lord, they say, no, this is actually in violation of this act, violation of that law.
Yes.
Then, my lord, it's a question of, my lord, the violation of law, Companies Act, or whatever provision, my lord, they challenge it. Then also, my lord, we are very strict now. Civil suit, my lord, will not lie. You will have to go, my lord, to the, my lord, if it relates to the affairs of the company.
You cannot.
Relates to affairs of the company, you will have to go to the company court.
That is different.
Because that's a cause of action. Because that's why I said, my lord, what one cannot do directly. And I'm sorry, my lord, I'm just repeating that.
That's why the clever drafting.
Yes.
That's why the clever drafting, they are not challenging with regard.
And, my lord, kindly see, the claimant is also not a shareholder.
So
Claimant is a if and when.
So let go to the testament issue.
Yes. If you think you have a grievance as a universal legatee, please go to the testamentary court. Because this court then cannot, a civil suit will not lie.
What is the stage of the testamentary suit?
Malad, the cross-examination of Malad, the witness is going on, Malad, of Malad, Mr. Lotha.
First witness is being cross-examined.
Who?
No, it's going on.
Is, I think, yes, Malad, it's the last.
On the 22nd.
Okay.
But today, Malad, for the protection, Malad, APL is there. And APL's interest has also been in the sense protected by the division bench. Still, Malad, the division bench stands to say that it is by majority. And they show you, Malad, they show the court, page 961. Now, kindly look at 961 is one of the APL members complaining.
N61 is the cause of action of the plaintiff.
Yes, but that is not, Malad, a letter, Malad, by the plaintiff.
No, not the plaintiff. That's why.
Yes, yes.
R7.
Yes.
Defendant 7.
It is, Malad, by Malad, one of the APL members.
Defendant 7 has not filed the suit.
Defendant 7.
Where is the Lucas?
He's supporting the plaintiff.
Or rather, the plaintiff is using him to try and, Malad, make out a cause of action. I don't know. That's why I said, Malad, I'm confused because I don't know whether, Malad, the APL member who's filing, really. Or, Malad, the grievance is being carried, Malad, by the universal legatee. Because if it's interest of estate, you'll have to go necessarily to, Malad, the testamentary suit. A civil suit, Malad, will not lie.
Yes.
Malad, now in the, Malad, in a supplementary affidavit, which, Malad, they have, Malad, will find there's an annexure 4. One of the companies, Malad, has been, Malad, just given, Malad, I'll show.
Supplementary.
Yeah, Malad, there is a.
Yes, yes.
Malad, kindly look at, Malad, this is one of the companies, Malad, Gwalior Webbing. The matter regarding the office space of the company at Builder Building, 4th floor and growing need. I'm sorry, Malad, page 12.
Page 12.
Page 12, Malad, of the supplementary.
Yes.
The matter regarding the office space of the company at Builder Building, 4th floor and growing need of additional space was discussed at the meeting of the Board of Directors held on 31st August 2024. After discussion, board authorized the management to identify and finalize other additional suitable space for the office need of the company on rental basis. We have come to know about the office space available at the east wing of 7th floor, which is owned by Builder Buildings Limited. Entire eastern wing, 9,000 square feet, 7th floor is vacant, available on rent. Keeping in mind our present and future requirements, we have shortlisted, earmarked an area of 1852 square feet carpet area in the said floor. Total monthly fixed cost for the said area is Sansaj, lease 65 Sansaj. Rate being charged is in line with rentals for commercial office space in central business districts of Calcutta. Apart from the above, Builder Building also levies service charge at 44. All occupants, which in our case will amount to be Sansaj. Thus, the total outlay of the office will be 69.81 lakhs. Propose that the agreement be entered jointly by 5 core investment companies group. Rental shared with following manner, and then Malad, that is given. It's a board's decision, and this is how Malad it's going to be shared. And my learned friend Malad in Punjab Produce and East India, he shows valuation of the company as he says that we have 2,400 crores. And Malad, there's a difficulty in Malad shelling out Malad 15% and 5%.
Yes.
Apart from the above, expenses were also incurred. Something interior that has to be done, a draft of the proposed agreement.
So this is a decision taken by.
Yes. Decision taken by the board.
Correct.
And 961, Malad, why I'm showing it, very interesting. Malad, one line I saw. This is Malad, volume 7. Malad, kindly look at Malad 1, 2, 3, 4th paragraph, which Malad, the third APL member writes.
Yes.
I also stated at the board meetings that there was no competitive courts or benchmark used to determine the fairness of rent and revision rent, even if there was a justification for it. I have therefore, for aforesaid reasons, dissented from the proposed resolution. So, my lord, either he is dissenting as a board member, then also, my lord, he cannot have a right because, my lord, the majority board, my lord, will prevail, or he is dissenting as a third APL member, then also, my lord, the division bench says, my lord, while it holds, division bench says no majority has to.
Whether he has raised objection in the meeting?
My lord, that's what he says, my lord, he has. So it's been considered.
It is the 25th October when
Yes.
the decision was taken.
My lord,
On
I think
31st of August.
Yes.
31st of August.
Yes.
And this is after 2 months.
Yes, the decision, my lord, correct, my lord, 30th August, when they say we look for a space, and then, my lord, again 23rd October, this was confirmed, my lord, with regard to. So, my lord, he takes a. So, I am saying, my lord, in either way, either in his capacity as a director, he cannot have a cause of action, or his capacity as, my lord, a third member of the APL, he cannot have a cause of action. Then, my lord, to base this objection letter as the cause of action for, my lord, my learned friends, my lord, I, in my most respectful submission,
Yes.
is, my lord, something, my lord, which, my lord, they will not be permitted in law. So it is no good saying that, look, because the testamentary court has said we can't interfere with
Yes.
third-party companies, and not mentioning that we are the ones who actually raised those objections in the testamentary court, saying that you cannot interfere with third company APL, and then to say we have the right to file a civil suit is something, my lord, which I would say, my lord, is contrary to their own argument, and, my lord, to contrary, my lord, to, my lord, this judgment, my lord, withstanding. Now, my lord, my learned friend also, my lord, makes some arguments, my lord, of prejudice to say, oh, how does it matter if the lease is executed tomorrow, if the lease is executed after short affidavits are filed? Because this is, now, my lord, we are not on that question. Today, my lord, if the plaintiff has come, he wants, my lord, the court to entertain a suit and to pass an order. He has to show, my lord, a legal right to be entitled to that order. It is not a question of, my lord, that, oh, the defendants won't be prejudiced. How does it matter? You wait for 7 days. It's a question of, it's a very important question, because the court will today entertain your right, which you allege, and which at least prima facie, my lord, has to be shown, my lord, whether, my lord, there is not. My lord, I submit, my lord, this my lord, whole suit and the petition, my lord, is not maintainable. But, my lord, we would like to, my lord, if, my lord, thinks, my lord, fit that, my lord, there should be an affidavit direction, my lord, we will, my lord, file affidavits. But, my lord, there's no question of, my lord, at this stage, my lord, to pass any order, because that will direct interference, my lord, with, my lord, the board's decision, my lord, of the companies. My lord,
Yes, anybody else?
no, among the defendants we have started. There's no question of anyone else submitting for the plaintiff. Not supporting the plaintiff, because I've made my submission.
I suppose so.
Yes.
I hope there are no other defendants.
No, no, why?
Supporting the
Supporting, yes. Not supporting the plaintiff.
No.
Corporation wants to support.
Oh, then he should have submitted earlier.
Why would I submit earlier?
Yes, because if you're supporting the plaintiff, you have to submit earlier. That's how I understand.
You may understand anything.
No, no, my lord, that's my submission. Mr. Bachawat, let's
Okay, let me see. If required, I will call.
Very well.
Yes.
Very well.
Mr. Bachawat, you are appearing for?
Defend number 14. Birla Corp.
14.
What's this? Birla Corporation.
Birla Corporation. Yes.
Now, my lord, the dispute, as I understand it, is this, but the undisputed fact here is, my lord, these companies who my learned friend, my lord, represents.
So you are supporting plaintiff?
Yes, yes, yes. Now, my lord, the picture over here is this, my lord, if your lordship takes the cause title. The defendant numbers 1, 2, 3, and 4. Come this way. But 1, 2, 3, and 4
are directors of some of these companies over here. In other words, my lord, defendant numbers 8, 9, 10, 11, and 12.
8 to 12.
Yes. Defendant numbers, not this is what I've understood from it, but defendant numbers 5, 6, and 7 are APL committee.
Yes.
They are also on the board, right? Now,
They are the member of the board.
yes. Board of some of these companies, not collectively or otherwise. Now, defendant numbers 8, 9, 10, 11, and 12.
They are the director.
They are the tenants. Tenants of defendant number 14.
8 to 12.
Yes. And they intend to take up a office under defendant number 13. At the moment, they are tenants under defendant number 14. They intend to enter into a tenancy with defendant number 13. Now, it's in the same building.
So they are vacating your premises.
Not clear. Not very clear. I'll come to it. No, don't say no. You have said nothing about it. Now I'll tell you. Correct. So now the point here is this. Not your lordship has heard delightfully vague submissions here. Now, what is the position here? Now, please notice two things. Defendant number 13 and 14. 13 is the owner of the 7th floor. Defendant number 14 is the owner of 4th floor.
Yes.
So, what's the difference? Shifting from 3rd floor to 7th floor, there must be some good reason.
Yes.
There has to be a reason. One is not doing it without purpose, particularly when the rent is 20 times higher or 100 times higher, whatever it be.
Yes.
There must be a reason. So, what's the difference between the two?
So how you can say?
No, I'm just giving your lordship the core of the controversy. What I have to say, I'll come to at the very end. But this is the core of the controversy. Now, therefore, this is the mystery. Why from 3rd floor to 7th floor? Answer is not very clear if your lordship looks at it. Birla Corporation Limited was, Millard, part of the MP Birla group of companies. Birla Buildings Limited belongs to the other gang between whom, Millard, the fight is. Not I'm using crude language, but this is it's warfare over here. They've filed proceedings against Birla Corporation at least a dozen times that your lordship has seen. At least a dozen times. So it's war. It's war here. It's not peace. This much is for sure. Now, so these are the two rivals. Now, please, Millard, also understand this. Undisputed position till now, is that the common case between the two warring groups of people claiming to be entitled to the MP Birla group is that, Millard, respondent numbers 8, 9, 10, 11, 12 are belonging to the MP Birla group and the estate. They are tier 1 and 2 companies in which Mrs. Birla had direct control, not 3 and 4 like Birla Corp. Birla Corp, no direct control.
Correct.
Direct. Now, what could be the motive of not shifting out the registered office of these companies from the group to which it belongs to a group to which it does not belong? But is the motive not very clear over here? All the vital documents are lying there. These are investment companies. They have no other business. The board does not say that there is any new line of business proposed. There cannot be any new line of business without leave of the court. The division bench is clear. Any major decision, please come to the court. There is no new line of business. So what is this expansion one is talking about? I'll come to that in a moment. Your lordship will see how hollow this will sound. So the motive is remove books, papers, documents, get it out. Why? Why? Now, this is what is becoming important. Till now, they have been proceeding on the basis that the APL had the God-given right to have control over all the companies. And on that basis, my lord, the APL had been putting their members into tier 3 and 4. Division bench said nothing doing, can't be done. It can't be done. Now, my lord, please keep in mind the distinction between tier 1 and 2 companies on the one hand and 3 and 4 companies on the other hand. My learned friend is relying on the division bench judgment, but not bringing out that distinction. So as far as tier 1 and 2 companies are concerned, APL is entitled not to say it is part of the state and he can have his people there. But he cannot take any major decisions, was what Mr. Abhijit Mitra has not submitted. Now, till now, they were not doing it on the basis that APL has the God-given right and it is being administered by court. The court has said no. APL is merely to act like a shareholder in these companies, and whatever a shareholder can do in these companies, he will do. If he has majority, he will do certain things. If he doesn't, he will not. Now, given this, not the first thing now to bear in mind is there is a decision to shift the registered office out of something not which belong to the MP Builder Group entities to a rival entity. Point number 1. Point number 2, my lord, please note this, that no justification has been given for the shift. The only justification given is completely, my lord, hollow and without basis. What is the justification given? Expansion in business over the years. Balance sheets have been shown to your company. It has no business whatsoever. None. Only job is collect, my lord, dividend income and nothing more. Number 3, please, my lord, note the position. It has already been shown. I will not waste your lordship's time. Right from the very beginning, all these companies have been on the 4th floor. Before the disputes began, while the disputes were there, and today. So, my lord, no justification for why the shift, of the necessity for the shift. So, my lord, there is something more than meets the eye. Not it's for not the warring parties to not sort that out, which leaves. My lord, if your lordship also sees page 19, page 19 once. Now, what I've told your lordship is summarized over here in a sort of way. But para 22, if your lordship would take. The 7th floor of Birla building is owned and occupied and under the control of the rival Birla group. The owner is Birla Buildings, an entity also under the control of the Birla group, who at all material times have been defendants and are supporting defendants in the testamentary proceedings. The present director of Birla Building Limited are Manohar Pachisia, an employee of GP Birla Group, Patodia, KK Birla, Saurav Ghosh, employee of BK Birla Group, and Vijay Dalan, employee of BK Birla Group, and the same will appear from a copy of the master data. So, my lord, this defendant number 13 is clearly, my lord, belonging to their group. Now, who are the people who have been, my lord, nominated or now presently, my lord, now there? Please remember, my lord, it cannot be disputed that the defendant numbers 8 to 13 companies are tier 1, 2 companies belonging to the Lord estate. No one can now, my lord, dispute this. Neither, my lord, Mr. Mitro's client, nor my learned friend's client. That position is established. Now, on that basis, your lordship will remember the APL has nominated, my lord, people, my lord, as directors in these companies. Correct. On that basis, it's too late in the day to now back out and say they don't belong to the MP Birla Group. Too late in the day. You can't shift it out of the MP Birla Group. Now, once the division bench came up with this distinction between the tier 1, tier 2, and tier 3 and tier 4, they realized the difficulty. So now, my lord, the attempt is, earlier the attempt was to say, look, these belong to Mrs. Birla. They are her personal estate. Now the attempt is to remove it out. Take it out. This is the situation. And that is why the about turn, my learned friend, your lordship has heard him say repeatedly, this was our submission there now. Now they are making that submission. But that vital distinction between tier 1, 2 and tier 3, 4, he has not brought out. Now, my lord, 2, 3, 4 other situations. Now, my learned friend says, as far as I'm concerned, submission made by him was, my lord, that there is no lease agreement presently today. This was the submission made. Your Lordship must have noted it. Now, fact of the matter is, my Lord, since these are all part of the MP Birla group for long years, my Lord, what has been happening is rent is being paid, my Lord, documents are thereafter executed. That is why, my Lord, the rent is a pittance. Your Lordship has seen it's a pittance. Now, out of these 5 defendants, only 3 pay rent. The other 2 don't. Which is why when they are now seeking new tenancy with Birla buildings, your Lordship will find again it's a collective rent. So it is not as if it's divided spaces or anything. But this much space, not as big as this courtroom, is sufficient to meet all their needs because there is no business. This is the given, Lord. There is only 1 or 2 employees for that matter. Everyone else is an employee of the Birla Corporation or any of these other companies. This is the given situation. Now, my Lord, in this case, what has happened is there were 5-year agreements entered into, expired. He has already, my Lord, after expiry, paid the rent for the entire year. It's one annual rent. It is not that, my Lord, monthly rent is being paid. Now, rent has been paid by him till March 2025.
Yeah.
He has paid rent till March 2025. So I don't know on what basis he says that there is no existing arrangement. Now, his letter is also on record saying, please sign the document. And that will be done in due course. It's always been done. These are treated as internal entities almost. It will be done. A board meeting, Lord, it has to be usual, Lord, technical formalities have to be complied with. Lord, the tenancy agreement will be executed. The rent is known. He is in possession. He has paid the rent for the entire year. So there was no, Lord, apprehension that he is going to be thrown out. That's not his case either. Your Lordship has seen the board minutes.
Yes.
The board minutes don't say there's an apprehension that I will throw him out. His apprehension is not that. What he's saying is, I need additional space. So there's no apprehension of being thrown out. So, my Lord, what was the need to do this? Today, my Lord, a mere oral statement from the bar that I need additional space, which is completely contradicted by the documents on record. My learned friend needed to go much, much further. He has not tried to do it, but that itself throws doubts on their motives. Now, okay. In fact, my Lord, his letter, your Lordship has seen, he has asked for a 5-year agreement. Please see his letter. Please see his letter. Page 55. Identical letters by, my Lord, the 3 companies at page 55, 56, and 57. Please see, my Lord, the last, my Lord, para. You are requested to share the bill and receipt for the payment made. You are also requested to share a draft agreement for renewal of the tenancy for a further period of 5 years with effect from 1st April to 30th March 2029 expeditiously.
So if it is it so? So they wanted to continue with you.
Yes.
By paying the rent.
Yes, they have paid.
How you will be affected?
I am not. Lord, what I am saying is they have asked for an extension. Now, my learned friend, Lord, what is he doing?
Yes.
He's already got this space. I'm pointing out this space is there. His apprehension is not that I'm throwing him out. This tenancy is very much there.
Correct.
That is all. This is all I'm pointing out from here. Now, Lord, as I point out, this need for additional space, Lord, is an excuse. Number 2, my learned friend has not justified the increase of rent from a total of, please compare, not the rents now. Please give me a moment, I'll just give your Lordship the total rent. I have it noted down here. The total rent, Lord, payable earlier or under these agreements, Lord, 4,93,039 for annually for all these companies. Not if your Lordship adds it up, otherwise, I'll just give your Lordship this from page. Just give the page, and that jumps up to roughly 50 lakhs a year. So, it is not a doubling, it's not a tripling, it is more than tenfold. More than tenfold. Please bear this in mind. Please come to page 7. page 7, your lordship will find that the total rent payable was, my lord, about 78,000 per annum. 52 and 16. 68,000, let's call it about 69,000 per annum.
Yes.
This was the total rent not paid for this entire area, roughly 2,500 square feet.
69,300.
Yes. And my lord, he is now going to pay roughly about 50 lakhs for very much the same area.
Page 20.
That is page 20. Please come to my lord, page 20. 50 lakhs plus furnishing cost of 75 lakhs. So 1 crore 25 will be his initial outgo.
Page 20.
Page 20, para 24.
Yes. Yes.
So, my lord, it's not a tenfold, it's actually a, my lord, much, but it's 100-fold or something like that. Now, my learned friend has naturally, my lord, tried to keep this under cover, but not this shows that this is more than what meets the eye. Perhaps something on the, not something which Mr. Mitro said, not gave me this idea. It's very much this. Who will this money be going to? Not this 70 lakhs a year plus other costs. Who will it be going to? The landlord is not the rival wing in the not probate proceedings. So, my lord, what is being happening? What is happening? Not money is being siphoned out of the estate. It's as simple as that. It's as simple as that.
Respondent number 1, 2, 3, 4, 5, 6. No one is a party in the testamentary.
And my learned friend says, go to the testamentary court. Please see, my lord, the cost title once. 1, 2, 3, 4.
5, 6.
Yes.
1, 2, 3, 4, my lord, they're not parties to the probate proceedings. You can't get reliefs against them, for sure. Similarly, the companies are not parties.
Yes.
So, my lord,
Yes.
and my lord, your lordship will remember, Lord, in the South Point matter and the other matter, I've showed it again and again. Justice Munshi in the trial court held, no order can be passed against the companies in a dozen places. That part is also upheld. So no orders can be passed against not the companies in this case, not by the probate court, not forgetting whatever the division bench has said. That much is accepted. Now, the other thing, my lord, is over here, my lord, perhaps, my lord, again, it's a factor which your lordship will, my lord, consider over here. Now, my lord, I think not. I'll leave it to the not rival parties to fight it out. But not the simple thing here is, as I have seen it, Mr. Banerjee has really raised a jurisdictional point. On merits, he said something simple. I need additional space. You can't stop it. It's a decision of the board of directors. It can't be stopped. Now, my lord, let me go whole hog and my lord, let's see if we support the plaintiff. What is the outcome? Now, his point is this is a decision of the board of directors which can be challenged either before the NCLT or elsewhere. A decision of the board can be challenged only in the NCLT, yes, but by whom? By a shareholder. His own case is that the plaintiff is not a shareholder. So it can't be an NCLT challenge. Next point is then, can it be a challenge before the probate court? Because this is what he seemed to be hinting at. You can't go to a civil court, you have to go to the testamentary court. But the testamentary court has been very clear that no order can be passed against the companies. It's been very clear about this. So, perhaps that is not the forum. Now, not limited understanding of law, not very limited understanding of law on my part, but I understand that oust of civil court jurisdiction can't be implied and it can't be based on guesswork. But it's a strict test. My learned friend will have to show beyond doubt that these orders can't be passed by a civil court. So, oust of jurisdiction, perhaps there's nothing much to this point. But the other point which my learned friend raised was, look, a decision of the board is not being challenged by a member of the board.
Yes.
is not being challenged by a member of the board. And the plaintiffs are not shareholders at present. They are at the highest a universal legatee. A universal legatee's rights are appropriately protected by the APL. This was his submission as I have understood it. So therefore, you have to go to the probate court. This is the second rung of his argument. Now, the fact of the matter is, if one cannot go to the probate court with regard to orders against the company, because that is what Justice Munshi has said, and that's what holds the field. But where would one go? To say that I have a right, but I have no remedy, it's something which defies all legal logic and reasoning. Because the probate court certainly cannot decide anything with regard to affairs of the company. It cannot. This much is clear. The division bench has very clearly clarified and said, look, what is the APL to do? APL will act as if it was Mrs. Priyambada Devi Birla. If she had been alive, as a shareholder, whatever she could have done, they can do. Nothing more, nothing less. Now, if they own majority in a company, they will exercise majority votes to do certain things. If not, they won't. This is the situation. But it does not give the probate court the right to do anything more within these companies. APL is a mere nominee or an appointee holding in lieu of the deceased.
Correct.
But it cannot pass any orders with regard to companies. So this argument also made by my learned friend perhaps doesn't have much basis. Those are my submissions. I don't think I have anything more to add. Anything? Too basic. Too basic.
For point number 7, may I be?
Sorry, just my axe. Yeah.
I take your lordship to two documents, my lord. Yes. My lord will come directly to page 961.
Yes.
The lordship kindly takes the first opening sentence of the first paragraph. I refer to board meetings of Gwalior, Bebing and East India held on 23rd October, where your good self and Mr. A.C. Chakraborty were also present as directors. An agenda note was circulated approximately 24 hours ahead of the meeting about a significant proposal to lease additional space of 1852 square feet at East Wing 7th floor in so-and-so Birla building at exorbitant rent of 4,93,000 and odd. So, the agenda note was circulated only 24 hours prior to the meeting, and this entire decision was sought to be taken and was taken with, my lord, unseen alacrity. Unseen alacrity. My lord, kindly take, my lord, what was the actual reasoning. My lord, my learned friend, my lord, Mr. Banerjee has pointed out to the, my lord, the agenda note, the note for the meeting, which is annexed to the supplementary affidavit for the meeting held on 23rd October. Well, I will place that. And before that, may I place this particular, this is the 5th paragraph. The only reason for the purported relocation of the registered office has been that our employees are feeling threatened, which is ex facie false, concocted and misleading.
Yes.
Well, if your lordship calls upon, my lord, Mr. Banerjee's clients, well, they would produce with your lordship the minutes of the meeting held on 31st August 2024. And from the minutes of the meeting, your lordship will find, my lord, this kind of statement was made. And my lord, it was also pointed out by me during the course of meeting that this is not correct. And let status quo be maintained because there is no material to support such an apprehension. But this perception is no perception, this is delusion. This is, my lord, imaginary. And this imaginary statement or this imaginary apprehension became the basis for, my lord, this renting of additional space of 1852 square feet. 1852 square feet on the same building. Yes. In the same building on the 7th floor. My lord, at a rental
of 4,93,000. As a member of the APL, since the APL, by reason of the judgment rendered by the Honorable Division Bench, as on 14th of December 2023, it is clear that the APL has controlling interest over the, in view of the estate, over the tier 1 and tier 2 companies. Having being held so, the question which arises is that, as a member of the APL, it is my duty as an officer of the court that whether any action which may lead to erosion of the estate, to point out before the appropriate authority, because I attended the meeting as a director of the board, but I am also a member of the APL. In fact, your lordship will find from the list of board of directors, all the members of the APL were members of the board of directors in this Gwalior Webbing and East India, with which I am concerned, because I am member director of those boards. Now, kindly come to the.
Why you are not challenging this?
I cannot challenge it.
Why?
I cannot challenge it because the division bench has has laid down the procedure. What I have done, I have immediately pointed it out to the Justice Shah, who is the third member of the APL committee. Because according to me, suppose the rent was X, because that particular leasehold property is also being held, and payment of rent has been made for the financial year 24-25. So, if that is X, now with the renting of this additional space, it will become 11X.
Correct.
So, this will have a direct telling impact on the financials of the companies. There is no doubt about it, because it is an expenditure. And in any event, since this will have an impact, it was necessary for me to point it out. I pointed out to the authorities, and now kindly take compare it with this annexure 4 to my to the supplementary affidavit.
You have pointed out if they have not taken any decision, what is your cause of action?
The cause of action is that it was necessary for the third member to take cognizance of my complaint and take appropriate steps as laid down or provided for in paragraph 217 of the judgment rendered by the division bench.
Yes.
Because according to me, a decision which is a financial decision, which will have an impact of increasing the expenditure 10 times, admittedly 10 times, it is a major decision. It's not a minor decision. And then question would also arise, under these circumstances, kindly compare this with the agenda note. Agenda note, which your lordship will find at supplementary affidavit. Your lordship will find this reasoning, this rationale, which was put forth during the course of meeting held on 31st August 2024, that there is a threat perception. This rationale is conspicuously absent. So the basis for which a decision was sought to be taken to search or to go for another additional space, that basis does not find itself, being mentioned in the agenda note. There is no such mention.
Kindly come to the second paragraph. Keeping in mind our present and future requirements, we have.
But that was not the case. That case was the threat perception. That was not the case. Case was threat perception. In 31st August till now. It is 31st August. Kindly take this is the decision which was taken on 31st August. Kindly take this. Kindly come to the last 2 pages of this decision, of these minutes. That is serial number 14.
Yes.
Kindly turn over and take the last page. I will not trouble your lordship with the entirety of these minutes. The second paragraph.
Yes.
It was informed that the staff members of the investment companies, trust and societies having their offices in the said space are being subjected to various types of intimidation and threats on daily basis. private security guards are being placed at the entry point by BCL. It was also informed that the entry and exit is also controlled by BCL because the keys to the entry gate are in the possession of BCL. Recently, they have also installed CCTV cameras inside the area which is occupied by a company and monitoring our movements. The management sought advice and guidance of the board to protect the rights of the company. One of the suggestions of the management was to file suit for declaration of the company as rightful tenant of the above-mentioned space. The board noted that it is a common past practice to let out properties belonging to one entity of the group to other entities at a very nominal rent. But the rent was 69,000 for all these companies. For instance, a huge property, and that too per annum, my lord. A huge property of one of the investment companies at New Delhi is let out to one of the listed companies at a nominal rent of 10,000 per month. The chairman and some of the other board members expressed deep concern regarding the present position. Sri M.K. Sharma advised that status quo be maintained since nobody is seeking to throw us out. So, this threat perception, this particular reasoning does not find its place in the ultimate decision, where a decision is being taken to take on lease a property and for payment of rent amounting to about 60 lakhs with additional cost of another 15 lakhs, and that too per annum. But so, the rationale does not find its place in the final decision. There is no other reasoning, my lord.
No, so then where is the decision?
The decision is that I am taking a lordship. The chair, after discussion, it was decided by majority that further legal advice be sought to protect the interest of the company, and if required, appropriate legal proceedings be initiated. It was also decided that keeping in mind the growing need for additional office space, the management may also identify and finalize additional suitable space for the office need of the company on rental basis. So, the primary point which was taken is the threat perception. And my lord, this threat perception is not there in the final decision. And there is no justification whatsoever for this additional space. There is no justification.
What is the date of the meeting?
31st August, referred to in the agenda note. Referred to in the agenda note being annexed to the supplementary affidavit.
31st of August.
Right, my lord.
So thereafter, what has happened?
Thereafter, my lord, on 22nd of October, my lord, a agenda note was circulated that a meeting would be held on 23rd October for this decision. 24-hour notice was given, and on 23rd October, this decision was taken.
What is the decision?
The decision is that to take on lease the additional space.
You are not having the decision?
No, I am not having. My learned friend may be having that decision.
What is the decision, Mr.
But supplementary affidavit is there. I'm sorry, my lord, it is কোথায় আছে? কোথায় আছে? পেজটা বলো। 12. I'm sorry, my lord, 12. আরে এটাই তো হচ্ছে annexure 4. এটা তো হচ্ছে agenda note.
This is the agenda notice.
This is the agenda note. They can minutes they would be having. They should be having the minutes.
Yes, Mr. Banerjee, what has happened after this?
Well, resolution been adopted. I'm not saying that we want to take on rent.
Because after discussion, it was decided majority to further legal advice we sought to protect the interest of the company and required appropriate legal initiative.
Yes, that is with regard to the threat. But we'll also see, after discussion, the last paragraph of that. After discussion, decided by majority, further legal, then after that, it was also decided that keeping in mind the growing need for additional office space, the management may also identify and finalize other additional suitable space for the office need of the company on rental basis.
So what has happened to the threatening legal advice?
Well, that I don't know, I can find out, what has happened.
They have paid the rent.
Yes, we have paid, rent.
They have paid the rent.
Anyway, I'll make my submission. After, they make their submission, I'll make my submission with regard to how, Mr. Sharma, and, Messrs. BCL, is affected, by this decision.
It is not the question of being Mr. Sharma affected. It is a question, my lord, I am just an officer of the court. And my primary duty is to protect and preserve the estate. The estate,
Yes.
So, my lord, these are my primary submissions, my lord. So, my lord, and so far as the
So
locus,
you're not present in the last meeting.
I was present in the last meeting.
So
I registered my demur. That is recorded in my mail.
you're not got the
No, minutes have
court
not been.
resolution?
No, not circulated. Not circulated, my lord. Unbelievable alacrity, my lord. Breakneck speed. They have to do it right now. My lord, in fact, my lord, in one of the APL committee meetings, my lord, I recorded my dissent note. Your lordship may also take note of that dissent note, which your lordship will find at page 603. It is part of, my lord, the decision taken on 603, if your lordship kindly takes. I'm sorry, my lord, I should have referred to the.
Yes. Tier 1 and Tier 2 company.
Yes, Tier 1, Tier 2 companies. So these were my dissent note. My lord, paragraph 31, she may also take note of. And then the shareholding pattern. That is at page 605. My lord, in fact, the shareholding pattern is also there in this petition at paragraph 11 of all the companies. The respondent number 8 to 12. Well, these are my submissions.
I can reply to all their submissions.
No, I'll have to. We have not finished.
Anybody
yet.
further?
No, we have
Yes.
finished.
Malad, I just want to take Malad on these two additional.
Who is other for
Malad, they're all Malad supporting Malad so far
with the
as.
plaintiff?
No.
Anybody's with the plaintiff? No. Then
Malad, I'll just take Malad 2 minutes on Malad. Malad, I'm very surprised Malad with respondent number 14 making any submission. That's Malad Birla Corporation Limited. Malad, one of the again Malad, the principal is Malad, one of the landlords of a company is coming and saying that I'm stopping the company from taking any other additional space on rent. Because today, Malad, when one supports the plaintiff, one has to also show what is his cause of action to support the plaintiff.
yes.
Because Birla Corporation Limited, Malad, in the testamentary court, has gone and submitted that, sorry, I cannot be made a part of this. If Malad looks at Malad, his Malad, the page 301, Mr. Bachawat's submission. I'm sorry, just try and identify where. Yes, at 302, Malad, Mr. Bachawat's submission before the division bench, paragraph 52. Mr. Sansach, learned senior advocate appearing for Birla Corporation Limited after elaborately submitting a genesis of the entire dispute contended, probate court itself could not have taken decision which were taken by APL, orders under the. Then, Malad, kindly see paragraph 54, 305. Insofar as he is concerned, it is further submitted that the shareholders have no right over the assets and properties of the company. Malad, page 305.
Yes. Further submitted that.
Shareholders have no right over the assets and properties of the company. Estate of PTB holds only 1260 shares, which is less than 0.002% share of the company. However, in the basis of the estate, it has no legal right to ownership and excess votes are held by BC and other companies. So, Malad, when he makes that submission before the probate court, he goes and says, I'm not part of the estate, you can't exercise any right. Here he comes and says that no, you now also look after the interest of the estate.
Yes.
Because otherwise, Malad, he has no right. He as well as an ex-landlord cannot come and say, I'm sorry, my tenant, you have no right to go and get another additional space.
Yes.
Well, I'm sorry, my lord, if that's a submission, absolutely, my lord, no basis at all. But and if he says, my lord, he's part of the estate, that's why, my lord, he's coming and making a submission supporting, my lord, the so-called, my lord, universal legatee. Then it's contrary to his own submission.
Yes.
And, my lord, so far as, my lord, my learned friend, Mr. Mujumdar is concerned, my lord, he has already raised his objection.
Yes.
In the board, as a director, and as APL member, which has been considered. It is not, my lord, considered, my lord, as a valid objection. And that is what, my lord, the division bench also says. So far as APL is concerned, sorry, APL, you will have to go by majority between the APL themselves. And, my lord, very honest, my lord, when my lord asked him the question, he very frankly submitted, no, I have no cause of action. I cannot file a suit. If he cannot, my lord, he does not have a cause of action so far as that is concerned, where is his now, my lord, cause to come and, my lord, support the plaintiff, my lord, in another civil suit?
Okay.
My lord, those are my submissions, my lord, additional submissions, my lord, so far as they are concerned.
Yes, anybody else?
That case not, since not my learn. Give me 30
No,
seconds.
the
30
respondent
seconds.
can't have, my lord, another reply to a reply, my lord, I'm sorry.
He has put words in my mouth which I have not used. But I said very clearly there is a distinction between tier 1 and 2 companies and tier 3 and 4. Birla Corporation is tier 4 company which is not part of the estate.
That you already
The
submitted.
other
But
defendants
how is he coming
are
and supporting
tier
tier
1
1,
and 2.
tier 2? Well, if he says, I don't want to be part of the estate.
Okay.
Lord,
That's
I'm
my
a-
submission,
I'm a
Mr. Pejawar.
defendant
Perhaps
here. Lord, I'm a defendant.
I made my
can
submission, my
support,
lord,
I
to the
can
court,
oppose.
my lord, I'm sure, my lord.
Katie,
where are you?
you are appearing for?
The defendant number 9. I am one of the companies, my lord, who proposes to take on lease this additional space. My lord, my only submission is on the locus of these plaintiffs. Their locus is that they claim to be universal legatees, and therefore they say that by virtue of being universal legatees, I am entitled to maintain this suit. And the only provision which has been shown, my lord, subject to correction is section 104 of the Succession Act. Kindly have 104 once of the Succession Act. No authority was cited for this proposition because there can't be any. I'll tell your lordship why. Kindly see 104. It says if a legacy is given in general terms without specifying the time when it is to be paid, the legacy has a vested interest in it from the date of the testator, and if he dies without having received it, it shall pass to his representatives. That is all that this says. Well, the vesting of legacy relates back to the date when the will is probated. That is the only effect.
After the
Grateful, my lord. Kindly see 336. Kindly see 336 once. Where does he get a locus today? And that is why the administrators are appointed. Kindly see 336. The assent of the executor. In this case, there's a will. They claim that there's a will. Then the assent of the executor or administrator to a legacy, because what is being set up are rival wills.
Yes.
So the whichever will is granted probate, then the executor or the administrator of that respective will has to give assent to legacy, gives effect to it from the date of the death of the testator. It relates back. That is all that 104 says. Does not give him a right in present time today to maintain a cause of action. Then, my lord, administrators have been appointed. Now, kindly see, my lord, section 247 once, please. Once an administrator is appointed, he is the one who's to represent the estate and take all steps to protect the interest. Administrator pendent LIT.
Yes.
Pending any suit touching the validity of the will of a deceased person, or for obtaining or revoking any probate or grant of letters of administration, the court may appoint an administrator of the estate of such deceased person. Now kindly see, who shall have all the rights and powers of a general administrator other than the right of distributing such estate, and every such administrator shall be subject to the immediate control. So the administrator represents the estate.
Yes. But here the administrator is appointed.
Administrator pendent LIT was appointed initially, and now only the body, the constitution of the administrator pendent LIT has changed.
Correct.
So one is Mr. Sharma, whom Mr. Mujumdar represent. The other are the other two administrators. One is the retired judge of our court and the Bombay High Court Chief Justice, and the other is a nominee of the Birla. So that is the constitution of the administrator pendant. So if there is any dissipation of the estate, it is for the administrators. not for the legatees. There's no section which has been shown to your lordship that a legatee or a person claiming to be interested in the estate of a deceased can come to court, because there is no such section. There's only one section which I must show your lordship, and the matter will end there. Kindly see 192 once, please. When can a legatee come to court? Kindly come to 192. This is the only limited provision in the Succession Act. Person claiming right by succession to property of deceased may apply for relief against wrongful possession. Part 7, protection of property of deceased. This is the only section, my lord, which gives right to somebody who claims to be the legatee or beneficiary of the estate to come to court. Only when there is possession of immovable property which is being taken, wrongfully taken. This is the only provision. Otherwise, there is no vested right in a legatee to come to court. Now, my lord, just one more short submission, my lord. Your lordship has seen 31st August 24, the last paragraph, resolution was taken that if we are proposing that there's an expansion in business and we need to take additional space. If anybody was aggrieved then Mr. Sharma should have come to court that day. Or, my lord, the legatees who claim today ought to have come to court that day. They cannot come to court today because the decision was taken as on 31st August 24 to look for additional space. The additional space has now been identified. Now, if they say that this additional space, I could have understood they come with a case that this additional space is at an exorbitant cost today. You could have got a cheaper space in the same building, you're causing detriment to. That is not the case. Their case is simple. They have to show to your lordship that the lease rent which I am taking at Birla Building is giving similar space to other entities at lesser rate than the rate which these 5 companies are taking. That could have been a cause of causing wrongful loss to the estate, that you're taking on the 7th floor at say 500 rupees. See, on the 6th floor, Birla Building is giving at 400 rupees to HDFC Bank or some other new entity. That is not the case. So there's no case of dissipation or taking at rent an exorbitant amount.
Yes.
Those are my respectful submissions.
I'm adapting whatever has been submitted, Mr. Banerjee. I'm for 11 and 12. 2 companies, Malat.
Yes.
Malat, 2 things, Malat. First, Malat, in their plaint, they have admitted to the factum that the rights of PDB is in respect of shares of the company. Malat. Now, Malat, when it is to the shares of the company, Malat, your lordship is well aware, Malat, the company jurisprudence, that independent entity. The company is an independent entity. Normally, the company is run by a board of directors. Now, Malat, that board of directors, Malat, again, it fell from your lordship, and they have also accepted that yes, the board had taken a decision. That decision, Malat, though not directly challenged, is being attempted to be impeded now. So, an action which has been undertaken by the provisions of the Companies Act 2013 is being attempted to be impeded at the moment, Malat.
Board of directors of all companies, not only the APL, the other members.
Yes, Malat, that is, I'm grateful to Mr. Thakkar, but Malat, it is a matter of record also that APL members do not constitute the only members of the board. So, Malat, that they were there on the board, they gave their dissent. Malat, board has passed a resolution. Malat, for the time being, let us leave aside Birla and Lodha. For the time being, Malat, I'm just submitting, Malat. Malat, what is this suit for? This is a suit by a shareholder. I'm giving them that leverage also, Malat, saying that they are shareholders of a shareholder challenging the decision of the board to take on lease a property of the for additional space for further works. This is the suit. Now, Malat, whether it is good if I'm spending more money or not so money, Malat, even if it's not testamentary claim or whatever, I'll come to that later. Even if it is bad, Malat, it's an action of the board of directors which is under challenge. Now, Malat, even if the suit is maintainable, Malat, your lordship is well aware of section 430. 430, Malat, even if the suit is maintainable, Malat, no injunction can be passed in respect of any action taken under that act. Now, Malat, kindly see Kindly see section 179, my lord, of the Companies Act.
Section
179. My lord, again, my lord, just to cut things short, my lord, it is not my learned friend's submission that the board couldn't have taken this decision. They are more concerned about the amount of money which is going out. They have not challenged that they cannot take this decision. They are saying it's an exorbitant amount. They are trying to deplete the funds or deplete the estate of PDB.
Correct.
So, my lord, at the end of everything, my lord, section 179.
Yes.
My lord, in 3, my lord, your lordship will find 179(3), my lord, resolutions are allowed to be taken, namely, though this is not, my lord, this is an inclusive definition, my lord, but I will fall under 3H, 179(3H), to diversify the business, to approve amalgamations, and then, my lord, kindly sees to take over a company and any other matter which is prescribed. So, my lord, this is in the regular business because I'm saying I need additional space. This is regular business. Now, my lord, kindly comes to section 430. My lord, section 430. No civil, sorry, my lord.
Yes.
But kindly sees, no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter with the tribunal or the appellate tribunal is empowered to determine by or under this act or any other law being for the time being in force. But this is one part. There's the jurisdictional part of whether a suit is maintainable. But let us say, the suit is maintainable. But there is a conjunction. And no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act. The decision was a board decision, and the action was to enter into the lease agreement. Today, my lord, prayer A and prayer B are injunctions which impedes the action of the directors taken under section 179. And this is no injunction. Even if the suit is maintained, I'm not in that. But there are judgments in section 34, same language, which says that this is different injunction. Even if the suit is maintained, injunction cannot be granted. So today my learned friends have come up and sought for an injunction in the nature of impeding a company action or an action of a action taken under the Companies Act. Now, my lord, now, my learned friends have referred to, my lord, some of the paragraphs, my lord. My lord, I'll just read 2 paragraphs, my lord. Kindly takes page 457. As a matter of fact, my lord, the division bench, my lord, kept the primacy of the independence of juristic entity of the company secure. Or else, my lord, there wouldn't have been anything else left and everything would be a probate court. But I am not on that. I am only on what the division bench has said.
Yes.
And kindly takes page 457.
Which para?
211, my lord.
Yes.
But before that, we are required to distinguish here between the rights directly flowing from and incidental to such ownership of shares and those which are remotely derivatives from such ownership and not proximate. But in my case, my lord, for defendant numbers 11 and 12, my lord, they are companies, my lord, where, my lord, if your lordship kindly sees the plaint, my lord, they have given the shareholding pattern, my lord. or even the petition, my lord. You can, lordship can see the petition. Petition to bear petition to bear.
Yes, page 12.
Page 12, my lord.
It starts on page 10.
Yes, my lord. My lord, kindly sees 14, my lord. Paragraph 13 and 14, my lord.
Yes.
Punjab Produce. The respondent number 11 PDB held no shares.
Yes.
However, shares in Punjab Produce are held by the following other respondent companies. So the derivative. And also, my lord, 12 kindly sees estate is 0.08%. But at page 12 only, my lord. But there are two tables. The upper one is para 13 of your lordship. But para 13 is for defendant number 11.
Correct.
There is no direct shareholding of PDB.
Correct.
And in 14, my lord, there is only shareholding of 0.08%.
Yes, PDB.
Now, my lord, let us come back to that order of page 211, para 211.
$211.
211.
Yes.
We are required to distinguish here between the rights flowing from and incidental to such ownership of shares and those who are remotely derivatives. Former are subject matters of the estate and APL can exercise those, but the latter remotely cannot be thrust on the respective company, which are independent juristic entities. Then, my lord, kindly sees 212. The APL thus cannot interfere with all internal affairs of the companies of all the tiers with the blessings of the testamentary court. Cannot be any universal dynamic injunction or direction affecting the future course of action or the companies of the testamentary court. But in spite of this finding, my learned friend's suit, my lord, piggy rights, if I may put, because we have been using quite a few colloquial terms today. So piggy rights, my lord, the letter of defendant number 7. Who's the APL? So, my lord, that the plaintiffs therefore do not have a right themselves.
True.
Now, when it makes through, my lord, then it's a testamentary jurisdiction they are trying to achieve before your lordship. They are asking now protection of estate in a civil suit.
Cannot.
They cannot.
Yes.
That is why, my lord, for the timing I had said, my lord, let us not look into the parties. What is the suit all about?
Yes.
3 shareholders asking for prevention of lease to be granted by the company or to the company by a third party company. And there are present lessor of another floor who's trying to create a breach of that contract. Disgruntled. That is what the suit is all about. Now, when we put in them,
not breach, not
trying to breach it. Malat, defendant number 13.
Yes, if you collectively.
Malat, yes, because I have entered into an agreement. I have not entered, but there has been negotiations.
Yes.
I am being prevented. And that company is not a party to the testamentary proceedings. Neither is it of any use here because they won't have a cause of action against that company.
Correct.
Malat, they have only used the term rival group. A very interesting term, Malat. But in the rival group, Malat, whichever persons they have mentioned as directors in that group, Malat, I do not think they are parties to testamentary jurisdiction or testamentary suit. They are not. It's only the 2 sisters. But in the testamentary suit, I'm not talking about this. So therefore, my lord, to say it's a rival group is trying to give some protection or give them lease, that is neither here nor there.
Okay. Next.
Last, my lord. Well, yes, my lord. The other thing is, my lord, the 3, my lord, prima facie case, balance of convenience, and my lord. My lord, first things first, my lord. It is established, my lord. I do not think I need to submit on or give any judgments, my lord. The estate of the company is independent to that of the shareholder. Now to come and say that I'm trying to prevent that estate to be used in any manner because I am a shareholder is always frowned upon. Unless it is a case of oppression mismanagement, which, my lord, your lordship is well aware, is not within the domain of this honorable court. Mr. Mitro had made a submission that I cannot go there because I do not have 10%. Bad luck. I don't have shares. Bad luck. Because earlier maybe it was maintainable, class action, derivative action. Now because of this 430 money, it's not maintainable. It is not maintainable.
Yes.
So you cannot overcome something which you are not allowed in law by filing this suit. Now, my lord, Mr. Bachawat was trying to make a distinction between tier 1 and tier 2. Your lordship will not find those pleadings anywhere in the plaint. So let us restrict ourselves to the plaint. As a matter of fact, the plaint and the petition, my lord.
That is the note of the D7.
Yes, only on that, my lord. But today, my lord, your lordship will kindly appreciate, on 15th of October, this agenda was circulated. And they wait till the 28th and then 30th they move. Well, what is the urgency? I mean, they had their time. They could have moved earlier. 18th there was division. And I have the document. Malad, it is not his suit. Let him not make a submission, Malad. We will go according to the plaint and petition. This is the suit which has been filed, and Mr. Mujumdar will file his affidavit to bring this on record when he got it. That he will do in his own way, but the plaint says and the petition says so. So therefore, my lord, there was no urgency. And my lord, may I just ask myself, what is the loss to be caused? What will be the irreparable loss?
10 times more than the actual rent.
My lord, here I go. Here. Okay. Very good. 69,000, my lord, give it a million times. Does he have a right to say anything? In this court, if he says it is his testamentary right which is being affected, this court does not have jurisdiction. He has to go there. If he says that no, it is my right as a shareholder because I am a shareholder, under paragraph 9 he has said so, then he has to go there. And if he doesn't have the shareholding, my lord, then again, my lord, with humility I submit. Bad luck.
Okay.
So, my lord, the imminent danger, my lord, then, my lord, what would happen? My lord, I am a shareholder of a few companies. I will immediately file a suit saying that no, this is a company, you cannot give this on lease because it might cause loss to the company. And if loss is caused, then it might cause loss to my dividend rights. Well, that is not the test. Cannot be. And again, saying all these things, I might as well just end by saying, Malad, no injunction, Malad, under section 430.
Yes. Next, anything, Paul?
Malad, I was only. Malad, there is a judgment, Malad. May I just place this? Well, this is 2022 SCC Online Calcutta 1389. Malad,
you had appeared. You have appeared.
I lost. Malad, I am not ready to lose everywhere. So, Malad, this is, Malad, is in respect of the Surface Act. I do not dispute that. But, Malad, section 34 and section 430 are perimeter same. And the division bench of this court has held that even if the suit is maintainable, if that and is there, injunction cannot be granted in any form whatsoever. Malad, paragraph 45 to 49, Malad. Malad, those are my submissions, Malad.
Yes. Yes. That's all.
But yes, I don't have any other.
If there's no other person from them, I have to get my rejoinder.
বলবেন কিছু?
Mr. Anirban Ray has submitted that this was since his last, the remedy, this was under section 179 is the board's power to do this. And section 430 excludes the civil jurisdiction. And section 430 has placed, Lordship may kindly see, does not exclude the civil court jurisdiction unless, it is a very important point, 430, the first line, no civil court shall have jurisdiction to entertain any suit or proceeding. Section 430. No, section 430.
Yes.
No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the tribunal or appellate tribunal is empowered to determine under this act.
Correct.
No, I want the second part.
Now, kindly come to the only provision where the NCLT has jurisdiction under section 241. 241 relates to the company's affairs. But who can file a 241? As I have shown, the appeals meetings record 100% of the shares of these 5 companies are controlled by the estate. I had shown the minutes. I think it was page 621 or 573. 244. Following members of a company shall have the right to apply under section 241, namely in the case of a company having a share capital, not less than 100 members, or not less than 1/10 of the number of its members. Whichever is less, so it has to be a 10% share. The exception is provided, is the proviso. At page 574, they show 100% by the estate. Proviso, provided that the tribunal may, on an application made to it in this behalf, waive all or any of the requirements specified in clause A or clause B so as to enable the members to apply under section 241. This has been explained by court that only a member can apply. That's why I said if I had one share, if I was a shareholder having one share, I could have applied for exemption under section 244.
That's why it's telling that unfortunate.
So, but 430 does not take away the civil court jurisdiction altogether. It is only if the tribunal has jurisdiction. 430.
Or under this act or any other law for the time being in force.
Or any other law for time being in force. And no integrability by any court or other authority, for any action taken or to be taken in persons of any power conferred by the court or any other law for time being in force by the tribunal or the appellate tribunal. So here, under the Companies Act, only there is the ouster of jurisdiction if I could have gone there. But I cannot go there because I don't have a single share. 430 is ruled out because of I'm not a shareholder. And that is
Bar is only if NCLT could have granted.
Bar is if NCLT could have granted the relief. India ekto bochilam. Yes. Yes. In the division, this is decided by the National Company Law Appellate Tribunal. You have to be a member to apply. A non-member can't apply. This is very. It's not just see paragraph 13 of this judgment of the Appellate Tribunal. Paragraph 13. The 12 and 13. Heard the counsel for both sides, we find that in spite of adding words relating to public interest in the old act, even when Act 13 was forced to 241 to continue to refer to members of the company to deal with question of oppression and mismatch. Thus, there is no scope to make alleged a purposive interpretation as claimed. We have perused 241 and read it with 244 and kept in view the old provisions of 299 we find that not much is required to be stated as Section 244 of the Act to us appears to be quite clear. A mere glance at the section shows that the proviso which has been added under clause A and B gives power to waive all or any of the requirements specified in clauses A or B so as to enable the members to apply. The proviso does not do away with members. Apart from this, the proviso controls and refers only to clause A and B and does not control what is not part of clause A and B. The opening words of subsection 1 are following members of a company. Then the clauses above are there. The proviso below clause A and B does not waive or control the opening words of the section, which clearly say that the right would be of members to apply. The proviso also gives right to only members to seek waiver or it. Even like a 241 say that any member can complain. A non-member cannot come. So I cannot go to the tribunal. So is my right excluded altogether? Now, 430 does not extinguish a right which I may have under other laws.
Yes.
Now, this takes me to Mr. Anirban's paragraph 211. This has to be at page 457, 211.
That's a division bench 211, not mine.
Page 457, 211. This and page 394, paragraph 108. Paragraph 108, which I had placed, that there can be no order passed against the other companies.
Page
394. Division bench held no order can be passed by the testamentary court against the companies. And 394, paragraph 108. I play, but then just last line. Last four lines of page 394. We need not labor much on this issue as the learned single judge rightly noted the proposition of law regarding held the companies not being parties not amenable to the jurisdiction of the probate court. While considering whether the companies can be joined as party defendant, the court held that the noticee companies can neither be joined as a party defendant nor can of restraint be passed against such company. And this is reiterated at paragraph 211, which Mr. Anirban placed. Yes. So, my lord, and I could not have gone to the testamentary court and asked for injunction against the company's board of directors' decision to give this away. Now, this takes me to Mr. Thakkar's argument on section 192 of the Succession Act. The 193. The shares represent the right to control this 192. The movable are the rights which flows from the 100% management over the company's assets. If any person dies leaving movable or immovable, say if the person dies leaving 100% shares in the company, nothing else, and the company in his bank account has 200 crores, can it be said that the legatee can't object that the 200 crores these directors control of the APL is going to give it away? The shareholder, I mean, it's just because a legatee will not be told because the testator had 100% shares in the company. You have to stop at the shares, but not what the shares represent. The shares represent right to control the 100 crores. Shares represent the right to control the 100 or 200 crores. Because the company has the 200 crores of rupees. So here the company's bank balance will be reduced by over 2 crores. And I cannot object because I have a right in the shares only. And this is a right I have. He has admitted I have a right during the pendency of probate proceeding. if any person dies, leaving property movable or immovable, and person claiming a right by succession thereto or to any portion thereof may make application to the district judge or the judge which where any part of the property is found. Here the property is registered office is Birla building within the court jurisdiction.
No, either after actual possession has been taken
Or
by another
apprehended.
person, or when forcible means be taking the possession.
Are apprehended. So my case is not by the apprehension, which is corroborated that they will sign the lease agreement, which will increase the annual expense by 100 times plus 3 years lock-in period plus renovation. So on the one hand, they are saying I should do the NCLT where I can't go. Testamentary court where they are showing the testamentary court has no jurisdiction over the company, which is also a fact. So where can I come? I cannot be remedialist. I cannot stand and watch my 100% shares, which will come to me, become worth that's the share value. Because in the meantime, the directors will dissipate the assets. Will fit away with 100 crores of rupees. I can't come anywhere. And when paragraph 213, the division bench has observed that that these APLs through their nominees have to act in the interest of the estate. Mr. Thakkar then his next my only cause of action could have been if at a lower rent some other space could have been obtained. Because the directors want additional space.
No, he has submitted with regard to the justification.
Justification. Directors suddenly want 100 square feet space. It was not required under any point of time earlier. The company business has not changed at all. They have not shown that the company business has expanded or any 5 more employees required to be deployed. And if additional space is required, why not have the approach Birla Corporation? Who has given it at 100th of the rate? If they had wanted the additional space, and that's a corporate decision, and I have they approached Birla Corporation has accepted the rate.
It is not the case made out by the Birla Corporation that he is having the excess area, he can provide the area.
Have they approached?
Well, that is their case now. It appears.
Today before this court, what you are making the submission on behalf of the D14, but the D14 has not made a submission. Yes, my area is vacant and they can take my area also.
My submission is apropos Mr. Thakkar's submission that the only cause of action would have been high rent. But they should, my submission apropos that is that the nominees of the APL should have inquired whether there is any available space at a lower rent. They have not shown that the person who has provided adequate space for last how many years, God knows, at 100 the rate, is willing to give at same rate. Why did they have to go to Birla Buildings Limited for 1829 without exhausting their right to go to the landlord? The landlord has to, I could have understood they wanted additional space. At 69,000 per annum, they are giving space, say 1,000 square feet. They want another 1,000 square feet. The Birla Corporation Limited is not willing to give it. So I'm going somewhere else.
Let the D14 tell that he is having the excess area, then I will pass a appropriate order.
Let them say that they need it. They have never asked me. They have never asked me for any additional area. But I will check. I'll come back. I'll give your lordship the answer tomorrow. Not a difficulty.
No, Mr. Mitra has taken the stand now.
Right.
They have not asked for any space from you.
Correct.
So you can give.
Correct.
But you have not made any proposal before this court or sent any proposal to that. Yes, my.
Because the question has never arisen. What is the question? This is an academic question. They've never asked me. If they had asked me, I would have said very well.
Mitra has raised the question. Mitra has raised the question because you have submitted, you have argued the matter, but you have not taken the stand. My area is vacant. They can take very.
I argued in response to Mr. Banerjee.
Okay,
Mr. Banerjee never took the stand that, look, I wanted space, you refused to give it. That's not his case.
No, Mr. Mitra has made out. This case has not been made out by Mr. in the application.
No, this is response to Mr. Thakkar's submission.
The case I had made. I'll tell your lordship, but the submission I had made was this wanting of extra space is a mere excuse because it's not a case which was made. That's the
So may I restate that? So far the additional space is concerned, they should have asked Mr. Bachawa, client, and now since the question is put, Mr. Bachawa has said that he can ask his client and come back tomorrow whether they can give the additional space at the same rate as what was available. And there is no tearing hurry that they have to sign by today. There's no set to sign it by today, and they can't wait for 1 day or affidavits to
25
and well, most important, up to 2025, this at this rate they've given the space. Any additional space, if they require, and Mr. Bachawat has said he can't say from the bar that he had they approached Birla Corporation. This should have been the submission of the defenders that they had gone to Birla Corporation, who's given at 100 the rate. Birla Corporation is not willing, so I am going to the 7th floor 100 times.
Same building.
Same building.
Okay.
Now that takes me to so that's why I can come under section 192 and say you don't dissipate the company's funds. Firstly, I couldn't have gone anywhere. I couldn't have gotten to under section 430. And these were the submissions which they made before the earlier learned judge also during the vacation that you don't have jurisdiction. But 192 specifically, which Mr. Thakkar upon apprehended dissipation of the movable assets.
Not a civil suit.
92 niche likha ache civil suit.
Yes.
Now, Lordship, last submission with Mr. Ratnanko Banerjee's case that Mr. M.K. Sharma should have challenged, or M.K. Sharma. Mr. M.K. or director should have challenged. But the director's lordship has seen 2 out of the 3 APLs are together. The entire board is nominated by the 2 APLs, the entire board replacing whoever they want to replace. So the entire board is the nominee of the APL. And when the division bench had observed that since the tier 1 companies also shareholders of other companies is the secondary and tertiary tiers, the APL through its nominees may also decide how to go about asserting the interests of the estate of PDB. The interest of the estate, they have not given any justification why they have to go to the 7th floor, why they cannot ask the same landlord for additional space as if they require. They can't file affidavits because after all, there is an order that for the time being, do not do it till the 4th. So my humble submission will be that the balance of convenience today, which is the main concern before my lord, and irreparable injury, they will not be prejudiced if the matter is deferred till after affidavits, if the execution of the lease and spending several crores of the estate's money held through the companies is not spent within the next few days, and they file their affidavit in the meantime to justify why they need it. After all, I have challenged all these actions, and I have shown that the board is entirely under control of the 2 APLs who have acted against the company's interest. So, architecture.
Where the property is situated, not the testamentary court. Section ही बोले
So the suit court where, I mean, this is not the test 192 doesn't say testamentary. It says the court where the property is situated. So if the property was situated today in Delhi, 192, where the property is situated. Where the property is situated. So it is not the testamentary court.
The wrongful possession.
Or apprehended. So if it's a movable, how can they be
It is not your case that they have taken away your possession of your right, whatever.
Well, why? Because if the shares represent a right to control the assets of the company. So if the assets of the company has comprises of some sum of money, that can't be given away for the asking. Can't be given away for the asking. That whichever court that can't be given away. So that can't be the assets. The movable assets cannot be dispossessed of. The movable assets.
So you can go. You can make an application before the appropriate court with regard to the giving a right to the administrators.
Well,
administrator can look after this. Whether it is correct or not.
I need the injunction against. Now this is the direction of the board. Direction of the board. If the direction of the board of the company, and so I need an order against the company because this is the company who is taking the property, who is proposing to take the property on lease. It is a company who takes the property. So I have asked for injunction against the company and the company's board, and which the division bench has held at paragraph 108, page 94, that I cannot ask the testamentary court to injunct the companies from taking from doing anything.
Not injunct, that administrator will look into that.
But
administrator will look into that. The court cannot pass any order. Court can appoint an administrator, and the administrator will take the all recourse.
Now, my lord, when there is a board resolution to execute the lease deed, only the court can injunct, because the board resolution, the appeals can't override the board resolution. So then the court can injunct the company from proceeding to execute. And if my lord, and also my lord, if my lord feels that this is a borderline case at the most, if I can go to the testamentary court, give us the chance. We can file within 7 days. Let them not do anything for 7 days. If your lordship, if your lordship says, lordship holds that the testamentary court cannot, if this is the finding of my lord, after accepting their submission, that only testamentary court can pass the orders I have asked for, even though I have asked for injunction against the companies or whatever. Decision where the appeals are only part of the board. Give me the chance to go there. After all, the estate, because after all, this is not something which has to be done today.
Okay, let me see.
Well, this judgment, I don't think Mullah applies at all, Mullah. If he's not a member, he can't have a greater right, Mullah, if he's not a member, to come and then file a civil suit and say you stop proceedings of a company. And Mullah, I never said, I never said that Mullah, either Mr. Sharma or Mullah, the universal legatee has right. I said no one has a right, Mullah, so far as the decisions are concerned.
It is non-judicial, non-justiciable. Nobody has
a right. I cannot file a proceeding against Mullah, the company and say stop.
So appearing for the plaintiff. So appearing for the defendant number 8 and 10. So appearing for the defendant number 14. So appearing for the defendant number 13. So appearing for defendant number 1 and 12, 11 and 12. The matter was moved before the vacation bench on 30th of October 2024, and the Honorable Court and the coordinating bench of this court has passed an order to the effect that for the ends of justice and to avoid further complications, without considering the merits of the case, the execution of the lease agreement pertaining to an additional space measuring 1852 square feet situated at East Block of 7th floor in Birla Building is stayed till 14th November 2024. Though the court has passed an order of stay till 14th of November, pass an interim order till 4th of November 2024, but the matter is not listed, and accordingly, learned counsel for the parties have mentioned the matter before this court, and this court has taken the matter in the supplementary list. Counsel for the contesting parties have argued the matter at length with regard to interim order. full stop. Heard the learned counsel for the respective parties. Fix on today क्या है 5 है ना on 7th November 2024 for orders. In the meantime, the order dated 30th October 2024 is extended. Come on 7th. I will pass till that. No, history we continue.